Arcelia Campbell, Gregory Carroll, Christopher Chase, Ronald Collins, Anthony De La Hoz, Dallas Dodd, Horace Durden, Delroy Derm, and Jacob Grice.
State has no objection to continuing these matters?
No, Your Honor, no objection.
And do any of you folks who are standing, whose names have been announced, have any objection to a continuance? Seeing none, case will be continued until April 24,
Thank you.
9 o'clock.
Your Honor, I have some out of custody as well that we're going to continue.
Hang on just a moment while we order in the court, please. Again, if your name is called, please stand and remain standing.
Charles Owens. Mr. Patterson, we continued this morning. Dustin Reeves. Devin Robbins. Joya Sledge. David Stanley. Zeb Tidwell. Wendy Ulrich.
Is that spelled?
Ulrich. David Warren. Angela Worley.
How's her name spelled?
Wehrly.
Joshua Willis. Those are all of my out of custody, Your Honor.
All right. So, folks, I'm going to have counsel repeat that, and let me know if you have any objection to continuing your case. Having people still coming into the courtroom.
Okay, Your Honor. Charles Owens. Dustin Reeves. Devin Robbins.
Actually, council, we'll take care of that at the end if they're still here and they haven't heard. So if your name has been previously called, you're excused until April 24.
Your Honor, if I may call one other gentleman to continue to Monday, Mr. Jeffrey Brown. Your Honor, we'd just like to see, leave him set for docket day on Monday, the 6th.
In agreement?
Yes, Your Honor.
This way.
Mr. Brown, you'll be back Monday at 9 a.m.
Jeffrey. Thank you. Yeah, 22 CF 1911. Thank you, Judge.
Other council have a list?
I do, Judge.
Name is called, please stand and remain standing.
Amanda Harville, 22 CF, I'm sorry, Jay Williams for the record. Amanda Harville, 22 CF 2440. Ms. Harville is currently in the Santa Rosa County Jail.
April 24.
Thank you, Judge. Doremus Holden, 23 CF 18.
Oh, they're in custody. We were just doing,
Just stand there.
it's faster this way, yeah, thank you.
Gary Hudson, 22 CF 51. Damon Hutchinson, 22 CF 2758. Jeremy Jernigan, 23 CF 28. Casey Johnson, this can't be right. I've got her case number wrong. I have to.
Case number is 221485.
I've got it. Judge, I'll take your word for it. We've got depots set
Casey,
on.
is that right? Casey and not Stacy?
Casey, that's correct, with a K. 221485, that's correct.
Casey Johnson.
Yeah, I've got the case number wrong.
No, move along.
Mr. Williams,
Yes.
can you just tell me, Casey Johnson, what's the reason for continuing?
Because the depots are set for March 28th.
Okay, just because I see it's from June of last year. Okay, that's fine.
Yes, ma'am, we scheduled the depots in it.
That's
Move
fine.
along, please.
Somebody else had an issue.
No need to have a full discussion here.
All right, Judge. Stacy Marie Johnson, 22 CF 3001. Kelly Victoria, 2385. Nicole Miles, 21 CF 3202. Christopher Matthew, 22 CF 1948. David Nelson, 22 CF 1795. Dana Lewis, 22 CF 2052. Eddie McBride, and he has two case numbers, 2272 and 22792. Devin Miller, 221953. Sheila Jones, 22 CF 2467.
That was Jones.
That's correct, Judge. Sheila. Robert Lamb, 22 CF 1483. Lorenzo Murphy, 22 CF 2877. And I'll add one to the original typed list, Aldrion Harris, and I'm probably mispronouncing that first name. It's Aldreoun. It's 22 CF 2314. I need to get him to sit down with me and watch the video.
Do you have any objection to those folks?
To Harris, no, Your Honor.
There is one Eddie McBride that's needing the status on that. So can we put that on docket today?
Can we maybe excuse his appearance? Okay. Judge, we can set McBride for docket day and on status. I'll just tell you, I've not been able to find an email on it, so it may be on me.
McBride will be March 6th at 9 o'clock. Otherwise, everyone else whose name is called, April 24. Stay in touch with your attorney, please.
Your Honor, I'm sorry. I'd hate to interrupt.
Hold on a moment, please, folks.
Your Honor, Mr. David Nelson's case, there was a no bond capias last time for a failure to appear on 22/17/95. We just asked that be set for docket day at this time instead of just continue today.
The no bond capias, Judge, was because we announced a continuance list before when Judge Nickinson had the bench. I gave a list of people. They were mistakenly, I had announced for a continuance for today's date. They were instead mistakenly put on for the 3rd. I was out on the 3rd because I had COVID and Mr. Russell covered for me. These individuals, there was, I'm going to say, 7 or so that had warrants issued for them. I brought a motion to rescind the warrants, provided a copy of the, had my secretary pull the court smart from that date and confirm that they were on the list that was called up and left the courtroom early. That was through no fault of his, and it was.
Capias been served?
Judge, I've been in contact with him.
Capias been served to your knowledge?
The capias was served. I had to go to first appearances. It was served before we could get the then, bear in mind, we've got different judges, to sign off on the order rescinding it. The same day that I appeared with him in first appearances, the judge signed the order rescinding the capias, but it was too late. It had already been served on him.
Judge, we'd still ask this be set for docket day. There is a probationary offer that is going to expire that day. So I'd like to give Mr. Nelson the chance to accept that or decline it.
Mr. Nelson still here?
I'm sorry.
Can you be back Monday morning, sir? All right, meet with Mr. Williams in the meantime.
Thank you, Your Honor.
Everyone else, April 24, 9 o'clock. All right, we have another list from any counsel.
I get it recalled.
Your Honor, I have one that I could call.
I'm sorry, Judge. I've got people asking me other questions. You want to go ahead and call him up now?
Damian Mitchell.
Damon Mitchell.
Damon Mitchell is present. Is there anybody still out in the hallway? All right, I'm seeing no hands, sir. All right, so what do you want to do with Mr. Mitchell?
Well, Judge, I was asked by security to bring Mr. Mitchell up.
Are you Mr. Mitchell? Damon Mitchell here? Are you Mr. Mitchell?
Damon Mitchell, if you're here, you need to come forward and come stand right next to me.
Not present. We'll move on.
Two to continue.
Okay, I've got 4 to call real quick that are out because they're sick. Judge, I've been contacted
Just make your argument, hit the case, please.
this morning by a total of 4 individuals, 2 of which were here, 3 of which were here and had symptoms and were sent home by security, and the other one was having a medication issue and was released. But William McMurrin, 22 CF 3098.
Category to default.
The first judge. He was here. I spoke with him. I told him to go downstairs, talk to security, and see if they'd let him in the building. He was previously not allowed entry because he had COVID.
So when do you want him back?
Judge, given that
Is he
he's
ready
still
Monday or not?
symptomatic, let's go ahead and set him off till the April
Do
date.
you have any objection?
No objection, Your Honor.
April 24.
Next one is going to be Danny Mason, 2020 CF 733 and 165. Mr. Mason did not speak with me directly. Court security told me that he was downstairs and they had him sitting outside because he was symptomatic.
April 24 is your request?
Yes, sir.
Any objection?
No objection.
Granted.
Thank you, Judge. Shirley Jones was present earlier. Excuse me. Ms. Jones was apparently having some medication issues, and so court security asked me if she could be excused, and I'll just go ahead and move to pass her until the 24th as well.
She was having a minor issue. You think you could get her back Monday?
I can try, Judge. Let me look real quick, and I'll be able to tell you if I have a number on her. I do not, Judge.
State's preference? Hearing nothing, April
She's not here.
24.
I'm sorry, Judge.
April 24.
Thank you, Judge. The next one is Jacqueline Lige, Lige, 2022, CF 2598. Ms. Lige, has got some, really sort of a white-collar case. It's a little bit complicated. I was going to ask for a continuance on that one anyway, but what I've been advised is that she was ill and was unable to attend court. She called our office, apparently.
Do you have any objection?
I do, Your Honor. I would ask for a capias. Was she advised to provide any type of proof to the court, or does she provide you any type of proof?
I got a text message about it after court had started. So I haven't had a chance to ask her to provide anything. Normally, I think the legal assistant does, but I obviously haven't seen.
How about docket day for a control date?
Okay.
For March 6, 9 o'clock.
And Judge, that's what I have. I did not include any of the folks in jail.
Next.
Your Honor, I have two others that have back into the courtroom. That's Ralph Thompson. Mr. Thompson, would you stand? There he is. And Ebony Williams. We are requesting continuances on both of those cases.
Okay, state have any objection?
Judge, I would object to Ebony Williams being continued.
All right. And
Ms. Williams, you'll have to stay. She objects to continue.
No, that is not my list.
what did you intend to do, counsel?
Your Honor,
Why did you need the continuance?
Your Honor, she requested another continuance.
You did?
Yes.
Are you ready?
We can be.
These cases are a year and a half old, and, you know, we just need to get them resolved. So March 6th for pretrial, for the, what do you call that, docket day? What's the language for that? Thank you.
Judge, I have one person that I can go ahead and resolve this morning or this afternoon, if I may call her. It's going to be Jackie Passmore. Judge, 22 CF 294, Tim Gibbs on behalf of Ms. Passmore. Judge, we have reached an agreement with the state in this case. If I can approach with a written plan and score sheet.
to make sure I understand, it's only as to count 1 and count 2 will be dropped, is that correct?
I'm sorry, count 2 would be time served, Judge. I must not have put that in there.
Want to add that on so she can initial it? and
Yes,
make sure she
thank you.
understands.
Just initial right there. I can. I just need some signatures mostly. So, but I can go, I didn't do my out of custody. All right.
Oh, yeah, all right.
Ma'am, if you'll raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, please.
Jackie Ellen Passmore?
And Ms. Passmore, I understand you're pleading no contest to possession of controlled substance and possession of paraphernalia. Is that your understanding?
Yes.
Have you written plea agreement here? And is this your signature on it? Did you read all this document before you signed it? Do you have any questions about anything in it?
No, sir.
You understand everything in it? You understand you're giving up your right to a jury trial, all the listed trial rights, and the right to appeal guilt? But keep the right to appeal fundamental issues or issues on sentencing errors. Had enough time to talk to your attorney?
Yes, sir.
Satisfied with the advice? Anyone promise you anything other than what is in this agreement to get you to
No,
plead?
sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Any medicine, drugs, or alcohol in the last 24 hours?
Sir.
Ever been committed to a mental health facility?
No, sir.
And the score sheet right now apparently scores 43.2 total sentence points. So that means if you mess up on the probation you're being offered and you come back to court, you'll be facing a recommended minimum prison sentence. You understand that? Very important that you follow through and do what you're supposed to do here. Tell me about having meth and paraphernalia.
I'm sorry?
Tell me about having the drugs and the paraphernalia. How'd you get
was-
stopped?
How it stopped?
How did the police find it?
I'm sorry?
How did the police find it?
We were, me and 2 other people were at the store, and I was shopping, and I don't know what happened outside, but when they came inside, they asked who I was, and they asked to search me, and I told them yes. I was 3 months pregnant at the time, so
What did you have with you?
I had meth.
And some paraphernalia?
Yes, sir.
What kind? A pipe?
Pipe, yes, sir.
You know how toxic that garbage is.
I'm very glad I got arrested. I had a problem. I'm at rehab right now, almost done with it. I'm becoming manager at my job. I have a healthy baby boy, and I will never regret going to jail that day. I'm glad I did.
Good for you. And I want to
Thank you.
suggest this to you and others who are struggling with drugs. You can get into committed recovery for the rest of your life. It doesn't mean you won't be faced with challenges. How long had you been using?
For about 2 years.
You had enough use where something triggers an urge in years to come. If you're not in committed recovery, chances are you could relapse.
I'm in Keaton right now, so Keaton's a very wonderful
Very good
program.
nurturing program, but when you get out of there, and the whole point of that program is to get you out into the real world where you can handle any kind of stressor.
and I'm ready for that.
The proof will be in the pudding, so to speak. You understand what I'm saying? And I hope you do succeed, and you can do it.
I know.
And so at this time, I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Any objection to the score sheet with 43.2 total sentence points?
No objection.
All right, at this time, ma'am, what was the decision here on adjudication?
Your Honor, if she doesn't have any other felony prior, I would be okay with the withhold.
I believe she does, though.
There was a prior.
Yeah, there are.
And
She's
matter
on
of fact, I
probation.
think it's
But this is a misdemeanor, right?
So this is possession, this is meth.
I think it's a kind of prior where an
The
adjudication
other thing,
is
Your Honor, if I
required.
may, I know that it may suspend their license
It will for 6 months.
if it's a adjudication.
Well, I believe it's legally mandated in this case, an adjudication with a prior record, as I read this.
I believe that is correct, Judge, because she does have a.
I'll leave it up to the court.
she's
Thank you,
on-
Your Honor.
All right, so, Under the circumstances, considering your prior record, ma'am, I believe I must adjudicate you guilty on these offenses. You'll be placed on 2 years community control, followed by 2 years probation on count 1, time served on count 2. This sentence, or these sentences, will be concurrent with a case out of Santa Rosa County, case 2016 CF 647. You're currently in Keaton on that program, as I understand it. And you'll be required to pay your standard court costs, which I believe will be $515 plus $100, and then your attorney's fees on this matter with $50 application fee and a $100 attorney fee. Do you have any objection to the reasonable nature of the attorney fee?
No.
All right. I will find that you've waived your right to a reasonable attorney fee hearing. And, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Good luck, ma'am.
They need a fingerprint sheet, and then you might want to need a
Your Honor,
fingerprint sheet.
since Mr. Gibb was appointed, we request a supervision.
Granted.
Thank you.
Case counsel, who's ready?
Ms. Rivers,
Your Honor, I am ready.
I just need to get a couple signatures.
Out of custody, in custody, or does it matter? Huh?
We can do the folks who've been sitting here all day. Let's try to.
Yes,
get
sir.
you.
Yes, sir. All right, Your Honor, the next person I have is Stephen Renfro. Your Honor, he must be outside. I talked to him just a few minutes ago. We'll skip him. Tabitha Rentz. Our Ms. Rentz is present, and we do have an executed plea agreement.
Bring it up, please. You may. You were invited. We only have one case, well, there are 2 cases on the.
Yes, Your Honor, there's a violation of probation and a new law.
All right, ma'am, if you'll raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please speak up loud and clear. State your name.
Tabitha Rentz.
And Ms. Rentz is, I don't see her signature here on the plea agreement.
She did sign it, Your Honor.
You didn't sign it in the right place.
She didn't sign it in the right place. There it is, right here. Yes, Your Honor, she signed it right there.
The addendum doesn't apply.
No, Your Honor.
Okay, my apologies. So, ma'am, is this your signature on the
Yes,
plea
sir.
agreement? And did you read all of it before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
Do you understand by entering your plea, you're giving up your right to a jury trial?
Yes, sir.
You heard me explain about all the trial rights?
Yes, sir.
And the right to appeal, that you're giving all that up, but you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Satisfied with the advice given? Anyone promise you anything to get you to plead
No, sir.
besides what's in this agreement?
Yes, sir.
Check out the
Anything
soaps,
other than
bath
what's in the
bombs, and
agreement?
other bath and body
Have
products.
you been threatened or
all
made to
made by
plead when
hand
you
with
don't
no-
want to?
No, sir.
And have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Have you ever been committed to a mental health facility? And apparently it's just a new arrest as the basis for the violation.
Yes, Your Honor.
All right, so what happened regarding the fleeing and eluding with lights and sirens activated?
Oh, I couldn't stop in the car. That brakes weren't working. And that's about what happened. I went past the stop sign.
Well, under the circumstances, ma'am, if there was a mechanical issue that prevented you, you couldn't put it in neutral and just put on the brakes?
It was very, the brakes were not working, like, it was not working.
Put it in neutral and let it just slow down?
That's what I was trying to do. I mean, it was like downhill, like going downhill.
How far did you go downhill? I mean,
I'm
most
not-
hills end.
I'm not sure exactly. I had to run off into a yard to stop it.
The point is, you may have a defense here that you're giving up by entering your plea if this was a legitimate mechanical issue and not an intentional act. You
Mm-hmm. Yes, sir.
understand that?
Yes, sir.
And I believe, does this charge, fleeing and looting, have extra costs? Right,
548.
there are extra costs. So
It's
the
548.
point is, do you understand you're waiving or giving up those issues?
Yes, sir.
You think that's best?
Yes, sir.
And this time I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Any possible defense is voluntarily waived. Have a score sheet with 35.4 total sentence points. Any objection?
No, Your Honor.
And ma'am, at this time, I find you guilty of violating your probation. Your probation will be reinstated. You'll be required to pay an additional amount of court costs and a $150 public defender fee. Or you listen to me, ma'am.
There, I'm sorry.
You have the right to a hearing regarding reasonable attorney fees. Do you have any objection to the public defender fees of $100 per
No,
case?
sir. No, sir.
And Your Honor, probation has indicated that her probation has terminated. She had nothing left to do. I did explain that to the state. So at this point, we would ask that no further action be taken other than that she be administered the court costs.
That's correct, Your Honor.
Well, that's not what it said there. If there's nothing left to reinstate, then that's a moot point. At any rate, in addition, with regard to the offense, there'll be 400, it was 500, and what did you say? 548 total costs, including costs of prosecution and other additional costs relating to this specific charge by statute, and another $100 attorney fee for this case. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you.
That's it.
Excuse me.
Angela Rushing. Your Honor, we've reached a plea agreement in this matter, if I may approach.
Okay. Ma'am, if you'll raise your right hand to be sworn, do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please speak up loud and clear. State your name.
Angela Rushing.
And Ms. Rushing, I understand that you're pleading no contest to a charge of fraudulent use of a credit card, 6 months or over $100. And is this your signature on your plea agreement?
Yes, sir.
Did you read all the document before you signed it?
Yes, sir.
Any questions about anything in it?
No, sir.
Understand everything in it?
Yes, sir.
Understand you're giving up your right to a jury trial, all trial rights, and the right to appeal guilt,
Yes, sir.
but you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Satisfied with the advice given?
Yes, sir.
Anyone promise you anything other than what is in your agreement to get you to plead?
No, sir.
Have you been threatened, forced, or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
And tell me about using a credit card fraudulently.
I had the company card and I misused it.
For personal use, not for business?
Both.
Well, the real issue is the
Yes, sir.
personal use. You did do some personal stuff with it.
Yes, sir.
Did you have permission to do so from
No,
the
sir.
company?
No, sir.
All right. Why would you do that? Think about it.
I know.
Well, you had a good job. I presume you lost your job?
Yes, sir.
It's a heck of a price to pay for a little convenience.
Yes, sir.
All right. I find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. And used it more than once during the 6-month period, or was it over $100 that you used it for?
Yes, sir.
Both, one or both?
I'm sorry.
The 6-month issue of using it multiple times or over $100?
Over
Or both?
$100.
Okay. And this time then, score sheet has 10.4 total sentence points. Any objection?
No, Your Honor.
And ma'am, at this time, or will withhold adjudication of guilt, you'll be placed on 3 years probation. You'll be required to pay $415 in court costs, $100 cost of prosecution. You're entitled to a hearing regarding reasonable attorney fees, and there's a $50 application fee, the $100 fee. Do you need a hearing about whether those fees are reasonable?
They are. Are you?
Okay,
Yes,
you do not
sorry.
need a hearing about whether they're reasonable. You agree they're okay.
Yes, sir.
All right, I'll find you've waived your right to a fee hearing. $50 application fee and a $100 fee plus restitution, the amount of $2,479.36, payable to Progressive Chiropractic and do 150 hours of community service work. Is there any reason you can't do that at a minimum rate of, say, 5 hours per month?
I'm able to do that, yes, sir.
All right, starting March 1, 5 hours per month minimum. You can do more if you like, just
Okay.
not less.
Yes, sir.
You also have to file a motion for early termination, and the state agrees you can do that upon completion of all your tasks, so long as you have no violations.
Yes, sir.
So the quicker the better.
Yes, sir.
You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Yes, sir. Thank you. We're good.
Thank you.
Charles Singletary.
And Your Honor, since Mr. Rivers was appointed, we request the supervision waive.
Granted.
Your Honor, Mr. Singletary is approaching on 22 CF 2418. Your Honor, we would like to reset this to March 2nd. He would like to accept the state's jail offer and turn himself in on that date. Yes.
No objection.
You can enter the plea and be sentenced at the same time.
Yes, Your
So
Honor.
don't fail to appear. What time is that now on March 2nd? 2 o'clock, was it?
It's
9 a.m., excuse me, 9 a.m., March 2. So that'll be Thursday of this week. Thank you, sir.
All right, you're good. Your Honor, the next one is Allison Snipes. Your Honor, as she's approaching, she's before the court on 22 CF 3067. This is another case we're going to set for March 2nd.
No objection.
All right, do you agree with that? March 2, 9 o'clock. Thank you.
9 o'clock.
Thank you.
David Stanley, I believe I've already called him.
You have.
Yeah, okay, thank you. Chance Stapleton.
It's coming up.
Your Honor, he's before the court on 21 CF 3291. We have a hearing set for March 9th. We would like to leave it on the trial docket.
And Your Honor, the state may not be able to do March 9th. I'm going to be in trial at the south end, but we can go ahead and leave it set. We'll let Ms. Rivers know.
All right, stay in touch with your attorney, sir. Hopefully it can get moving forward. March 9, what time is that hearing?
9 o'clock, Your Honor.
9 o'clock.
Your Honor, the next one that I have is Katrina Turner Hasselbrink.
Last name again?
Turner Hasselbrink.
Got it.
She's before the court on 22 CF 2767. The state did extend a PTI on this case. She did sign it. However, her husband has voiced a lot of disagreement. I don't know at this point what we're going to do.
Just asking to lower the,
Couldn't hear you.
just asking to lower the amount that,
No, sir, I'm not involved in that, ma'am. That's up to the state, and some of it may be some required expenditures. I don't know.
So, Your Honor, I guess we'll ask to continue it to
oh, no,
4/24.
that's okay.
That's without objection, Your Honor, and we can, I've already told you I'll waive what I can, but the offer remains open.
Thank you for waiving it.
Oh, what's the next court date?
4/24.
April 24th. Stay in touch with your attorney, please.
Yes, sir, thank you.
Your Honor, the next one on the docket is Charles Velez, 21 CF 2690. Charles Velez. Your Honor, I am new to Mr. Velez's case. I have not met with him yet. I am giving him my card at this time. And
Must be continuous.
I think the state wanted to set it for trial.
How long have you been on the case?
I started working here the last week of December.
How long have you been on this case, though?
That's when technically I would have been assigned the case.
So about a little over 2 months.
Judge, I'll agree to a continuance to let Ms. Rivers familiarize herself with the case.
Ms. Velez, do you have any problem with your attorney trying to get up to speed on your case?
No, but this is the 5th time I've gotten a new public defender.
No,
I've been
sorry, I don't
submitting
have any
witness
control
statements
over
and
that.
witness evidence and camera footage on my end, and I don't get called back or any kind of mail, correspondence, nothing.
And that's not correct, Your Honor. He did leave a message saying that he had submitted some footage. We did not receive the footage. I did indicate that. I believe my assistant did call him back and tell him about setting an appointment with me, and we never received a call back.
Or if you could make an appointment and get in
The
face-to-face works a little
assistant
bit
that I
better.
spoke to called me back and said she did receive the footage and that I got a new attorney because my old attorney was Mr. Gibbs, and I didn't even know anything about it. And she even apologized 2 or 3 times saying, "We're so sorry you didn't find out, or we didn't tell you that you had a new attorney." Her name is Abigail Clark.
The point is, sir, this is your attorney now. I'd encourage you to work with her so she
I
can get
do
up
as
to
much as
speed
I
to
can,
help
sir.
you on your case. It's been around
Almost 2
a year and
years.
a half,
Yeah,
so that's a long time.
I'm
And,
ready for whatever they're ready for.
well, hopefully you can get it closed, but you need to
Yes,
have
sir.
effective representation to help you.
Sir,
Okay, so please try to schedule an appointment with her, because face-to-face meetings are usually a lot
I'll
more
call her
productive.
as soon as I get home
Thank
and
you,
leave
sir.
a message with her legal assistant.
Sarah.
Sarah? Yes, ma'am. Thank you, Your Honor.
Thank you. So April 24 is your next day.
Your Honor, Lisa Walker is the next one on the docket. Your Honor, the information I received, and we did receive a phone call from her this morning, is that she is still in hospice. There is previously a waiver on file. We would just ask to continue her case to 4/24.
No objection.
Counsel, you might want to verify and be able to, notify counsel. We don't want to be harsh about things, but
Judge, I had previously seen documentation of the hospice care that was months ago, but I'm
Stepped in.
assuming nothing's changed.
well, usually it only goes one way, but
Yes.
not always, surprisingly. So
Your
I
Honor,
would
the,
like to verify that.
Your Honor, the next one is Zachary Ward, 22 CF 2858. Don't think I have a score sheet, though.
It's a very new case in all things considered, but if you're ready to resolve it, good.
Do we have an agreement in this matter, Your Honor? Thank you.
Did I sign it?
Okay, counsel, is this a plea to all 3 of the counts?
Yes, Your Honor.
Sir, if you'll raise your right hand to be sworn. You swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God? Yes, sir. All right. And state your name, sir.
Zachary Ward.
So there's an offer of a year probation on felony,
Yes, Your Honor.
is that correct?
Yes, Your Honor.
So, sir, I have the written plea agreement. And is this your signature on that plea agreement? Yes, sir. Did you read all this document before you signed it? Yes, sir. Any questions about anything in it? No. Do you understand everything in it? Do you understand that by entering your plea, you're giving up your right to a jury trial, all jury trial rights, and the right to appeal guilt? Yes. But keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney? Satisfied with the advice? Any promises other than what is in this agreement? Have you had any other promises besides what's in this
Oh, no,
agreement?
sir.
Have you been threatened or made to plead when you don't want to? Had any medicine, drugs, or alcohol in the last 24 hours? Ever committed to a mental health facility? Tell me about what happened here with having some drugs, including some legend drugs without a prescription and drug paraphernalia.
Pulled up to a friend's house. The FWC officers were there investigating night hunting. Nobody was home, so I was the first person they talked to. And I guess he saw something in my truck and wanted to look. So
You give him permission?
kind of not really. He has to look at an arrow of mine. I had broadheads that had rubber bands on them, and one of the rubber bands was busted, and he thought I might have shot a deer with it or something. But digging through the truck after he asked to look at the arrow, found what they found. So.
Well, did you think he was going to do anything other than look at the arrow? Okay. Well, you might have a legal issue there about how far he went with his investigation of something. And what did he find?
Pipe, a pill, and a little bit.
Laying out where he could see him once he picked up the arrow? So were they under something or in something?
I believe he found the pipe in between the seats, and I think he said he found the pill in the center console, and the other stuff was in a cigarette pack.
All right. And were they yours for illegal use? Didn't have.
I don't know about the pill. I didn't know about the pill.
Whose car was it? How would the pill get in there?
I give people rides all the time. I just given a couple people a ride to the scrapyard earlier that day.
Was the pill the illegal felony substance? And do you understand that you might have a defense if you didn't know it was there, never exercised any control over it? You could present that and let a jury decide whether you were committing a crime or not. You understand that? But you're giving up that right by accepting this deal. You understand that? And what was this legend drug?
Was methadone hydrochloride.
Were you taking methadone? No. Was it somebody else?
Yeah.
So same thing.
My truck, my stuff.
Pardon?
My truck, my stuff is what I was.
Well,
what I've understood.
that's certainly a point in the discussion, but there's a more fine point about whether you knew the stuff was there, whether you exercised any control over it. And so that's the relevant question for this discussion. You understand that? And you're giving up the right to raise those issues by taking this deal. That's what you want to do. Find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. Any possible defense is voluntarily waived. And I have a score sheet with 16.6 total sentence points. Any objection?
No, Your Honor.
All right, sir, at this time, before we withhold adjudication on these matters, you'll be required to submit to a substance abuse evaluation as a part of 12 months probation. You'll do that substance abuse evaluation within 30 days and enroll in any counseling within 30 days and successfully complete that. You'll not possess or consume any controlled substances without a prescription. And is there an extra fee for paraphernalia? Okay, so there's, I think that's in addition to the other court costs here, the paraphernalia charge.
We haven't ever done it before.
Okay, well, we've got the $515 plus the normal cost of prosecution, which is $100. And sir, you're entitled to a hearing regarding reasonable attorney fees, which would be a $50 application fee and a $100 fee. Is that reasonable to you? You're giving up your right to any hearing? And you're waiving any costs of supervision. You can apply for early termination if you have no violations.
He just
and file a motion with the court. Sure, you advise of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. And that's 12 months probation on each count concurrent. Or, excuse me, count 2 is a second-degree misdemeanor, so that's a year on count 1, 6 months on count 2, and a year on count 3. Thank you, sir.
Your Honor, the next case is Elijah Westbrooks. Your Honor, he is in the Walton County Jail. His case numbers are 22 CF 2738 and 22 CF 2012. We're requesting a continuance to 4/24.
Granted.
And I believe we did Jeffrey Willis. So that leaves, I'm sorry, no, that was Joshua Willis. That is the last person that I have on my sheet as out of custody. So unless you're ready with inmates, you ready with inmates?
Some more people who are at liberty here.
Charles Russell, Public Defender's Office. First out of custody judge is Larry Miller. Mr. Miller is present and approaching. Case number is 20 CF 2060. Judge, on Mr. Miller's case, I was going to announce ready for trial. I was informed by my client this morning of a new witness. We can either go ahead and set it on the trial docket, and between now and Monday, I will talk to him. If I'm going to list him, I will. Or we can continue it. I'll let the state decide what they want to do.
Your Honor, with the new witness, it really doesn't give us enough wiggle room with what's coming up the next couple of weeks. We're not going to object to this continuance. Just ask that Mr. Wilson provide the information just as soon as he has it.
Yes, ma'am.
All right, so April 24, stay in touch with the attorney, sir. This one's been around a really long time.
Yes, sir. I inherited the case, and anyway, it's been a while.
There's a lot of inheritance going on.
Lot, Judge. Laura Rooks. Ms. Rooks is present and approaching. Judge, I have a proposed agreement and a score sheet for Ms. Rooks, if I may approach.
Counsel, I'm trying to figure out is there a period of supervision here?
There is, Judge. Originally,
It's all, oh, I see what you're doing.
right, originally it was community control followed by probation. Now it's just straight probation.
All right, ma'am, if you'll raise your right hand to be sworn, do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please speak up loud and clear. State your name.
Laura Brooks.
And Ms. Rooks, I understand you're pleading no contest to pawnbroker transaction fraud in count 1, a lesser included offense of grand theft over $20,000 but less than $100,000 in count 2, and Indian stolen property, those 2 counts, and then the state will be dropping count 3. Is that what you intend to do here?
Yes.
I have your written plea agreement here, and is this your signature on that agreement?
Yes.
Did you read all this document before you signed it?
Yes.
Do you have any questions about anything in it?
No.
You understand everything in it?
Yes.
Understand you're giving up your right to a jury trial, all your trial rights, and the right to appeal guilt.
I do.
Keep the right to appeal fundamental issues or issues on sentencing errors. Had enough time to talk to your attorney about your decision?
I have.
Satisfied with the advice given?
I am.
Anyone promise you anything except what's in this agreement?
No.
As modified here? And have you been
perfect.
threatened or made to plead when you don't want to?
No.
Had any medicine, drugs, or alcohol in the last 24 hours?
No.
Ever been committed to a mental health facility?
No.
Tell me what happened.
I mean, I worked for these people. I worked for them for a long time, actually, and
An opportunity to take something and decided to do it?
I wouldn't necessarily put it like that, but some jewelry definitely came up missing.
Did you take
And
it?
I mean, the guy I was dating that I brought over there definitely did.
Were you involved in that in any way?
I mean, I brought him to the house with me.
Different question.
I feel like
Did you
it's.
know he was going to take it?
No,
Did you encourage him to do it?
no.
Did you help him do it?
I mean, I let him in the house, but I didn't
Other than
know.
letting him
like-
in the house, did you have any idea he was going to take the jewelry?
No,
You may have a complete defense in this case.
I'm good with this.
That's okay.
Thank you.
You get to make that decision.
Yes.
Only you can make it. Do you think the jewelry was worth at least $20,000?
I honestly, I have no idea, sir.
To the extent that it was not, you're actually charged with it being, over 100,000, but if it was not worth 20,000, then you could, while you might be guilty of a crime, it could be an even lower crime than what you're pleading to. Do you understand that?
I
Let's say it
understand.
was worth only 10,000. You understand that?
I understand.
So the point is, you're giving up even partial defenses, let alone a complete defense, to these charges.
I understand.
Complete defense would be the fact that you had no involvement in this case other than letting somebody in your house. You understand that?
I do.
And this is the way you want to handle it.
Yes.
Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Any possible defenses are voluntarily waived. I have a score sheet with 42.9 total sentence points. Any objection?
No objection, Your Honor.
Ma'am, are you aware that if you mess up this supervision that's being offered, you'll be in a presumptive state prison range?
Yes.
So do what you're supposed to do.
Yes, sir.
This time I'll adjudicate you guilty on both counts. You'll be placed on 60 months probation, concurrent on each count, and also concur with the probation that you're presently serving. Costs of supervision are waived. You'll pay restitution in the amount of $99,000 to Jennifer Macy, restitution of $5,000 to Theodore Macy, restitution of $3,419.30 to Latitude Subrogation Services. All that restitution is owed jointly and severally with Roy Cato, who was involved in case 21 CF 1233. You pay required court costs, and you can perform community service for any eligible court costs. You'll pay $100 cost of prosecution. I presume it's $515 in standard alternative court costs. It's not listed here, but that's usual. 515, all right. And under the circumstances, you have the right to a hearing regarding reasonable attorney fees. There's a $50 application fee, and a possible $100 fee for the attorney's office. It goes to the state, not to the attorney. Is that acceptable to you, ma'am?
Yes.
A hearing about whether that $100 and $150 is reasonable?
Yeah.
You need a hearing about that, or is it reasonable?
No, this is good.
Okay. So I'll find you've waived your right to an attorney fee hearing. You'll not possess or consume any alcohol or controlled substances without a prescription and subject to random urinalysis. You have no contact with the Macy's. You'll stay away from 1212 Twin Bay Drive in Fort Walton Beach. Your supervision will not be violated for failure to pay restitution in full as long as you're making good faith efforts to pay during your supervision. And Counselor, and how does the state want to proceed on count 3?
State would enter a null pros, Your Honor.
All right. Counsel, is there anything I may have overlooked?
No, Your Honor.
Ma'am, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you.
Then my last out of custody judge is Robert Strauss. Mr. Strauss is present and approaching. Case number is 21 CF 247. Mr. Strauss's case, Judge. Mr. Strauss was in the hospital last week, but he did get a message to me regarding some witnesses. My intention was to announce ready for trial. Again, it's the same position as Mr. Miller's case. I can either leave it on the docket and I can try to talk to those witnesses between now and then and list them, or I can continue it. I'll leave it to the state.
The witnesses, sir, on which case?
On your case, 21 CF 247, the child porn case.
This case is from 2021.
We can leave it on the trial docket, and
Sure,
I'm going
let's
to use
do
the
that.
witness. Okay.
Give it your best effort, counsel. So
Yes,
you're
sir.
having the docket day on the 6th, is that correct?
Yes, sir.
All right.
That'll be
Stay
fine.
in touch with the attorney, sir.
Yes, next Monday. That's all my out of custody, Judge.
Thank you. Anyone else, counsel?
Got inmates, but that's all my out of
I'm
custody.
talking about people out of custody.
Can we just pass him present?
I do have some out of custodies, Your Honor. Ready?
There's a defendant in the audience that does not have an attorney at this point. Do you have Mr. Moore? Right. May we call the case, Your Honor?
Yes.
This is 22 CF 2628. Defendant.
His name, please.
Tamika Tarsan.
And
Tamika Tarsan.
Last name?
Tarsan.
How do you spell that?
Tassin.
Your Honor, she was previously represented by private attorney Bert Moore. He has recently received a 1-year bar suspension, and it is now effective. So at this point, we would either need to appoint the public defender, or Ms. Tassin could hire her another counsel.
Ms.
if
Tassin,
she
you have the
chooses.
right to an attorney. If you cannot afford one, one will be appointed for you. Are you able to hire counsel?
I just
You've already
rather-
hired one.
Yes, I'd just rather just do a public defender, not from this
Well,
point.
the issue is if you qualify, so I can take testimony from you about that. You wish to have a public defender?
Yes, sir.
Raise your right hand to be sworn. You swear affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again.
Tamika Hassan.
And ma'am, are you employed?
Yes, sir.
And what's your take-home each pay period?
Take home 11
How often?
every 2 weeks.
That's 1,100?
Yes, sir.
How many dependents in your household? Yourself and who else?
And my 4 kids.
You have 4 children? Is there another income earner in the household?
No, no, Your Honor.
I believe, counsel, is what's your understanding of qualification?
I believe that's within the guidelines, Judge.
All right.
We'd still ask that she fill out an application.
And of course, you have the right to move to withdraw if she doesn't qualify, but under the circumstance, oh, there it is. I knew there was one up here.
Your Honor, since we've just been appointed to this case, we'd ask for a continuance to next cycle so we can get familiar with the case and meet with Ms. Tassin.
Certainly.
No objections.
And there is appointed, she does qualify. And we'll set it for April 24, meet with, are you going to be counsel?
I believe Ms. Rivers will be based on the alphabet.
And then the lady sitting behind you will likely be your attorney. Make him keep an appointment. Thank you. All right, counsel, call the case, please.
Yes, Your Honor, I have a few out of custody that we can resolve as well. First, Judge, I have Mr. Eric Allen. Your Honor, on Mr. Allen's case, we have reached an agreement with the state if I can approach with a written plea.
You may. All right, sir, if you raise your right hand to be sworn, you swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
State your name, sir.
Eric Allen.
And you're pleading no contest to a lesser included offense with no valid driver's license?
Correct.
You have a written plea agreement here. Is this your signature on that plea agreement?
Yes, Your Honor.
Did you read all of it before you signed it?
Yes, Your Honor.
Any questions?
No, Your Honor.
Understand it?
Yes.
Understand you're giving up the right to jury trial, all trial rights, the right to appeal guilt?
Yes, Your Honor.
But keep the right to appeal fundamental issues or issues on sentencing errors. Had enough time to talk to your attorney?
Yes.
Satisfied with the advice?
Absolutely.
Any promises other than what's in this agreement?
Yep.
What?
Sir?
Have you been promised anything except
Oh,
this?
no, sir.
Okay.
Sorry.
Have you been threatened or made to plead when you don't want to?
No, sir.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever committed to a mental health facility?
No, sir.
You were driving without a valid license?
Correct.
How come?
I had it gotten back. I had gotten it back about a year and a half ago, 2 years ago. And Judge Ward, he knew the DMV was going to take it back, but he made me get it anyway. So they gave it back to me for like a month or 2 months, and then they went ahead and took it back from me. The DMV did.
So why were you driving on the day that this happened?
Well, my girlfriend and I actually got in a big argument, and I just needed to leave the house for a while. So I just went literally a block up the road and pulled over.
Take a walk.
Fair enough.
You know, if you don't have a valid license, you can't drive except in a dire emergency.
Yes, sir.
Okay. Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Under the circumstances, you'll be adjudicated guilty. You'll be placed on 6 months probation, pay $300 court costs, a $50 cost of prosecution. Do you need a hearing about reasonable attorney fees?
Sir.
Do you need a hearing about reasonable attorney fees?
No, sir.
All right, $50 public defender application fee and a $50 public defender fee, and you'll complete any outstanding DUI charge sanctions that you have not yet completed.
Yes, Your Honor.
Has the right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Your Honor.
Thank you. Good luck.
And Your Honor, we request the supervision fees be waived.
Granted.
Thank you, Mr. Berry. Judge, the next person I'd like to call is Ms. Miranda Ballantyne.
And after this, if I may, Mr. Gibbs, I need to just call one case after this, please.
Your Honor, Tim Gibbs for Miss Ballantyne, excuse me. Tim Gibbs for Miss Ballantyne in 22 CF 1807. Judge, we'd like to just leave this on docket day the 6th at 9 a.m.
Ordered. Stay in touch with the attorney, please.
No objection.
Yes, ma'am. Next case.
I was gonna call Mr. John Green.
Green.
Yes. James, I apologize, and the case number is 21 CF 2552.
All right, James Green. Mr. Green here he is.
Your Honor, it's the same situation for Mr. Bert Moore.
Okay. And sir, once again, you have the right to an attorney. Your attorney has been suspended, so do you want me to inquire about whether you qualify for public defender services, or do you want to hire a private attorney?
Public defender, please.
Raise your right hand. You swear firm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, sir.
James Green.
And are you employed? What do you take home each pay period?
About 500
How often?
weekly.
Weekly? How many people in your household? How many dependents? 3 plus yourself?
No. It's
So
just
2 plus
myself
yourself?
2, yes.
So you make a little over $2,000 a month? Appoint the public defender, you qualify.
Thank you.
So on Mr. Green's case, Your Honor, since we have just been appointed, we'd request a continuance to next cycle so we can meet with him and discuss his case.
Granted.
Thank you, Judge.
Please make and keep appointments with your attorney, sir.
Your Honor, if I may, the next person I'd like to call is Jeremy Brundage. Your Honor, Mr. Brundage is present and approaching. Tim Gibbs on his behalf, 22 CF 2652. Judge, we've reached an agreement in Mr. Brundage's case if I can approach with a written plea.
May. He's pleading to all 3 counts.
Yes, Judge.
Do you have a score sheet?
Don't believe one was printed out, but I believe Ms. Leon is going to be preparing that. I've seen the score sheet. It's been provided in discovery, and I have no objection to it.
Recall the score.
I'm going to pull it up, Your Honor.
I do not believe it was I believe it was in between 22 and 44 points, if I remember correctly.
While she's looking that up, sir, if you'll raise your right hand to be sworn. Do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, sir.
Jeremy Brundage.
And Ms. Brundage, I understand you want to plead no contest to possession of marijuana over 20 grams, possession of drug paraphernalia, and driving with your license suspended as a habitual traffic offender.
Yes, sir.
And I have the written plea agreement. Is this your signature on it?
Yes, sir.
Did you read all of it before you signed it?
Yes, sir.
Any questions?
No, sir.
Understand it all?
Yes, sir.
Understand you giving up the trial?
Yes, sir.
All trial rights and the right to appeal guilt.
Yes, sir.
But keep the right to appeal fundamental issues or issues on sentencing errors. Had enough time to talk to your attorney about your decision?
Yes, sir.
Satisfied with the advice given?
Yes, sir.
Any promises made besides what's in this agreement?
No, sir.
Been threatened or made to plead when you don't want to?
No, sir.
Any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
Tell me about getting stopped by the police and them finding these drugs and paraphernalia.
Oh, I was coming from the store and didn't come to a complete stop. And they
Did
did
you
a
or
search.
did you not?
I didn't come to a complete stop, what I was pulled over for.
Okay. And then they stopped you?
Yes, sir.
All right. And how was it they found the drugs?
They searched the car.
Did they ask permission to do it?
Yes, sir.
Did you give them permission?
Yes, sir.
Okay. You knew the drugs were there?
Yes, sir.
They were your drugs?
Yes, sir.
You had marijuana?
Yes, sir.
More than 20 grams?
Yes, sir.
And what kind of paraphernalia?
Scale.
Okay. Was it for drug weighing?
Yes, sir.
And was your license suspended as an habitual traffic offender?
Yes, sir.
So why were you driving that day? Just out riding around?
Yes, sir.
When your license is suspended, you can't drive.
Yes, sir.
All right, unless it's a dire emergency. Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Presuming that the score sheet is under 44 points.
Your Honor, if I may, it's 10 points, 10.6 total.
Oh, it's going to be pretty low unless he had a significant record. At any rate, sir, this time you'll be adjudicated guilty. You'll be sentenced to time served. You'll be required to pay $515 in court costs, $100 costs of prosecution, And you're entitled to a hearing regarding reasonable attorney fees. Do you need fees or a hearing about whether the $50 application fee and $100 public defender fee are reasonable?
Yes, sir.
You need a hearing about that? All right. So you agree that's reasonable?
Oh, yes, sir.
Okay. And I'll assess the $50 application fee if unpaid, plus a $100 public defender fee. Those monies are due within 180 days from today's date. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Yes, sir.
Thank you, Judge. Call the clerk later this week. You need to be fingerprinted. Call the clerk later
Case
this week
ready?
to get a payment plan. Thank you, Your Honor. Next case, Judge, if I may. I have Ms. Sarah Bryant. Your Honor, Tim Gibbs on behalf of Ms. Sarah Bryant, 22 CF 955. Judge, we've also reached an agreement in Ms. Bryant's case, if I may approach.
And now, if you'll raise your right hand and be sworn, do you swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Sarah Bryant.
Ms. Bryant, I understand you're pleading no contest to driving with your license suspended or revoked, first offense, possession of methamphetamine and drug paraphernalia. Is that correct?
Yes.
Is this your signature on the plea agreement?
Yes.
Did you read all this before you signed it?
Yes, sir.
Any questions about anything in it?
No, sir.
You understand everything in it? You understand you're giving up the right to a jury trial, all trial rights, and the right to appeal guilt,
Yes, sir.
but keep the right to appeal fundamental issues or issues on sentencing errors. Had enough time to talk to your attorney?
Yes, sir.
Satisfied with his advice?
Yep.
Any promises made besides these? Anybody promise you anything
No.
except for what's on this document?
No.
Have you been threatened or made to plead when you
No.
don't want to? Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility? How long, or tell me
It
about
was
how you got
last
stopped?
year. Last year.
You did go to a mental health facility?
Yeah, last
How
year.
long did you stay?
Just a week.
So you didn't go off to Chattahoochee or anything?
No.
Okay, so it sounds like more of an observation,
Yes,
not a
sir.
commitment. And tell me about getting stopped in this case.
I was driving when I shouldn't, and
How come?
Right
What
answer.
happened? I mean, why,
just wants to know what happened. He
did you
wants to
do
make
to
sure
make the
that
police
there's
stop
enough.
your car?
I don't know why, actually. They were sitting at the gas station pump behind me when I was at the store. I hadn't even, I felt like they were,
Got to talk up so I can hear you.
Go ahead and let him know.
they were behind me at the gas station, and I don't know, I guess they just decided to pull me over out of everybody. I don't know.
You know why they decided to pull you over?
No, sir.
Was it at night?
No.
Were any of your taillights broken or anything?
No, sir.
Well, if you have no idea, was there anything in the probable cause statement about the reason for the stop? Well, the point is, ma'am, if there was not a legal basis for a legitimate stop, you might have a legal issue here about how you got stopped and the search was made and you ended up getting arrested. You understand
It's
that?
okay. I'm gonna go with what he's got.
Well, that's a different question. Just listen to
I'm
what I'm
sorry.
asking you. You understand you may have a legal issue here that you're giving up by
Yes, sir.
accepting this plea offer.
Yes, sir.
All right. Go ahead, sir. And how was it they found the stuff? Did they ask you if they could search your car?
Not really. They just kind of did.
They just went ahead and started searching.
Yeah, but I mean, other people had been using the vehicle and wouldn't. So.
Were you stumbling around or doing anything to make them think you might be impaired before you got in the car?
No. I'm usually
So-
very aware of myself around vehicles.
So was this your meth and paraphernalia?
No, sir.
Whose was it?
I'm not sure. I'm not sure who had the vehicle
Did
last.
you even know it was in your car?
No.
Didn't even know it. So, and you never handled it?
I have before, but not.
No, I'm
that-
talking about the
Oh,
stuff
no.
that was in there. Did you
No.
ever handle it?
No.
Did you even know it was there in the car?
I had a hint that maybe something in the car. I just didn't know what.
All right, well, why would you have had it in the car?
Well, I didn't think I was going to get pulled over, but I didn't know to.
Yeah. What I'm trying to get at is, did you have any reason to know it was there and actually control it in any way?
No.
Okay. If that's the case, you may have a defense that it wasn't your stuff, you never used it, and you didn't even really know it was there, you know? So you're giving up that issue as well. Do
Yes,
you
sir.
understand that?
Yes, sir.
All right. And do you want to do that or not?
Yes, sir.
All right. Under the circumstances, I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Any possible defense or legal issues are voluntarily waived. And we have a score sheet.
That'll be forthcoming, Judge. I believe she also does not score.
Likely be in similar range of scoring. Have you ever been in trouble before, ma'am?
It's been a long time ago.
How long? Or what
I'm
were you,
not
what
sure.
were you convicted of?
I'm not even sure. It's been that long.
Felony, misdemeanor, or do you remember?
I don't remember. Probably one or the other.
She has a total score of 17.4 points. Her prior record only shows 3 misdemeanors.
Thank you. So
Misdemeanor.
that'll get signed later.
No
Any
objection,
objection to that
Judge.
score sheet?
No objection.
All right. And ma'am, at this time, the court will withhold find you guilty of the offense. The plea was, as I stated before, the court will withhold adjudication of guilt. You'll be required to pay $100 cost of prosecution, or $515 in court costs, and a $150 public defender fee. Your sentence of time served, and this is on all counts. It will be payable within 180 days. And once again, as you might have heard me say before, did you need a hearing about reasonable attorney fees? Pardon?
Yes, sir.
You need a hearing on that, whether they're reasonable or not?
About the attorney's fee, that $150 public
That's
defender
fine.
fee. Are you okay with that?
Yeah, I'm okay with that.
And then that finding stands. And is there a requirement for adjudication on the driving with license suspended charge? I don't think there is there?
Not that I'm aware, Judge.
No extra fees.
I'm willing to pay that.
Advisory right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
And for the record, Judge, those were all withholds of adjudication.
Withheld on each count.
Thank you, Judge. So 180 days to pay all of that.
Okay.
You can get a payment plan with the clerk.
Okay.
Mr. Gibbs, I have the score sheet.
Judge, let me approach.
Next case, please.
Chair, the next case I'd like to call is Shane Collier. Your Honor, Mr. Shane Collier is present and approaching. Tim Gibbs on his behalf, 22 CF 663, 22 CF 665, 22 CF 2690. Judge, we have reached an agreement with the state. If I can approach with a written plea.
All right, sir, I have a plea agreement here on 3 cases, and it's my understanding that you're pleading nolo contendere to aggravated animal cruelty, to fleeing or eluding at high speed, to burglary of an unoccupied conveyance, and to grand theft. Is that your understanding?
Yes, sir.
All right. And I have the plea agreement here. Is this your signature on it?
Yes, sir.
The state has not signed it. If you could return it to the state, please. And did you have a chance to read all that before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
You understand you're giving up your right to trial, all trial rights, and the right to appeal guilt, and that's a jury trial.
Sir.
But you keep the right to appeal fundamental issues or issues on sentencing errors. And if you had enough time to talk to your attorney about your decision,
Yes, sir.
are you satisfied with the advice given?
Sir.
Does anyone promise you anything other than what is in this agreement to get you to plead?
Sir.
Have you been threatened or made to plead when you don't want to? Had any medicine, drugs, or alcohol in the last 24 hours?
Sir.
You ever been committed to a mental health facility? And tell me what happened about the burglary and grand theft.
I don't know. There was like out with like my buddies and stuff. We was just out there like, I don't know, we was really just having a fun time. And then we was just walking, and then like, I guess like they had saw stuff, and then I guess they had went to go grab it, but I guess I was with them. I got caught in the camera with them. I ain't do nothing though.
Well, that's my point. Did you go onto somebody else's property or in a car or anything to steal anything?
Yeah, I was on the property with them.
So you went on the property. Did
Yes,
you know
sir.
they were going to do any stealing? Were you going to act as a lookout or warn them if anybody came?
No, sir, I was just following them.
Were you going to get anything out of it?
Sir.
Did you get anything out of it?
Yes, sir.
What did you get?
I don't remember what it was. I remember that after a little while later, they had like told me that they had took it after we had got pulled over or whatever, and then each one of us just like claimed one, I guess, type
Was it
stuff.
like fishing rods?
Yeah, I think that's what it was. I think that's
How
what
did
they
you
gave
do
me.
that?
I didn't do it. I was just with them.
Well, you agreed to take some of the stuff.
I figured out that it was taken after the fact that
Well-
they had explained it to me.
Once you take it, you know, that you're at least participating in the theft.
Yes, sir.
And if it came from a burglary going on somebody's property, then arguably you could be an accessory after the fact. Now, you may have a partial defense in that regard.
Yes, sir.
As to the burglary. But do you think what you were involved in taking or what they took altogether was at least $750? Because it's accused of being grand theft.
Yes, sir.
Okay. And tell me about the fleeing or eluding at high speed.
Gosh, that was so long ago.
By the way, how old are you now?
I'm 18 now.
Okay, how old were you when all this happened?
It might have happened last year. Probably like 17.
Well, if you were 17, we might have an issue here.
I
Has it
believe,
been looked into?
no, as far as I know, no, Your Honor. I believe, at the very
Look at
least,
the
that-
arrest report. What's the date of birth and what's the date of the offense?
The date of the offense, I do.
Judge, his date of birth is just, October 29, 2004. I do know that in 22 CF 663 and 22 CF 665, those did start originally as juvenile cases. Eventually, the state did file a direct file transfer to circuit court.
Well, if they follow the procedure, that's fine.
Yes,
Just wanted
that's-
to make sure we were on the right page here.
Thank you, Judge.
Yes, sir.
But the point is, do you recall fleeing and eluding at high speed? What happened there?
I guess I just got scared and took off.
Were you going at high speed?
Sir.
No accident?
Yes, sir.
Well, that's fortunate. And tell me about this animal cruelty charge.
Oh yeah. This was like maybe like 3 years ago. This been going on. So like I guess I was with my friends, right? And we was all like chilling and stuff. And then so there was like kitten. We was supposed to go give it to like the animal shelter or whatever, like, cause it kept coming to my front porch. I had walked home one night and it followed me, and I gave it food and it just stayed on my front porch every day, like every night. It would sit
Talking
there.
about some animals?
Yeah, it would like sit there and meow and stuff. So then like,
Cats.
yeah, and then so like, I was like, oh well, it can't sit there on the front porch. And I had people in my house who were like severely allergic, like could die from a cat, you know. So we couldn't have it. So we had to trap it and go like give it to the animal shelter. But before we did that, a bunch of my buddies came over and we was just like, I guess we were just chilling. And then I don't even know, like we was like, I guess I was inside the whole time. I guess my name got brought up because I guess the lady who called the cops was my sister's best friend's mom, and like she knows me and she don't like me. So I guess
Here's my
they
point.
called the cops on me because it happened at my
Here's my
house.
question. Did you do anything to harm one of those cats?
No, sir.
Nothing at all?
Nothing at all.
Did you do anything to help any others or tell any others to do that?
No, sir. I was inside my house.
Well, if you didn't do anything, you didn't initiate anything, you didn't help them or encourage them in any way, you may have a defense to that charge as well.
Yes, sir.
And that's, not a good charge to have on your record. You
Sir.
know, it has some serious implications for a lot of the public.
Yes, sir.
So, my question to you is, again, is this agreement something you want to take
Yes, sir.
to all these offenses?
Yes, sir.
Knowing that you may have multiple legal issues about how things happened and possibly multiple defenses about virtually all these charges.
Yes, sir.
Understand that? And you want to give them up for all time and go ahead and take this agreement.
Yes, sir.
And you're going to be a convicted felon because of this.
Yes, sir.
And that's going to affect your ability to get jobs and do all kinds of things in the future. You understand that?
Yes, sir.
Okay, but this is the way you want to handle it?
Yes, sir.
You've learning a very difficult lesson. I'm sure if your family talked to you, they probably said you're known by the company you keep. And if you're chilling with people who are getting involved in difficulty,
I changed my whole friend group.
well,
I don't got
I'm glad
none of
to hear
them no
that.
more.
It's unfortunate that it happened a little bit late. But the point is, you've got to make decisions for yourself and not just go along with the crowd.
Yes, sir.
All right. And do we have a score sheet, by the way?
Yes, Your Honor, we do. And for the record, in 22 CF 663, state would announce a dismissal of count 2, the child abuse in exchange for a free count 1.
If I may approach, Judge, no objection.
And the score sheet totals 42.4 total sentence points. So, Mr. Collier, I do want to tell you that you're going to have this 5 years of probation.
We were just clearing up that he wants to continue forward with the plea.
My point is this, is how what you want to do is continue on with the plea.
Yes, sir.
And what I'm telling you is that with 5 years of probation here, that's the offer. And with this score, if you don't do what you say you're going to do, which is follow the law and stay away from bad influences and make your own independent decisions,
Yes, sir.
if you come back, you're looking at a presumed state prison sentence, probably somewhere around 14, 16 months minimum, unless you judge is convinced that you don't really need it.
Yes, sir.
You understand that? It's a very important thing. So this time, sir, I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. Any possible defenses or legal issues are voluntarily waived. And at this time, you'll be adjudicated guilty. You'll be placed on 5 years probation on each count concurrent. You'll pay $300 cost of prosecution and $415 court costs per case. So that's going to be somewhere around,
$1245, I believe, Your Honor.
$1,545, I think. Plus, there's a public defender fee here, the application fee of $50 and $100 per case. Do you need a hearing about whether those fees are reasonable?
Can you say that one more time?
Yes, sir. You've got a $50 public defender application fee and a $100 public defender fee per case. And you're entitled to a hearing about whether those fees are reasonable. You understand that?
Yes,
Do
sir.
you need that hearing or not? Or do you think those are reasonable fees for your attorney's office?
Those are reasonable fees.
All right. I find that you've waived your right to an attorney fee hearing. Sir, you'll enroll in an anti-theft course within 30 days. Court finds that restitution is owing and will reserve jurisdiction for 60 days to determine an amount. You'll have no contact with, is it Bobby, what is it, Merrick?
Yes, sir.
So, yes.
Merrick III. You'll also have no contact with a person whose date of birth is October 26, 2006, and whose initials are KMM. You do not possess any animals or reside in the same household where there are any. You'll submit to a psychological evaluation within 30 days and follow through with any treatment that is recommended. That includes taking any prescribed medications. You also enroll in an anger management course and follow through with any treatment that's recommended. You should do that within 60 days. And you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Yes, sir.
Thank you, Judge.
The request for supervision fees be waived, Your Honor.
Yes.
Thank you, Judge.
Good. Wanna do that?
Thank you, Mr. Berry. Next, Your Honor, if I may, I have Crystal Gifford. Your Honor, Ms. Gifford is present and approaching. Tim Gibbs on her behalf, 22 CF 2872. If I may approach with a written plea.
Okay.
Miss, Gifford.
We have a score sheet.
Do not have what?
Was she pleading to? As charged? I'll print it out, Your Honor. It's just next door.
And I'll begin here, and if you raise your right hand to be sworn, please. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, self you got?
Yes, sir.
And speak up loud and clear. State
Yes,
your
sir.
name.
Christelle Gifford.
Ms. Gifford, I understand you want to plead no contest to aggravated battery with a deadly weapon and criminal mischief over $1,000.
Yes, sir.
And those are both felony offenses. And is this your signature on your plea agreement?
Yes, sir.
And did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Understand everything in it?
Yes, sir.
Understand you're giving up your right to trial, all trial rights, and the right to appeal guilt.
Sir.
But you keep the right to appeal fundamental issues or issues on sentencing errors. You had enough time to talk to your attorney about your decision?
Yes, sir.
Satisfied with the advice given?
Sir.
Any promises made besides what is in this
No,
paper?
sir.
Been threatened or forced to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
Ooh.
Have been committed to a mental health facility?
Sir.
All right. And tell me about what happened here with the criminal mischief and aggravated battery with a deadly weapon.
It's my car. I backed into a lady at a stop sign.
Did you do that intentionally?
Yes. Yes,
Why?
because I took my anger out on her instead of the person who was beating me.
Did the car actually hit her or hit her car she was in?
My car backed into the front of her car, yes, sir. At a stop sign. We were stopped at a stop sign, so I was 4 or 5
What had
feet.
she done to get you upset?
Sir, I was arguing with I'm leaving a horrible relationship, sir, and we were arguing. And instead of getting beat up, I left the house. And things escalated.
As you point out, you shouldn't take that out on others, especially
No,
on
sir.
innocent third parties. And so how much damage do you think you did to her vehicle?
I called my car insurance company. They're paying for it to be repaired. They haven't told me yet.
Do you think it was at least $1,000 worth of damage?
I don't think so, because there wasn't but a scrape on my car.
Well, you may have done some criminal mischief here. You may have at least a partial defense that you did a lesser amount of damage. If it was less than, was it $200, it could be one level of misdemeanor. If it was between 200 and 1,000, it would be another level, but not a felony like this is charged as. You understand that?
Yes, sir, but if I do everything I'm supposed to do and never get in trouble ever again, it goes away. Yes, sir.
Well, it doesn't necessarily go away, but it doesn't become a long-range felony conviction.
It's not currently a conviction because it is a withhold of
Yeah,
adjudication.
It's not a conviction because it's a withheld adjudication. As long as you do everything you're supposed to do, this will still be on your record if you mess up otherwise in the future, but it will not be shown as a actual conviction, but it'll still be on your record. Okay? That's a big distinction legally.
It is.
It is.
I mean, for future jobs. I'm an accountant.
Well,
I mean,
it's not a felony conviction.
it's not a conviction, but it's a felony on my record.
It will show that and you'd have to ask if an employer asks you, have you ever been arrested? You'll have to tell that. Did you ever settle the case in court? Sometimes they ask those questions. Usually it's just about an arrest, and then they look into it after that. So this will be readily available as a public record.
You would not have to say that you are a convicted felon so long as you do not violate your probation.
But I'm still a felon.
Well, you're charged with a felony. You don't.
Charged with one. It's not technically a conviction for a felony. It's
Okay.
not legally a conviction.
Okay, yes, sir.
Can Okay, may I confirm, 1 second, Your Honor.
Your Honor, in speaking with Ms. Leone, I think we might be able to modify the resolution on this case. If we could leave this set for Monday for docket day to get that resolution.
Matter to you. In the meantime,
Thank you, Judge.
since this young lady is a CPA, ma'am, you might want to ask someone that you know as an advocate to check with your board with a hypothetical. If there's a withheld adjudication for a felony, would that be any difficulty for a CPA keeping their license? You understand that?
Yes, sir.
I'm not here to give you legal advice,
Yes, sir.
but you can ask those kinds of questions or have someone do that for you so you will be more informed, because I can't
Right,
give you
get in
legal
the
advice
nitty-gritty. Yes, sir.
beyond what I've told you.
Yes, sir.
Okay, so I don't know what the CPA board may or may not do with that, but you ought to factor that in making your decision.
Yes, sir. Yes, sir.
Okay?
Okay.
So you're free to go. Just give me a call.
Yes, sir. When I come back, when to
Stay in touch with your attorney, please, Monday morning at 9 o'clock.
Thank you, Your Honor. Your Honor, next I have Mr. Bradley Standard. Your Honor, Mr. Standard is present and approaching 21 CF 3108. Judge, we're asking to continue this to the next cycle. We have another round of depositions we'll need to be setting.
State have any objection?
I'm sorry, Mr. What?
This
is
Ms. Sandler's case.
Oh, Ms. Sandler.
Mr. Standard?
I'm sorry, okay, there is no objection.
And is that acceptable to you, sir?
Yes, sir.
Case is getting a bit shaggy. Need to kind of get it resolved.
Yes, Judge.
All right.
Thank you, Judge.
April 24, 9 o'clock.
Thank you, Judge.
Yes, sir.
That's all I have at the moment, Judge.
All right, we have another counsel ready with another case.
Yes, Your Honor. Your Honor, I have a few more to address.
Order in the court, please.
Your Honor, Alexandria Slusher, 22 CF 2197. We received notice that from 12 Oaks that she had turned herself in. She's doing inpatient there for a month. I believe we filed a
Asking for a
waiver of
continuance?
appearance, and we are requesting a continuance.
Any objection?
No objection.
Granted, April 24.
And, Your Honor, the next one that I have is Andrew Stokes. I haven't had any contact with Mr. Stokes.
Bond status? Actually, if we can hold the failures to appear to the end.
Yes, Your Honor. The next one I have, Your Honor, is Tyrone White, 22 CF 3181. I received a text from our office that he had called in saying that he was on his way to the emergency room because he was out of oxygen. He has poor health. Asked if maybe we could put it on 3-9. Tyrone White. Put it on 3-9 and give him the opportunity to make it into court.
Notify the bondsman for March 9.
Your Honor, the next one we have is Donna Walters, 22 CF 1688. Your Honor, she is a PTI reject. They had sent her back from pretrial intervention. Your Honor, she does contest that she has violated her pretrial agreement in any way.
Need a contested hearing on that?
Yes, Your Honor, we would.
Your Honor, she's already entered into a plea when she accepted PTI, so it should proceed to sentencing.
Counsel, how do you want to schedule it?
Your Honor, if we could schedule it for she would like a hearing, Your Honor, because she
Ma'am.
contests that she violated in any way.
It'll be a combined hearing to determine
Yes.
whether there is
Right.
any, and if she's found to have violated, then generally that's more administrative, but in the circumstances, if you have any authority, I'm sure the judge will be interested. So, but we need to schedule it for another proceeding regardless. So how much time do you need to be prepared? Set it on a sentencing date, or do you have those on your docket?
We have miscellaneous days.
Well, subpoenas would have to be issued, so March 30th.
All right, what time? 2 p.m., March 30th? Stay in touch with your attorney and get her all necessary information on your case.
Okay.
Thank you, Your Honor. That's all the out of custody that I
Does
have.
the council have any?
Afternoon, Judge. Oh, I'm sorry.
There's one more. Go ahead. Your Honor, I have one more. I have a plea. Out of custody, I called him earlier, but he was not in the courtroom. That's Stephen Renfro. If I may approach, Your Honor?
May. All right, sir, if you raise your right hand to be sworn, you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God. State your name, sir.
Stephen Renfro?
Mr. Renfro, I have a plea agreement. I understand. I don't have it checked here as to which plea he's entering, counsel.
No contest, Your
All right,
Honor.
I'll check it for you. And so, sir, you're pleading no contest, is that correct?
Yes, sir.
And is this your signature on the plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it? Do you understand everything in it?
Yes, sir.
You understand you're giving up the right to trial, all trial rights, and the right to appeal guilt, but you keep the right to appeal fundamental issues or issues on sentencing errors. You had enough time to talk to your attorney about your decision?
Yes, sir.
Are you satisfied with the advice given?
Yes, sir.
Anyone promise you anything to get you to plead, other than what's in this agreement?
Yes, sir.
Been threatened or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility? Tell me about driving with your license suspended and then having some drugs and drug paraphernalia found.
Suspended license I didn't know was suspended. It was actually suspended that day for having a ID and a driver's license at the same time, which I did not know was illegal.
What about the drugs and paraphernalia?
The drugs I put up for somebody. They asked me if I would hold them because I had a little talk with them about using them and when not to use, and so
You just tell them to get rid of it.
I wish I had them now. I mean,
Was there some drugs paraphernalia there, maybe a
yes,
pipe or
sir.
something?
They asked me could they leave it in the truck. I mean, I
So it was a pipe?
yes, sir.
Okay, so did you ever possess it for illegal use?
No, sir.
What was your purpose there in trying to help them get over a problem?
I was talking to the girl about, she was using fentanyl, and I told her she didn't know when her next time would be her last. And she said she had already used. Can I hold it for her till, because she had already used that day. I said, yeah, throw it in the console.
Well, you should have gone to turn it in.
Yes, sir.
But to this extent, that you did not have the intent to illegally use or possess those items.
No, sir.
You understand you're giving up a possible defense to these charges. At
Yes,
least
sir.
that portion of the charges. So why do you think you were stopped in the first place?
I was told that that they have some kind of system on their car that told them that I was driving with a suspended license.
Okay, well, they can match your license to your tag,
Apparently so.
driver's license to your license
First
tag.
I'd heard of it.
All right. And did you receive notice of that?
No, sir.
All right. Well, you might have a legal issue here, and counsel, did you check your green sheet about whether it had been sent out at least 20
We
days
did, Your
ago?
Honor. It had been sent out, and we did have a discussion about it, because there was a short lapse, and I did even have a discussion with the state about it, where he could have, thought his license was good when it wasn't. And the state has, made a good offer based on that, because it was originally charged as a felony.
Well,
But the state did give notice, it was marked on the sheet, on the DL sheet. That they
so
had
it was
provided
at least
notice.
20 days since they had sent notice?
Not having it in front of me, Your Honor, I couldn't tell you right at this moment.
Sir, to the extent it may have been less than 20 days, you understand you're giving up a legal issue there as well.
Yes, sir.
It's my understanding you're pleading to a lesser charge regarding the driving license matter of a misdemeanor under 322.34 subsection 2 sub B. So is this the way you want to proceed, is take this offer?
Yes, sir.
Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support it. We have a score sheet with 17.6 total sentence points. Any objection?
No, Your Honor.
All right, sir, this time, court will withhold adjudication of guilt. You'll be required to pay the $515 in court costs, plus $100 cost of prosecution. You're entitled to a hearing on attorney's fees. You need a hearing about whether the $50 application fee and the $100 public defender fee are reasonable. You've waived your right to that hearing. You're also sentenced to time served on this matter. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Judge, let me shuffle a bit here. Judge, there was one more case where the individual's not going to be in court today. If I can go,
Could we hold it till the end?
Sure.
Let's deal with people who are here where we can take care of their business.
All right, Judge Crystal Hall. Judge, this is a PTI fail-out. We need to set her on, I guess, a miscellaneous date for sentencing.
It was March 30th, if I recall. Okay. Well, it's a sentencing
Mr.
hearing.
Williams?
In effect,
Was there a plea with the PTI? Because what I'm suggesting, if it was a failed PTI, if we can put it for next Monday, or even in a miscellaneous, we may be able to resolve it.
Madam Clerk, if I can inquire, because I just got the file today, are you showing that she entered a plea on it originally? The case number is 20 CF 864. All right. Ma'am, can you be back here for Monday? And can you meet with me maybe Friday or something like that? At my office at 9 o'clock on Friday.
Okay.
All right.
Monday morning at 9 for court.
Thank you, Judge. Come to my office. Public Defender's office here in Crestview. 106 Pearl Street, I think. Okay, next one that I have is James B. Ham. Judge, we're still waiting on an FDLE report, just confirming the substance.
No objection, Your Honor.
Mr. Ham, you have any objection?
No, sir.
That's request to continue granted April 24. Thank you, sir. Stay in touch with your attorney.
Judge, the next one is going to be Trayvon Howard. Judge, I think we're going to be able to get this resolved, but I don't know that we're going to be able to get it resolved this time. Mr. Howard, when I spoke with him earlier today, had a question, and I want to give him a chance to get that question answered.
I like-
We can move it.
I was just saying, I like that offer that they gave me and stuff like that. I didn't want to violate my probation.
Think you
Yeah,
can
he's
meet
got
between
a-
now and Monday and put it back on Monday?
Judge, do you think you can manage to talk with your misdemeanor attorney or your?
By Monday, yeah, I could probably do it.
Okay, that's fine, Judge. I've got a number of others I'll be setting for then as well.
If you've got any, issues, make sure you talk with both your attorneys about it.
Okay.
Got a misdemeanor issue affecting you.
Yes,
Is
sir.
there a potential VOP if he pleads?
That's correct, Judge.
Yeah, you need to be aware of that, because if this is alleged to have occurred after you were put on probation, entering a plea is considered a violation.
Yeah, that's what I don't want, but I like the offer they gave me. I just
It's
want.
all based on the dates, sir.
All right.
Yes, sir.
Yes, sir.
Talk to your other attorney too, though, in the meantime.
Next one is Joseph Johnson. Judge, on this one, I've gotten some information that there might be.
He is
Oh.
an inmate, definitely.
I'm sorry. I had him in my, I did not have a red sticker on him. Did we already handle Shirley Jones?
I think we handled that.
Excused?
Yeah.
Okay. Let's see, Heather Kelly's an inmate. Ethan Knecht. Judge, I believe you were here when it came up previously. This is the gentleman that entered a plea. He had a brand-new case that I apparently failed to arraign him on. I thought I'd arraigned him there with Judge Nickinson. In any event, we pulled the court smart. He entered a plea on everything, but this case number was not in the case numbers that the judge had announced. Ms. Leone, I've talked with you about it before we did
Yes,
that, and then I've
yes.
talked with you again since, and last time it got passed to make sure that you were
Counsel, what do we
okay
need to
with
do today?
I think what we need to do, Judge, is let me arraign him on case number 22 CF 3113.
What's his plea?
Not guilty, but he's about to change it to no contest, and we sent it to him concurrently. Is that
Yes.
your agreement?
Yes, Your Honor.
We're just correcting the scrivener's error, Judge. Let me see if I've got a copy in this file. The original agreement, Judge, was filed with the clerk in the other case, and the original agreement has this case number on it, but I've got a copy here that I can provide to the court. Well, actually, it's a copy of the signed.
I already knew that I'm not.
Quickly. Give you the score. And if this would be not pro-tunc to previous date.
I can't do it that way, but I can do it retroactively.
That would be
I
fine.
didn't, it was not done originally. So which one is it that he's pleading to today?
This is 3113.
Mr. Williams, I'm so sorry, Your Honor, the score sheet, are they updated with all the cases in it? Would you
Well-
like me to look at them?
No, it's actually the same score sheet that we used before, so the other cases, I guess, would now be prior record, maybe?
Well, yes.
But that would give a lower score anyway, so we'll waive that.
Whichever way the court prefers, Your Honor. It was,
Will you tell me what you want to do? I'm here to resolve questions.
it was our intent at the beginning to have a global resolution. So whichever way it works, I'm fine.
You have no objection to Mr. Williams'
No, I don't,
suggestion?
I don't object.
It's really curious to me how this didn't happen with everything being right in the documents. But you say you both agree that it did not happen, is that correct?
Yes, Your Honor. It
We thought it happened. What came up is his name came up
There's no
later.
resolution on 3113?
Correct. It was on the plea agreement, but it was not.
All right, raise your right hand, sir. You swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God. All right, and state your name, sir.
Ethan Colquitt.
And Ms. Smith, I understand you're pleading no contest to a charge of allegedly felony failure to appear. You can put your hand out, sir, while we're talking. Is that what you want to do?
Yes, sir.
And everything will be done in this case retroactive and same sentence as to the other thing? You agree that's appropriate?
Yeah.
Did you fail to appear on those other charges or some of charges?
On the other ones?
Yeah, at some point, had
On
you
any
failed to
felony
appear in
charges?
court?
Yeah, yeah.
Why did you fail to appear?
Just missed it. I just got the date wrong.
You gotta keep track of your court dates when you come to court, sir. Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support it. Any objection to the score sheet with 36 total sentence points?
No objection, Judge.
All right, sir, at this time, the court will withhold adjudication of guilt. You'll be placed on 3 years probation, concurrent with any other matters that you're on probation for, and this sentence is imposed retroactive to the date of disposition of case 22-2954. You'll have all the same conditions as were announced in that case, and you'll be required to pay the additional $450 in court costs plus $100 public defender fee, $100 cost of prosecution. You have the right to a hearing on the $50 application fee and the attorney's fee of $100. Do you need a hearing on that?
No.
Waiving a right to an attorney fee hearing. So those fees are assessed. And Madam Clerk, is that sufficient for your records? The using and imposing those requirements in this case. And sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Judge.
Thank you, Mr. Williams.
All right, that should take care of it, okay?
Thank you.
I'm sorry. you had-
Oh, it's okay. Thank you.
222954.
The next one I have, Judge, is Jason Kuntz
With a K or a C?
with a K, Judge. Judge, we're going to move to continue Mr. Kuntz's case. Our case is, I've got,
He has two on the docket.
yes, sir, I want him to go speak to an expert for strategy and mitigation purposes.
We're also set for depositions, no objection.
All right. Is that all right with you, Mr. Kuntz?
Yes, sir.
All right. April 24 at 9 o'clock.
Yes, sir. Thank you, sir.
No, we haven't done any of those.
Mr. Kuntz, touch base with me in maybe 2 weeks, okay? Just so that we can stay on top of it. All right. Do we have Amanda Lawson on the docket? Okay. I think this is actually a VOP case, Judge, that just wound up in the bucket. Daniel Lawson, 22 CF 2898. Judge, I need to go over the discovery and Mr. Lawson's plea
New
agreement.
case, so state have any objection? Mr. Lawson, do you have any objection to your attorney taking time? Defense request to continue granted April 24, 9 o'clock. Make and keep appointments with your attorney in the meantime, sir.
Thank you, Judge. Desiree Lige, case number 22 CF 450.
Just coming up.
Judge, I don't know if they're on the schedule yet, but I had asked my legal assistant to schedule the state witnesses for depot. I'm going to move to continue it. It does have a bit of legs on it. All I can say in my own defense is I think I've had it since maybe October.
No objection.
Lige, do you have any objection?
No, sir.
Williams, get moving on it.
Yes, sir.
Follow up with your assistant to make sure it's done.
Yes, sir.
Thank you, Judge.
Thank you. Stay in touch with your attorney, ma'am. April 24, 9 o'clock.
Carrie Lobo, Judge, can we have Mr. Lobo come in on Monday? And Mr. Lobo, can you meet with me on Friday? There's been a change in the offer to you.
Stated in agreement?
Yes, Your Honor.
All right, March 6, 9 o'clock. Thank you, sir. Meet with your attorney in the meantime.
Danny Mason? Sorry, Judge, I keep stumbling across people that are incarcerated. Danny Mason?
You already called him.
I did? Oh, did I continue? Is he one of the ones I continued?
Yeah, they were already done.
Chance Mabry?
Chance Mabry, not here past the end of the docket unless you have other information.
Judge, I don't. I do know that he's got some,
It's all right, counsel, I need to take a 10-minute break. We've been at it for over 2 hours. Be in recess until 4 o'clock.
Okay.
Chance? I don't want to have him.
He's got
Good.
anxiety and depression issues, and I don't want to say that.
April 24, 9 o'clock.
Thank you, Judge.
How soon do I see you?
Just call, make an appointment.
I can still do the phone appointment, right?
Oh, yeah.
Okay, all right, thank you.
All right, Chance Maybury.
No answer put into the docket.
Judge, he was in mental health court for a while. I'm not
Put it at the end of
sure.
the docket and deal with people who are here who need to get their cases resolved. Mr. Williams? We've got
Ashley.
70 inmates after we've taken care of these folks, so.
Yes, sir. Ashley Mayan-Oviedo.
He's apparently out in the hallway.
She is, Judge. I know she's here. I've seen her several times. Here, I'll just call her back up in a few minutes. Matthew McCauley. Excuse me. Judge, I'm going to have to move to continue it then. He's going to need more notice to be able to get here than on Friday. There has
Do you have
been
any
a...
objection?
No objection.
You have any objection, Mr. McCauley? All right, April 24, 9 o'clock. Is Mayan-Oviedo here? Saw another lady walk in, but that's apparently not her.
And I know that she was in a hurry to get called. So, all right, Terry McMullen. Judge, this is a fairly new case. I have reviewed the body cam videos, but I need to sit
Asking
down
for
with him.
continuance?
Yes, sir.
State have any objection? Objection. And sir, do you have any objection? All right, and you're Mr. McMullen? April 24, 9 o'clock, granted.
Make an appointment, come by my office. Alan Mobley. Judge, there are things I need to discuss with you. The case is brand new. I'm showing that it was arraigned back on January
Do you have any
26th.
objections? No objection. First time up. Sir, do you have any objection? April 24, 9 o'clock. Make an appointment with your attorney, sir. I think Ms. Mayan-Oviedo's here now, possibly.
Thank you, Judge. She's approaching. Judge, we have spoken about the case a little bit, but no depots have been done. It's brand new. Move to continue.
No objection.
Any objection, ma'am? Please keep appointments with your attorney, April 24, 9 o'clock. Sorry to rush you, Mr. Williams, but just get right to the point.
Judge, that's all right. I understand. Ray Mobley. Judge, I've got a couple of things I need to ask Mr. Mobley about.
Relatively new case, asking for continuance?
Yes, sir.
State object? You object, Mr. Mobley?
Yes, sir.
April 24.
April 24th.
Make an appointment, come in and see me or
Sure,
call me,
you still do
okay?
it on Tuesdays?
Usually or Tuesday, but you can make the appointment anytime.
I'll call tomorrow.
Okay. Taylor Mooney. Ms. Mooney, could you come in this early? Judge, actually, I don't know that we need to do that. Let me just ask for a continuance on it. Looks like I'm going to have to schedule a depo with the victim. I tried to just talk with him on the phone.
Do you have any objection, ma'am? All right, April 24, make and keep appointments with your attorney, please.
Yes, all your court dates are going to be at 9 until we pick adjournment. Lorenzo Murphy.
Check that we had already taken care of the case.
Did we already say, we may have continued. I mean, may have been on my continuance list.
Is that Chuck Murphy?
I think he was. Latoya Nelson, 22 CS 1641. Judge, I need to get her in, look at one of the body cam videos.
Can you do that before Monday?
I can try to. I would suggest if we do that, we do it without subpoenas. Can you be available as early as Friday to come to my office and Monday to come back to court to try to get the case over with more quickly?
Yes.
Okay.
Next court date is March 6th at 9 o'clock, ma'am. Get by to see Mr. Williams and take a look at that video so you can make some decisions and talk to him about it.
I'm going to suggest 10 o'clock Friday morning.
Okay. 10 o'clock Friday, excellent.
Thank you. Hobart Newell. Mr. Newell, I'm going to ask you to do the same thing.
Okay.
Come over at, say, 11 o'clock on Friday. And Judge, we can pass this until the 6th. This case has been around for a while, but I need to let him look at some stuff.
That's a way to keep it moving, thank you. So May 6th, Monday at 9 o'clock, sir. Thank you. Keep that appointment at 11 o'clock Friday with Mr. Williams.
All right, Judge, that brings us back to Chance Mabry again.
End of the docket, sir.
And, well, I think I am. Ciara McDonald, she's not going to be here, Judge. She's in labor.
All right. How would you like to reschedule?
Judge, if she's in labor, I don't think I'm going to be able to get her in by Friday. It looks like they induced, and so let me just pass her till the 24th.
I think that's more reasonable. State have any objection?
No, Your Honor.
All right. Gentlemen don't have to deal with those kinds of challenges, so April 24.
Yes, sir. All right, Judge, in terms of out of
Robert Lamb?
Robert Lamb, oh, I thought I called Mr. Lamb earlier. I think he has two. Let me look, I've got the, yeah, he was continued, Judge, or he was on my list for continuance.
May not have been here at the time. Let me double check. I do have them checked off, so.
Yes, sir, we,
That's, what date did we say, April 24th?
it was the 24th. We called out a number of names, one after the other, and continued them. Yours was in that group, so you can leave.
I'll call you this week to schedule. The case is relatively young. Make and keep appointments with Mr. Williams, try to get the case resolved. Thank you. These are just spectators waiting, inmates? Okay, so we now have down to inmates. Let's go ahead and deal with those folks.
These people are here because they have friends or loved ones. That
Right. So, who has the list ready for?
Did we resolve what we're doing with Mr. Mabry?
We did not, because he's going to be at the end
Oh,
of the
at the
docket.
end of the complete
Trying-
docket. I understand, Judge.
Trying to deal with people who are here,
Yes, sir.
in one capacity or another.
We're going to take David Weiser.
Charles Russell, Public Defender's Office, Judge. This is David Weisar. Case numbers for the record are 21 CF 1739 and 1740. This was the one that we had the Nelson hearing back on the 9th, Judge. And you issued a detailed order. A couple of things. You wanted me to meet with him. I've met with him twice since then, and I was looking into a cell phone. I think I've determined the source of the confusion. One of the prior public defenders had informed Mr. Weiser that there was a cell phone in evidence because they had called evidence, and that's what they said. My investigator has checked with evidence and property and anybody else they can think of at the jail. There's no cell phone. He is in the process of getting paperwork to see if we can figure out if it was there. and
Not
it's
among
gone.
his personal belongings and
We've checked property and evidence, Judge, and anything else we can think of, and there's no cell phone.
All you got to do is check evidence logs, because I know it was there. She went to, the investigator for the sheriff's office went to the place of arrest, came to the jail and told me she had the cell phone. Picked up my cell phone.
And we've ordered records, paperwork, Judge, so we can see for ourselves.
Once we do a subpoena Dukas Tecum, see what they
We may
produce.
take that if there is one, but so far we've run to dead ends on that. So my intentions were in both cases were to set them for trial, but with the cell phone issue, I don't know what we need to do.
Well, you've got, when would be the trial cycle?
March 20th, because it'll be with Ms. Basso. It's March 13th and 20th of the 2 weeks, but she's already tied up with the trial the first week. You want to try bringing it Monday docket day and see if I've gotten anything sent by then?
No. If that's what it is, then we need to do other things to verify whether or not this item exists in the custody of the sheriff's department, either by records or by physical presence. And
Plus, I have
think you have mechanisms, as I suggested, to do that. That typically takes about 2 weeks to get it resolved.
I have a letter from the public defender's office from Timothy Gibbs stating that he talked to evidence at the sheriff's department and my cell phone was there.
That's correct, Judge, and I've confirmed that with Mr. Gibbs, but evidence doesn't confirm it.
The point is you need to verify that one way or the other.
Okay.
To have everyone clear, if it's there, it's there, if it's not, it's not. And there are legal mechanisms available to try to get that clarified, because it's a significant issue from your client's perspective, obviously. So I would recommend that we set it for the second trial week. In the meantime, issue a subpoena Dukas Tecum to bring the records and/or the phone. And go from there.
April 20th at 9, Judge,
And so,
and with
is there
subpoena.
anything else to do to be prepared for trial other than determine the availability of that item?
Not from my perspective, I don't know.
How about from the state's perspective?
Your Honor, just to be clear, we're going to go ahead, and he's got 2 cases. So I'm just going to, I'd like to go on 21 CF 1740, the failure to register. It's less witness intensive, if we've got to tee it up quickly.
And
Go ahead and do that one.
motel records that she hasn't given us.
I had requested some motel records on that particular case. I believe the state has it. Just as soon as she gets it to me, I can show it to Mr. Weisart. So if we can get that, that'll be fine.
Let's try to get this matter moving. This gentleman's been here a long time, and his case, like so many others, needs to get resolved, so. All right, doing the best we can here, Mr. Weisart, and you can see Mr. Russell is trying to get things clarified for you. And so give him your best ear on the subject.
So do we need to bring him in docket day, Judge?
I don't see any point. Unless-
Or no?
If there's anything we need to address at that point, otherwise, if there's a jury trial review, I don't think we have one.
Right.
I don't think so.
20th would
Date
be
and
our
time
last
for
chance.
jury selection? What's the date?
Mr. Russell?
Okay. Okay, let's set it for,
Let's treat this as a docket day and set the date and time and go eliminate extra work, if we can do that. Is that a problem?
can we set it for April 6th at 9, Judge, and that'll give us a chance to talk and we'll figure, hammer out the
March,
details.
sir.
Oh, that's right.
April. March 6th?
I mean, March, I'm sorry.
We can chat before then. I just got the jury on the 6th.
Mr. Russell, I'm trying to
Oh.
avoid you having to come back to court and your client have to come back to court any more than normal. What I'm suggesting is treat today as the docket day and go ahead and set the trial date right now. That way you can get subpoenas out. And, is that a problem for the state?
No, I'm just trying not to sneeze, I'm sorry. We can get this penis out, yeah. I was trying not to sneeze, what that look was.
It looked like there was something else going on, so, Mr. Russell, is that a problem for you?
No, sir. So March 20th, we will be picking a jury. We will go that Monday?
That's a Monday.
Is that what we're, okay.
March 20th at 9 o'clock is jury selection, is that the normal time?
Yes, sir. Yes, sir.
Right.
Do you know how many days it might be?
Yeah, I would think one.
But I would say exclusive of jury selection.
Jury selection in a day, so, all right. So we're trying to get things moving here for you.
So March 20th. Thank you. Daniel Kilburn. Charles Russell, Public Defender's Office. Judge, this is Mr. Kilburn. Case numbers are 17 CF 3565, 21 CF 452. We've got some witness issues. We're asking for continuance.
Without objection, Your Honor.
Kilburn, do you have any objection?
Any objection?
April 24.
Thank you, Judge. Appreciate it. Okay, and it's moved. Second to Morrison. Judge, this is Mr. McQueen, David McQueen. Case number is 21 CF 1989. We are ready for trial on Mr. McQueen. Docket day, March the 6th.
Sure.
All right,
Okay.
March 6, 9 o'clock.
See what I can do.
State is ready, I presume?
State is ready, Your Honor. Now, we did make a 5-year DOC followed by a 7-year offer for probation. The sex offender designation, is he formally turning that down at this time?
I'm still talking to him about that, and that's why I'd like to set it for docket day. I should be able to let you know something this week.
Fair enough. We'll
Okay.
leave it open until docket day.
Okay, I'll be in.
Next, please.
James Willoughby, 22 CF 2415. We've reached an agreement in this matter, if I may approach, Your Honor.
All right, sir, if you'll raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, please speak up loud and clear. State your name.
James Willoughby.
And Mr. Willoughby, I have a written plea agreement here, and I understand you're going to be pleading apparently no contest to a charge of burglary of an unoccupied structure. Is that your understanding?
Yes, sir.
That's count one. And is this your signature on that plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Have any questions about anything in it?
No, sir.
You understand everything in it?
Yes, sir.
You understand that by entering your plea, you're giving up your right to a jury trial,
Yes, sir.
giving up all your listed jury trial rights and the right to appeal whether you're guilty.
Yes, sir.
But you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir, I have.
Are you satisfied with the advice given?
Yes, sir.
And has anyone promised you anything other than what is in this agreement to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
You've been committed to a mental health facility.
No, sir.
What happened about this burglary?
We was broke down on the side of the interstate, and we had animals with us, and it was middle of summer, it's real hot, and I went over to see if the car on the other side of the interstate had maybe had something to drink in it, and
You went in the car to try to find something to drink
yes, sir.
without the owner's permission?
Yes, sir, I did.
All right. I find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support it. I have a score sheet with 45 total sentence points. Any objection?
No, Your Honor.
And this is going to be a mitigated sentence, is that correct?
Yes, Your Honor.
And state announces a null process to count 2.
Thank you very much. Second, please.
Yeah.
Sir, at this time, you'll be adjudicated guilty. You'll be sentenced to time served. You'll be required to pay $415 in court costs plus $100 cost of prosecution. You're entitled to a hearing about reasonable attorney fees. You need a hearing about whether attorney's fees of a $50 application fee and a $100 attorney fee are reasonable.
Perfectly reasonable.
You'll find that you've waived your right to an attorney fee hearing, and so those fees are assessed. You'll be required to pay those amounts within 180 days. And you're advised of the right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Sir?
You have anything else holding you in custody?
Anything else holding you in custody?
No, sir.
And you'll be released this evening in all likelihood.
Thank you, sir.
Next
case.
one's William Oglesby. Your Honor, he's before the court on 21 CF 802, 22 CF 2516. We're requesting a continuance at this time. I'll
Is that
talk
all
to
right
you.
with you, Mr. Oglesby?
Sir?
Is the continuance okay with you?
Sure, yes, sir.
All right. Defense request to continue granted, April 24, 9 o'clock. Your attorney will be in touch, sir.
We'll talk before
Okay,
then.
all right, thanks, Your Honor. Good.
Thank you.
Tyler Aquane, Your Honor.
See, that's how I know I can always count.
He's before the court on 21 CF 1972, 22 CF 523. If I may have just a second, Your Honor.
Yes, ma'am.
Your Honor, at this time, we are going to request a continuance.
State have any objection?
No, Your Honor, it's without
Jane,
objection.
do you have any objection?
No, thank you. Or no, Your Honor.
Defense
Sorry,
request to
wrong
continue
day.
granted, April 24, 9 o'clock.
Thank you, Your Honor.
Attorney will be in touch.
Thank you, Your Honor.
Willie Patterson. Your Honor, we have a hearing set for tomorrow, so we are requesting the continuance to 4/24, but just a reminder also that we do have a hearing set for tomorrow on 2/28,
What time is that hearing?
9 a.m., Your Honor.
And state have any objection to a continuance?
No objection.
And Mr. Patterson, do you have any objection to a continuance?
No, sir.
Defense request to continue granted, April 24, 9 o'clock.
You got,
You'll be back tomorrow morning for that hearing.
Ladarius Purdue, 22 CF 2008. Your Honor, previously, we had an evaluation done on him, and the recommendation was that he was incompetent due to intellectual disabilities. The state did one as well, I believe. Then we had it referred out to determine if, I'm trying to think of the name of the agency, if they would in fact take him. APD, thank you. APD did an evaluation as well, and it should be in the court records.
I haven't seen it either. Do you have it?
I have something here from Dr. Sheehan. I don't know if that.
I think that would be it, Your
That's not
Honor.
APD.
That's not APD?
And that was on February 15th. I don't see any.
I believe that would be the February 5th. I think that would be it, Your Honor.
Oh, it does say, okay. Apparently this was the clinic that the APD is using, so let me review that.
What happened to my jail list that I had over here? Oh, here it is. Nope, that's not it. Jail list, yeah, it's in here, so it's around here somewhere. Unless Lisa took it.
I have to write the date of
Yeah.
and the name of the judge. That's all. Because they send that back.
I have some white out. There we go.
I've had an opportunity to review Dr. Sheehan's evaluation. It does find one area unacceptable, another area questionable, and recommends community training. However, they point out that past community training has been difficult because of lack of showing up and cooperating with family, as I understand it, of getting him to the training sessions. So the recommendation is in custody training if that's available. Educate me, counsel. Is that available in Okaloosa County?
It is, Your Honor.
All right. And state have any comment?
No, Your Honor, I'll agree to whatever the recommendation is from the APD.
And
It's Mr. Sanchez is the one that normally comes out to the jail to conduct the restoration training.
And under the circumstances of the tiebreaker report with APD and their recommendation, I will find that the defendant is incompetent to proceed and in need of competency training that can be provided in the jail setting. And Mr. Sanchez will be ordered to provide that. How long does it typically take? Do you have for review?
We have review every 6 months,
Well, Mr.
but in this particular situation, since it indicates that it might not take as long, we would ask that a review be within 3 months.
Has been in training before, so would you like to have a review in about 2 months, see how that is?
That would be fine, Your Honor.
Acceptable to the state?
No, yes, Your Honor, that is acceptable. However, the misdemeanor prosecutors reached out to me. He does have an open misdemeanor case, 22 MM 3966, and the prosecutor's requesting that we take the same action as to the misdemeanor if the court would have jurisdiction to also declare him, deem him to be incompetent with no objection from the state on that misdemeanor case as well.
Well, once again, I'll ask for your suggestions here. My understanding is the competency issue in county court is problematic.
It is. If he is restored within a certain time period and defense has agreed to continue it, that's fine, but otherwise, they're supposed to enter a dismissal to the charge once he's found incompetent.
And that's understandable. If the court That's the way it
I
is.
have the authority to order that, per se.
I just said I would ask.
There's no problem within the state attorney's office of sharing that information with your prosecutor and with the defense counsel in the PD's office and the county judge to help determine case management.
I'll let them know, Judge.
All right. So under the circumstances, if defense would craft the appropriate order, and I do find the doctor's report persuasive, and so we have a returnable date for a miscellaneous matter in about 2 months. Acceptable, counsel? It's a little over 2 months, but that'll give time to get paperwork out. What time? May 4 at 9 o'clock, and Mr. Sanchez needs to have his report in at least 1 week prior to that. Okay, Mr. Perdue, it'll be Mr. Sanchez coming out to talk to you about stuff you've gone through before. Try to work with him so you can try to get this matter resolved. Thank you, sir.
James Phelan, sorry.
How's that spelled?
It's spelled PH. Your Honor, Mr. Phelan's before the court on 22 CF 2949, 22 CF 2989, 19 CF 2215. We did have an evaluation done by Dr. Zeman. We have submitted a copy to the state. I believe the state is going to be requesting an additional evaluation be done by Dr. McDonald.
That's correct, Your Honor.
Submit the appropriate order.
Yes, Your Honor.
And so in that case, we request continuance 424.
Granted. So there'll be another doctor coming out to talk to you, sir.
Your Honor, the next case is William Pigg, P-I-G-G. He has approximately 5 cases, Your Honor. We are requesting continuance to 424. We're in the process of trying to get him into Phoenix House. If he does get in before then, we will bring it before the court before then.
No objection.
I had 4 cases on this docket. And so, sir, do you have any objection to a continuance?
No, Your Honor.
April 24, 9 o'clock, sir. Your attorney will be in touch.
Soon as to enter your plea then,
Okay, what was the court?
424.
424. Do you know how long it typically takes for like a?
I would imagine within the next week or 2.
No, would the
Well, let's
Okay, I'll see.
worry about that. Let's get Phoenix House nailed down first.
Okay, thank you.
Yeah.
Thank you, Your Honor.
Thank you, sir.
Drake Reese, 22 CF 2435. That's fine. Your Honor, this is Joshua Ramsey before the court. Your Honor, the state has announced a null pros for his new law violation. I believe at this time, they'll be asking the court to enter dismissal to his violations of probation. He would be reinstated back to probation and would go back to being on probation.
That's correct, Your Honor.
It actually be community control.
Or, sorry, community control.
So he was on community control and he's being restored to it?
What Mr. Rivers said. He's on community control until July the 14th of this year, and then has probation to follow until July the 14th of 2024.
So the state has dismissed a new substantive charge and is dismissing the VOP?
Yes, Your Honor, the new charge was the sole basis of the VOP, so the state would ask the court to dismiss the VOPs.
So, Mr. Ramsey, you're being restored to your supervision, which I understand is community control. To be clear, you'll be given credit for the time that you've been in jail toward that time period that you have left on your community control, okay? So, you know what you're supposed to do. You'll be released tonight, go by probation, community control tomorrow morning by 10 a.m.
Sir.
Thank you.
But they're going to talk to you first. Drake Reese? Your Honor, this is Mr. Reese. He's before the court on 22 CF 2435. There is some things missing in discovery, as well as I am requesting an evaluation be done. We are requesting continuance at this time to 424.
No objection.
Reese, do you have any objection, sir? Sir. All right. Defense request to continue granted, April 24, 9 o'clock. Your attorney will be in touch.
We'll be back out. Marlon Reynolds. He's before the court on 22 CF 2617, 19 CF 1553, 20 CF 1432, 21 CF 432. We are requesting a continuance, Your Honor.
No objection.
This is a brand-new case. Yeah, this is this is Gerald.
Yeah.
Gerald Reynolds. That's why I was looking at him funny. This is the wrong Reynolds. I believe, I believe Gerald's set for tomorrow.
You're not,
Marlon.
Marquette?
No, sir.
No, he's Gerald, and I think he's
Marlon,
set for
excuse me.
tomorrow.
Okay.
So if we could bring him back for tomorrow.
Sorry you've had to spend the day here all day, sir. But we'll get you back, and can we get Marquette, excuse me,
Marlon.
Marlon here?
And if y'all would let him know he needs to come back tomorrow, because he's getting out. Samuel Roberts.
By the way, do we have Marlon Reynolds here? Just wanted to be sure.
We are requesting a continuance at this time to 4/24.
Without objection, Your Honor, we'll be in touch with Ms. Rivers.
All right with you, Mr. Roberts?
Sir.
Defense request to continue granted, April 24, 9 o'clock.
Thank you.
Thank you, sir.
I mean, it's, they can bring him tomorrow, and we'll continue him tomorrow.
Yeah, that's a good idea.
Yes. That way, at least he's seen us. Gregory Spears. Donald Robinson, yes. Sorry, I did veer off the sheet. Hello there. Your Honor, I am going to request a continuance for Mr. Robinson. I'd ask to put him on the March 2nd docket. Maybe we can resolve it then.
That acceptable to the state? Who has Mr. Robinson's case? Donald Robinson.
Ms. Glisson. Robinson, we're going to put him on March 2nd.
Yeah, that's fine.
Sir, you'll be back later
Thursday.
this week on Thursday. Thank you, sir.
Mhm.
And what is Mr. Robinson's status here? Is he, this case has been sitting for some time, it's just awaiting?
No, Your Honor, he just recently was arrested.
See.
One of the charges is a failure to appear.
Got it. Okay, thank you, sir.
Hakeem Smith. Your Honor, we are requesting a continuance to 4/24.
No objection.
Is that all right with you, Mr. Smith? April 24th?
Can I
The
get
attorney
one?
needs time to look into your case to make sure she has everything covered to give you good advice.
Your Honor, we'd like to put it on for 4/24. I did talk to him about coming back out there. He does want to try to resolve it before then, if possible.
All right. Well, so your attorney will be in touch, sir. April 24 will be your next court date. Thank you.
Luke Truder.
How are you?
I'm good. If we could put this on for March 2nd, I just need to talk to the state a little bit more.
We're not gonna, I'm out the 2nd. Can we
You're
do
out the 2nd, sorry, the 6th?
Can we do it the
Yeah,
6th?
March 6th. How about March 6th? We
right,
requested
would you, sir?
continuance to March 6th.
Mr. Tritter, is that acceptable to you?
Yes, sir.
March 6th.
Thank you, sir. God bless you.
That's it. I'll tell you about it.
Okay. Thank you.
Mm-hmm.
Happy birthday.
You too. Ronald Ward.
Sorry, that's okay.
Client's first name, please.
Ronald.
I have 3 cases on the docket.
Yes, Your Honor. And we've reached an agreement in this matter, if I may approach.
All right. Sir, if you'll raise your right hand to be sworn. You swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, sir.
Ronald Ward.
And Mr. Ward, I have a written plea agreement here. I understand that you're pleading in counsel. I don't have a box checked, which is the plea.
No contest, Your Honor.
All right, I'll check that on your behalf. And, sir, I understand you're pleading no contest in case 22-2470 to a violation of probation, and you're also pleading to the 2 counts in case 22 CF 3142 of possession of controlled substance and possession of drug equipment. The state's apparently going to drop case 2347. Is that your understanding?
Yes, sir.
All right. And is this your signature on the written plea agreement?
Yes, Your Honor.
Did you read all this before you signed it?
Yes, Your Honor.
Do you have any questions about anything
No,
in it?
Your Honor.
Do you understand everything in it?
Yes, Your Honor.
Do you understand you're giving up your right to a jury trial as to the new case?
Yes, Your Honor.
You're giving up your right to a violation hearing on the VOP. The rights are pretty much the same with 2 exceptions. Number 1, a VOP just needs proof of guilt by the greater weight of the evidence, a very low burden of proof, while the new case must be proved beyond every reasonable doubt, the highest amount of proof it takes to prove any fact in court. In addition, you'd have the right to a violation hearing, while on the new case, you'd have the right to a jury trial or a judge trial, depending on everybody agreeing to that. In either case, all the other rights are basically the same, but you're giving up all rights whichever apply as to these 2 cases. Do you understand that?
Yes, Your Honor.
You have any questions about that?
No, Your Honor.
And so you understand you're giving up your right to a violation hearing and your right to a trial, giving up all of your trial and hearing rights, giving up your right to appeal whether you're guilty of either of these matters. And but you keep the right to appeal fundamental issues or issues on sentencing errors. And have you had enough time to talk to your attorney about your decision? Are you satisfied with the advice given?
Yes, Your Honor.
Has anyone promised you anything other than what is in your agreement to get you to plead?
No, Your Honor.
Have you been threatened, forced, or made to plead when you don't want to?
No, Your Honor.
And I have a score sheet here which says you score 39.2 total sentence points. Any objection?
No, Your Honor.
And sir, I want you to know that means that if you mess up on the probation that you're going to be on, you could be facing, would likely face at least a minimum state prison sentence.
Yes, Your Honor.
Unless you present mitigation
Yes.
the court finds persuasive. Do you understand that?
Yes, Your Honor.
So the game is changing.
Yes, Your Honor.
All right. Now, tell me what happened here with this drug equipment arrest.
I was guilty, you know.
Were you
I was,
driving? How'd the police contact you?
I was going home, or I was going to stay with my ex-girlfriend.
Were you driving?
Yes, Your Honor.
Why'd you get stopped?
For a headlight.
And it was out?
Yes, sir.
All right. This was driving at night?
Yes, Your Honor.
All right. So how did they end up finding the drugs and the paraphernalia?
It was in the console in a cup.
So they could see it?
Yeah.
Okay, and they did see it?
They seen it?
It was yours?
I admitted to it, yes, Your Honor.
And you were using it for illegal purposes, both the drugs and the
For
paraphernalia?
personal use?
Yeah.
Yeah.
Well, what kind of controlled substance was it?
Methamphetamines?
That's not illegal, like some other
Yeah,
substances
I
are.
know. I've learned my
In addition
lesson.
to that, it's so toxic, sir, that's just foolish to be doing that stuff.
Yes, Your Honor. I've learned my lesson.
You can ruin your health.
Yes, Your
and
Honor.
your life doing that mess.
Well, I'm hoping to straighten my life out. This is a big eye-opener for me, Your Honor.
I hope that is all true.
I got a little girl due in June, so I got to straighten my life up.
It can be a big motivator, but in the end, you need to really do this for yourself and
Yes,
everybody
sir.
else benefits when
Yes,
you
sir.
do right.
Yes, Your Honor.
You understand that?
Yes, Your Honor.
So at this time, I'll find your plea to these matters to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support your plea. And at this time, probation is found guilty of a violation, and your probation will be reinstated for the remainder, and you'll have an additional $100 court costs. And since that's a felony probation, you have the right to a hearing regarding reasonable attorney fees. There's a $50 public defender application fee and a $100 public defender fee. Do you object to whether those are reasonable? Please answer out loud.
No, sir.
I'll find you've waived your right to a reasonable attorney fee hearing. And on the new case, you'll be required to pay $515 in court costs plus a $100 public defender fee, or excuse me, cost of prosecution. Similarly, you'll have another $50 application fee and a $100 public defender fee for the new case. You'll submit to a substance abuse evaluation and complete any recommended counseling on that. You'll do the evaluation within 30 days and start treatment within 30 days of any recommendation. You'll not possess or consume any alcohol or controlled substances without a doctor's prescription, and you'll submit to random urine sampling. You'll perform 25 hours of community service work, and you get credit for time served on the misdemeanor. Now, just counsel, and on the felony count of 22-3142, there will be 12 months of community control concurrent with your reinstated probation. Do you know what community control is, sir?
I have a hint of what it is. It's
hyper-strict probation.
Okay.
The community control officer will require you to check in on a regular basis.
Yes, sir.
They'll come by and check on you at random times. You cannot leave your home except at approved times to go to approved places for approved purposes.
So I like
Can't even go next door to visit your neighbor.
Yeah. Just to call, I got to call in and like say I'm go to work.
He or she will tell you what you got to do to get stuff approved.
Yes, Your Honor.
It'll probably be like a regular report that you'll have to fill out, and you'll do things at that time.
Yes, Your Honor.
You have any questions about that?
No, Your Honor.
Your Honor, there is one additional thing. I did mention it to him, and the state has mentioned it to me. The state would like the condition put in there of no violent contact
Yes, Your
with
Honor.
Brittany Watts.
Yes, Your Honor.
Is that a part of the VOP?
Brittany Watts.
Is that a part of the original probation? How is she involved in these?
It's not, Your
That's
Honor.
the case that was dismissed.
And that's acceptable to incorporate a non-related issue?
As long as it's no violent contact, he says he does agree to that.
You willing to waive any objection to that additional condition since she's not involved in either of the two cases you're
no,
being
Your
sentenced for? All right, without objection and waiving any objection, then I'll require that there only be peaceful contact with, what is her name?
Brittany Watts.
Brittany Watts. Okay, thank you, sir. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Your Honor, the supervision fees waived.
We would request it. Vernon Webb? Your Honor, he will need a moment to sign this. I did provide him with a copy last week at the jail. Any questions?
No questions.
All right, so here it
Questions,
is.
Your Honor.
Going to need to sign it.
Absolutely.
There. That's it. If I may approach, Your Honor?
Also, at this stage of the proceedings, you don't even need to ask. Come on up. All right, sir, if you'll raise your right hand to be sworn, do you swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, speak up loud and clear. State your name, sir.
Vernon Webb.
And Ms. Webb, I understand that you're going to be pleading no contest to 2 cases involving alleged failure of a sex offender to register during a month of your birthday or during every 3rd or 6th month following your birthday or birth month, or failure to respond to address verification.
Yes, sir.
2 different instances of
Yes,
that.
sir. Well, yeah.
I have the written plea agreement here. Is this your signature on that?
Yes, sir.
agreement? And did you have a chance to read all this document?
Yes, I did.
Before you signed it?
Yes, sir.
Do you have any questions about anything in it?
None at all.
Do you understand everything?
I do, sir.
Do you understand that by entering the plea, you're giving up your right to a jury trial as to each of those cases?
Yes, sir.
You're giving up all your jury trial rights are listed in your agreement?
Yes, sir.
You're giving up your right to appeal whether you're guilty of
Yes,
these
sir.
charges, but you keep the right to appeal fundamental issues or issues on sentencing errors.
Everything's good.
Have you had enough time to talk to your attorney about this decision?
Yes, sir.
Are you satisfied with her advice?
Absolutely.
Does anyone promise you anything other than what is in this agreement to get you to plead?
No, sir.
Have you been threatened, forced, or made to plead when you don't want to?
No, sir.
And I have a score sheet here that says you score 87.6 total sentence points. That means that you're supposed to be receiving a recommended minimum sentence of 44.7 months in prison. That number will go up if you violate the supervision you're being offered, because you're being offered a mitigated sentence here. You understand that?
Yes, sir.
And it is highly likely that you would be facing a prison sentence somewhere at a minimum range of roughly 50 months in prison.
Yes, sir.
At a minimum, and possibly more, and depending on what the nature of the violation was. You understand that?
Yes, sir.
Has anyone told you that will not happen?
No, sir.
So, tell me what happened here.
What happened was, sir, I left Indiana at the end of my probation period to move to Florida just to retire. I'm on Social Security. I'll be 70 this year. And I came and registered the same day I got in town, just like I'm supposed to. I've always have. And I have ADHD, and for some reason, it just went right over my head that I was supposed to report back in 6 months. I thought it was just at the end of a year. So the 6 months went by, and then a couple months later, they showed up at my door and arrested, to tell me I was going to be arrested. I just did not comprehend that I was supposed to show up at 6 months.
You apparently did it several 6-month cycles, or
No?
The other one was the jail, when he was released from the jail.
Yeah, it's the same. It was just because I wasn't informed after the first arrest. I wasn't informed that I was still supposed to go register for the 6 month, even though it had long passed.
you've got to go register anytime you're released from custody, and you're going to have to do it again.
Yeah, I just didn't occur to me.
Well, you need to put that somewhere where it's stamped on the wall.
It'll be in my phone. I'll have a reminder. Absolutely, yes, sir.
They've given you all that stuff. Plus, I believe is he subject to electronic monitor?
Yes, sir.
In Lunsford?
Yes, sir.
So, and another thing that you need to be cautioned about, sir, is there could come a time when you could be subject to a civil commitment as a sex offender if you had serious enough violations later time. You understand that?
I'm sure I'm fine with it.
Florida is very strict about sex offender.
It was a very mild. It was a very mild violation.
The point is, it depends on what the future holds.
Right.
That's up to you.
Yes, sir.
Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. And any objection to the score sheet?
No, Your Honor.
Find based on the score sheet, there's a valid basis for mitigation. So at this time, you'll be sentenced to 5 years in the state prison on each case. However, that sentence is suspended in each case, and it's concurrent. That's on the condition that you serve 6 months community control, followed by 3 years probation.
Yes, sir.
During that time, there'll be a GPS device on your leg for the entire 3 years. actually, it's 3.5 years, or is it contemplated that, because typically, community control and probation are mutually exclusive.
Your Honor, we're asking for the 3 years of 3 years of probation with the first 6 months to be on community control as is required by the statute. To register that scores out to DOC, he must be placed on 6 months of community control.
Well, help educate me, maybe I'm a little behind the time, but typically I've found that community control and probation are mutually exclusive. I do one plus the other, or is there a specific requirement that community control be a part of the first 6 months of probation?
No, Your Honor, we had just written it up that way. We can go ahead and just, if it's easier, we can go ahead and say 6 months of community control followed by 2.5 years probation. The contemplation is 3 years.
I
Yes,
just want
sir.
to make sure it's clear, but that's my understanding, that they are two totally different kinds of supervision. I don't want to confuse the records by that complication, so that's the way it'll stand, 6 months followed by 2.5 years. Is that the
Yes, sir. That's our
2.5
request.
years of probation? So it's a total of 3 years to achieve the intended outcome. There'll be $1, is that $1 a month or a
Dollar a
day, or
day.
what is it?
$1 a day, Your Honor.
For the monitor. You'll also pay, is it contemplated, since there were 2 separate cases, there'd be 2 separate costs here?
Yes, Your Honor.
Were you aware of that, sir?
Yes, sir.
As far as court costs, Your Honor, not necessarily for the monitor.
I understand about the court costs here. So it'd be $415 of court costs doubled, plus $100 cost prosecution doubled.
Those are all
And,
doubled?
Sir, you're entitled to a hearing regarding reasonable attorney's fees. Were you arrested on the same date for these 2 offenses?
No, sir.
Okay, so there'd be a $50 application fee per case and a $100 public defender fee, but you're entitled to a hearing about whether those fees are reasonable. Do you need a hearing about whether those fees are reasonable or not?
No.
Right, so find that you've waived your right to reasonable attorney fee hearing and the $50 application fee per case and the $100
Second one
defender
took place
fee per
right here
case
while I
is
was
assessed
finishing
as
up the
well.
first one.
And you think you'd be able to spend, or, by the way, costs of supervision are waived in this agreement. Do you think you'll be able to satisfy these financial obligations
Absolutely.
within the
Yes,
3
sir.
years?
Absolutely.
Are there any other special conditions that I need to announce?
Not from the
You
state,
think-
Your Honor.
well, all right. Sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Remember, as soon as you're released, you got to check in by, and do you understand how strict community control is, by the way?
Basically.
Well, it's a very strict form of supervision. You're going to have to check in on a regular basis as directed by your officer. You're going to not be allowed to leave your home except for approved times to go to approved places for approved purposes. You can't even go next door to visit your next door neighbor.
Okay.
That's how strict it is.
That's fine.
You understand?
Yes, sir.
Okay. Thank you.
Your Honor, GPS is to be attached before he's released from jail.
Correct.
We're taking his out of turn right now?
Hilton Lett. He has no attorney on the docket.
All right. And sir, you're McKelton Lett, is that correct? Did I pronounce your name correctly?
Yes, sir.
All right. And sir, you've got apparently multiple counts of possessing obscene communication or using a computer to seduce or hire a child. Looks like 4 counts of that, plus traveling to meet or use a computer to lure a child and using a two-way communication device. These are all serious felony offenses, and you have the right to an attorney. If you cannot afford one, one will be appointed to assist you. Do you want an attorney to help you on this matter?
Yes, sir.
Can you afford to hire one? You raise your right hand to be sworn, please. Your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? All I'm going to ask you about is your finances. You can put your hand down, sir. Are you employed? Do you have any income right now? No, sir. What's your bond right now? All right. And do you have any big savings or anything like that or investments? Point to public defender.
Or if we may, public defender was previously on this case. And last time we were here, well, we were here for a Nelson hearing on the 5th of January. And Mr. Russell was found to be effective. However, Mr. Lett did not wish Mr. Russell to continue, so he wanted to go pro se. The court did not engage in a FREDA hearing at the time, and it was reset for today.
Well, he's asked for counsel, I've appointed counsel, and at this point, public defender is appointed. Is there anything that needs to be raised by the public defender?
No, sir, I think he's going to qualify, Judge. At this time, we're going to ask for a continuance, because if I recall, the state had added some witnesses right before we're going to ask for continuance.
And Mr. Lett, I'm acquainted with Mr. Russell, as I am with a number of the attorneys here. And please listen to what he has to say. Sometimes he has to be a bearer of bad news, but he'll give you sound advice in the end. Do you have a right to go to trial or not? That's your choice, not his. But he'll tell you what he thinks, and then it's up to you to decide how you want to go forward. Okay?
May I ask you something?
I don't know that I can answer. I'd recommend you talk to Mr. Russell or ask him first.
Judge, Mr. Lett is asking about, he doesn't want me as his public defender, and I told him, you don't get to pick your
So I don't have any authority. I can appoint the public defender's office, and then the public defender decides which of his staff members handle which cases. So I have no authority over that.
I had put in for a new representation. The reason why,
Well,
conflict of interest.
under the circumstances, let me go back here. Is there ever an order entered?
I think it was just entered on the minute sheet, Judge. I don't know if it was written.
When I just had my notes from the 5th.
I feel like I can't go to trial with somebody who ain't trying to work with me. He ain't trying to work with me.
You had that hearing. The judge apparently denied it. I don't see an order to that effect, unless I'm overlooking something. And so if you don't want him, I have no authority to make the public defender assign someone else. So the alternative is to hire a private attorney, if you have the ability to do that, or to represent yourself. I'm going to give you a strong recommendation that, as Mr. Russell, as all the attorneys here, have a lot of cases, as you know from sitting all day today in holding. And so we're trying to move cases and get people's cases resolved. And he would come to you and talk to you to help you prepare the case and give you advice about what you should or should not do.
So how you trying to help me? You talking about 10 years?
Well, sir, he has a legal and ethical obligation to tell you what the state is offering. If it's a part of a plea offer, he cannot withhold that from you, because in the end, you're the one that has to make the decision. He has the ethical duty to tell you that. Every defense lawyer has that obligation. Okay? You might not like to hear it, but he has to tell you. It would be wrong for him to withhold that from you. So, like I said, sometimes lawyers have to be the bearer of bad news, but you get to decide whether to take the offer or not. If you don't, then you can go to trial, and he'll do everything he can to assist you in achieving a good outcome. He can't guarantee a successful outcome, but he'll do everything he can to try to achieve one, because a jury decides the case.
Then he ain't never put me in for a bond, another bond reduction, or
Did you ask him for a bond reduction?
I asked him for everything. So much stuff, bro. How I gotta ask him to do something for me, which he should know what to do for me.
Judge, if I recall correctly, I think he already had a bond hearing. Explained to Mr. Lett.
I've been here 2 years, sir.
I explained to Mr. Lett, unless there was new information, he's not going to get.
I ain't even from here. I've been here 2 years.
I'm not familiar with what the judge's practices are here. Typically, once a bond hearing is held, unless something changes, there's not a basis to renew that. And the passage of time is not necessarily, although we have had the unusual circumstance of COVID being involved, which I presume has impacted this case somewhat, as it has many of the others.
What I'm saying, I feel like I can't go to trial with him, right? That's what I'm saying. I can go to trial, but with him, I don't see if I can't go to trial with him.
Sir, I'm prepared to, if you do not want him to represent you, you do not have to accept his
I
representation.
can't pro se myself.
You can, but I'm going to schedule what's called a Ferretta hearing for Monday, because we've been here all day, and we have a number of other people who need their cases resolved. So Monday, you have what's called a Ferretta hearing, and put that on the docket and notify the assigned judge, please.
What is a Ferretta?
Ferretta, and it means that a hearing to determine if you can represent yourself, which you said you wanted to do. Okay? Because right now, there was a Nelson hearing, and the court's minutes say that the judge would not remove Mr. Russell, found that he was doing a reasonably effective job on your behalf. That's the underlying premise of that ruling.
Excuse me, Your Honor. May I send you the...
Sir, I can't rehear the case that other judge heard, but I can order that you have a Ferretta hearing to see if you can represent yourself, and that'll be Monday morning. Thank you very much. Who's that, please?
Patrick Harrison, Judge.
Judge, I've got 3 or so that they want to call out of order. Mr. Harrison is the first. Judge, I went out Saturday and spoke with Mr. Harrison. On it. Judge, I need to speak with the attorney that had this case before me. Mr. Harrison informed me that he was told that there was a better result coming. We've had a new prosecutor, and we've had a new defense attorney come in. So I just need to check with those 2 individuals and see if we're missing something as a result of the depots that were taken before. I can try to do that before Monday. And then just report to the court at that point. I'm going to suggest, though, that we not send subpoenas on it.
Monday morning, March 6th at 9 o'clock, sir. Hopefully, Mr. Williams can resolve the question you've raised. Thank you, sir.
Judge, Mr. Lindeman's going to be entering a plea this morning. I just have to go over something with him real quick, make sure that
Go ahead. What we have now left? Nothing. 1083.
Madam Prosecutor, that he will get back with the defendant's mother. Would you make that without written consent? He had no contact.
Yeah.
Right, without written consent.
Yes.
Okay. Judge, we have an agreement. The only caveat to it, and I will write it in. is the no contact with the victim should be without written consent. The alleged victim is a friend of the defendant's mother. At some point, they'll want to have contact.
Who's to verify that, to get the written consent?
The
The state or
way I've
probation?
always seen it done and had it done is that it's delivered to probation. If there's any reason why we can't do it that way.
Who notifies, who gives notice to the victim to submit the written request?
I've had it go both ways, Judge, where, he could tell his mother, well, look, I can't be around him unless he says it's okay. Obviously, he's not the contact.
Any recommendation?
Peter, how do you want that?
Right now, it's no contact at all, so if the victim wants contact, usually they'll contact my office, and we'll direct them to write written consent to probation, or they can contact the defense counsel's office as well, usually, one way or the other. But for right now, I have no indication.
There's no affirmative outreach unless the victim raises the issue?
Right, well, it's no contact, that's the answer right now.
But I'm talking about, there are
No,
other
sir.
ways to do that, is,
Correct.
find out if the person wants it.
Unless probation does that, I don't think y'all do it.
I mean, unless the victim, if it went like Mr. Williams said, the victim would come to our office, we would make him sign a notarized statement saying he wishes to have contact with the defendant. And if the court gives us that authority to let that happen, then we would let it happen under those circumstances. We would have a
Yeah,
notarized-
that's getting to step two. My question is, step one, is there, the state's indicating that there's no outreach, it's the victim's responsibility to make the first move.
Yes, Your Honor.
Judge, the only thing that I would ask is that he be allowed to tell his mother, I can't have contact with this gentleman.
Well, his mother's
Oh, that's,
here.
Well, ma'am, then you're hearing this, right?
Yes, sir.
Okay, all right, it's taken care of then, Judge.
Victim does
Yeah.
not.
does the state have any objection to that? It's a third party.
I'm sorry?
Does the state have any objection to that? I don't want
No,
anyone
no
getting
objection,
themselves
Your
into
Honor.
trouble here.
No objection.
All right, without objection, so see where it goes, ma'am.
All right. Hey, that was,
But you cannot have any, until it gets approved by, and you hear it directly from probation that it's been approved.
Yes,
You
sir.
Understand that, sir?
yes, sir, understood. Okay, all right.
He's going to ask you some questions. You need to just answer them truthfully.
Okay, okay. Yeah.
The Spanish speaking. For a different day.
All right, sir, if you'll raise your right hand to be sworn. You swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
And speak up loud and clear. State your name, sir.
Skylar Linderman, Skylar Caleb Linderman.
All right, Mr. Lindeman, I have a written plea agreement here. I understand you're going to be pleading no contest to a lesser included offense of aggravated assault with a deadly weapon. Is that your understanding?
Yes, sir. Yes, sir.
And is this your signature on the plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about it, everything in it?
No, sir,
Anything?
I understand it.
Do you understand everything in it?
Yes, sir.
Do you understand that by entering your plea, you're giving up your right to a jury trial?
Yes, sir.
Giving up all your listed jury trial rights, and you're giving up the right to appeal guilt, but you keep the right to appeal fundamental issues or issues on sentencing errors.
Okay.
Have you had enough time to talk to your attorney about your decision?
I think everything's good. Yes, sir. I'm good.
That's you making that choice, sir, not him. So have you
Yes,
had
sir.
enough time to talk to him?
Yes, sir.
Are you satisfied with his advice?
Yes, sir. Yes, sir.
Does anyone promise you anything other than what is on this agreement to get you to plead?
No,
Have you
sir.
been threatened, forced, or made to plead when you don't want to?
No.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, I have not taken any medication today.
He normally does, Judge, and it's written in the appropriate spot.
What do you take?
I take Zyprexa, I take Celexa, I take Vistaril, and I take
Something else?
Yes, sir.
But it's
Yes,
under
sir.
doctor's supervision.
Yes, sir.
And when did you last take those medications?
My last time taking medication was last night.
Is the fact that you haven't had any today causing you a problem right
No,
now?
sir. I feel great.
Have you
I feel
taken
good.
anything except your prescribed medicine as prescribed?
No, sir. No, sir.
And, all right. So tell me what happened here about this alleged aggravated assault with a deadly weapon.
Well, I panicked, and whenever I called, and I was on the phone, when I called the police, I just wanted to, I was the one who called the police, and I just wanted to I needed help getting him out of there because
Where are we talking about? Whose house were you in?
my mother's house.
Okay, and he was there visiting your mother?
No, my mother, she was doing her Uber driving, and I'm guessing he was supposed to be at work or something. I don't know. He was there at the house, there for a good 3 or 4 hours, and I didn't even know it. And to be honest with you, I was trying to do something else. I was working, raking up somebody's yard for some money. And when I took a break, she asked me if I had taken my medication that day. I said, well, to be honest with you, I forgot. And she told me to take a break and go to my house and take my medication. And I went to do that. And whenever I went in there, I was going in there. Whenever I did realize he was there, I asked him for a cigarette. And for some reason, I have no clue why he started cussing me out and he wanted to fight. And I told him,
Was it normal for him to be in your house?
yes, at the time it was.
And so when he started cussing, what happened?
I
asked
told
him to leave?
Yes, I did. I told him meet me outside because he needs to leave. I didn't say I wanted to fight him, but I did tell him he needs to leave. If he's gonna be violent like that, he needs to leave. Don't be violent towards me like that. I ain't,
So what causes a violent interaction?
It never got physical between the two of us. When we stood off in the front yard, we had a standoff.
So you both left without anything happening?
I left to go get a phone from somebody to call the police because ultimately he assaulted me in the front yard. You know what I mean?
What did he do to do that?
When he came out the back door, he took his shirt off and came around open. I came outside with a weapon to defend myself because I can't take him in the hand. He's way too strong for me. And
What did he do to assault you?
he just ran up on me and he got close. He was closing the distance, and I made him stop closing the distance because I raised my weapon and I told him he better back up.
What kind of weapon did you have?
It was a knife.
So, and how much bigger than you is he?
He's way stronger than me. He can pick me up, throw me. On
that's why
bench
you
press,
took the knife out in the
bench
first
press
place?
wise, I have a shoulder injury and he has no injuries of any sort, and
That's why you took the knife outside?
Yes, sir.
All right. Well, sir, if he was in your
If I didn't
house-
have a shoulder injury, I wouldn't have needed the knife.
Let me finish.
Yes, sir.
If he was in your house and you asked him to leave and he got into an argument with you and he threatened you and wanted to fight you, and you said, let's take it outside, or words to that effect.
Yeah.
And then you armed yourself and went out because you were worried what he might do, and then he comes at you. Was the knife where he could see it?
Yes.
I mean, just when you walked out?
Yes, sir.
He still
I
charges at you.
wasn't hiding. I wasn't trying to hide nothing.
Okay. And he still charges at you.
Yes, sir.
How
He was
close
still charging at me with the knife.
How close did he get?
Within arm's reach. I mean, just right at the point of me having to hurt him.
And that's when he stopped.
That's when he stopped. And he was still, even whenever he stopped closing the distance, he was still standing his ground right there on top of me. You know?
Sir, that may be a defense to this case. If you were doing stuff based with reasonable fear for your safety, and you only brought the knife out there because you were worried he might do just what you say he did, and then he did it, and you didn't stab him, you didn't hit him.
I didn't
do
hurt him,
anything
I
with
didn't.
it, You have a right to defend yourself.
Yes, sir.
Understand that?
Yes, sir.
You have a right to stand your ground in your own house.
Yes, sir.
And under the circumstances, you're giving up that defense by taking this offer. Do you understand that?
Hold on. Hold on.
If everything you say is true,
Yes, sir.
a jury might think you were defending yourself, and you have the right of self-defense.
Yes,
From
yes.
an aggressor, a man who was bigger and aggressive toward you.
I have a shoulder injury, and I have done law library work.
Gotcha.
I got paperwork right here. I'd
Listen
like
to
for
me.
you to read if you don't
Listen to
mind.
me.
Yes, sir.
The point is, you may have a defense. It would be up to a jury. You can present that to a jury to let them decide whether they believed it or not. The
Yes,
state
sir.
has to prove that you are guilty of the crime. You can raise a defense, and the state has to prove that the defense isn't true.
Okay.
But you
Yes.
have a burden to raise the defense in front of a jury. Then they get to decide. Your attorney can't say what the jury would decide. I can't say what the jury would decide. But you have the right to have that trial and let a jury make that decision instead of doing this plea agreement. Okay? That's what this is all about.
Okay.
You can take this agreement if you want. I would think that Mr. Williams may have recommended that you take the agreement. If he didn't, that's fine too, but it's usually a good idea to listen to your attorney's advice. But the point is this, you don't have to take this if you don't want it.
I'd rather take the year of community control.
No, that's the decision that only you can make. He gives you his best
Right.
advice,
Can you
and then
read-
you have to
can-
decide.
Can I hand this to him? There's some law library work
They're
right
not
here.
going to let you approach, but Judge, he's asked that I approach and I provide the,
Doing this, and
I
if he
understand.
wants to present
Okay.
anything, he can do that with the jury.
I can't see his face. It's kind of hard to. I'm trying hard to. I'm trying to understand.
Sir,
what he's
you want to
saying,
take
know?
this offer?
I would say take the year of community control. Yes, sir.
All right.
Yes, sir.
Well, I do want to make sure you understand, part of this is that you get 20 months state prison, but you're getting credit back to February of 2021. So basically, you've served all that time.
Yes, sir.
And unless you got something else holding you in custody, you would get out and you'd be
No,
put
sir.
on community control.
Yes, sir.
Okay?
Yes, sir.
And that's what you want to do?
Yes, sir.
Now, let me mention this to you. Community control is really strict supervision. Have you ever been on probation before?
Yes, sir.
Okay. Well, the point is this is stricter.
Yes, sir.
Your community control officer will tell you to meet with them regularly. There'll be limitations. You cannot leave your house except at approved times to go to approved places for approved reasons.
Sir.
You can't even walk next door to visit your next door neighbor without it being on a schedule.
Yes,
and
sir.
with the probation
Understood.
officer's permission.
Yes,
You
sir.
understand that?
Yes, sir.
Community control officer's permission. You understand that?
Yes, sir.
So you still want to do it?
Yes, sir.
Find your plea to be freely, voluntarily, knowingly, and intelligently made, and there's a sufficient factual basis to support the plea. Here's one other point I want to make to you, sir. Your score sheet says you score the 45.7 total sentence points, so you could be facing a prison sentence if you're not successful on community control.
Yeah, I'm confident I'll be able to complete it.
So I hope that confidence is rewarded. It looks like you'd probably be looking at somewhere in the neighborhood of a minimum of 18 months in prison if you mess up,
Yes, sir.
okay?
Yes, sir.
Could be more,
Yes,
could be
sir.
less, depending on what the judge decides.
18 months ain't much.
And at this time, sir, you'll be adjudicated guilty of the lesser included offense of aggravated assault with a deadly weapon. As a lesser included, you'll be sentenced to 20 months in state prison with credit for time served since February 6, 2021. You'll be placed on 1-year community control. You'll have no contact with Michael, is it Crane? Is that right?
Michael Crane, yes, sir.
Okay. And that's without his written consent provided to probation. And then you'll only have peaceful contact if he does ask for contact. You understand that? Okay. You'll pay $767 in court costs plus $100 cost of prosecution. And you've got a $50 public defender application fee and a $100 public defender fee.
you can talk to probation about it.
Okay.
And,
You need a hearing about whether those fees are reasonable, sir.
what he's asked about, and Judge, and I understand you got to ask him about the hearing. I talked with him about that 2 days ago as well. He's going to some alternative on the court costs. I'll go over it with him again.
He has the right to claim indigence and ask for community service and other things under the law, and that can be a hearing on that, but I have to impose the costs. And, but the question still is, regarding the attorney's fees, you have a right to a hearing about whether the fees requested are reasonable. you need such a hearing, sir?
In a hearing on the question of whether or not the
Kind
public
of-
defender
kind of-
fees, that $100 and the $50
yeah,
application
it's,
that I talked about on Saturday.
yeah. Everything.
Okay with you?
Yeah, I'll pay him. I'll get a job. I'll
And that
pay
you
him.
waive your right to an attorney fee hearing and assess the $50 public defender application fee and the $100 public defender fee.
Yes, sir. Understood.
Continue with any treatment that you're on. You'll not possess any weapons. You'll take medications as prescribed. You'll also submit to a mental health evaluation within 30 days and follow through with any treatment that's recommended.
Yes, sir.
And
Okay.
Counsel, have I overlooked any requirements here?
I don't think so, Judge.
And sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. If you're released later today, Mr. Linderman, listen to me.
Yes, sir.
If you're released later today, you've got to go by the Community Control Office by
Yes, sir.
10 a.m. tomorrow morning.
10 a.m. Yes,
10
sir.
a.m. tomorrow morning.
Yes, sir.
Okay, and check in and call them and let them know. They'll give you information here about what you need to do tonight about calling. Where would you be staying?
At my mother's house. I
What's
can
the
give you-
address?
The address was 137 Panama Drive,
Where? Crestview?
Crestview, Florida. Yes, sir.
Okay. And you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Thanks, sir.
Yes, sir. Thank you.
Request supervision fees be waived, Your Honor.
Yes.
Yeah, it's a key more. Judge, I'm going to ask this case be left on for docket day on Monday. I had some issues. They went on lockdown at the jail for about 5.5 hours yesterday, so I wasn't able to see him, and I need to get out to see him again.
Ms. Moore, you'll be back Monday morning at 9 o'clock. In the meantime, Mr. Williams will be out to talk to you, okay? Thank you, sir. Sorry for your long day here today.
Judge Amos Washington.
Your Honor, Tim Gibbs on behalf of Amos Washington, 21 CF 2413. Judge, we're asking to continue this to the next cycle. We'll be probably getting some mitigation works together. Then speaking with the state on how to try to resolve this as well. So that negotiation is also ongoing.
State have any objection?
No objection, Your Honor.
No, this case has been around a while, but it is a serious matter, so is that acceptable to you, Mr. Washington? Is that all right with you, sir? All right. Is that April 24th is your next day?
Yes, Judge. Thank you.
At 9 o'clock, sir. Thank you. Someone else ready?
We can bring her. It doesn't really matter. Just start bringing them out. Your Honor, Tim Gibbs on behalf of Miss Earlene Gildner, Judge. This is going to be case numbers, excuse me, if I can find them. 23 CF, 17, 19 CF, 34, 35. If I can have just one moment.
Yeah, thank you. I was falling asleep. Oh, here it is.
Judge, we'd like to leave this set on docket day, please.
All right. March 6th, 9 o'clock.
Thank you, Judge.
So you'll be in touch with
We're going to have it. Are we doing ladies? All right. Your Honor, Tim Gibbs on behalf of Ms. Harriet Ash. This is 21 CF 2408. If I can have just one moment, please. So, again, 6 months followed by 6 months jail. Probation. There's the court cost. Please sign right there for me. Come by my office after you get out. We can get you a copy. So you should sign right there for me, please. It might be a well, might not be. Let me approach Your Honor with a written plan and score sheet.
It is snooze. Oh, okay. So it's going to go off.
No objection to that score sheet, Judge.
He's right there. I snoozed it. That's what popped up.
And counsel, is this with or without credit?
This is with credit for time served, Judge. She's got about 17 months or so.
I missed it here. Oops, I overlooked it. All right. So, ma'am, if you will, please raise your right hand to be sworn. You swear affirm the testimony you give will be the truth, the whole
Yes.
truth, and nothing but the truth so help you God?
Yes, Your Honor.
And state your name, please.
Harriet Vanessa Ash.
And Ms. Ash, I have a written plea agreement, and is this your signature on that agreement?
Yes, Your Honor.
Did you read all this document before you signed it?
Yes, Your Honor.
Do you have any questions about anything in it?
No, Your Honor.
Do you understand everything in it?
Yes, Your Honor.
Do you understand that by entering your plea, you're giving up your right to a trial in this case?
Yes, Your Honor.
You're giving up all of your jury trial rights and the right to appeal whether you're guilty, but you keep the right to appeal fundamental issues or issues on sentencing errors. And have you had enough time to talk to your attorney about this decision?
Yes, Your Honor.
Are you satisfied with his advice?
Yes, Your Honor.
Does anyone promise you anything other than what is in this agreement to get you to plead?
No, Your Honor.
Have you been threatened or made to plead when you don't want to?
No, Your Honor.
You had any medicine, drugs, or alcohol in the last 24 hours?
No, Your Honor.
You ever been committed to a mental health facility?
Yes, Your Honor.
How long did you stay?
6 months.
All right. And are you currently under the care of a mental health provider?
Yes, Your
Are you
Honor.
taking prescribed medications?
Yes, Your
And
Honor.
are you taking them as prescribed?
Yes, Your
Have you
Honor.
done that within the last 24 hours?
No, I missed my dose for this morning because I was here.
Okay. And is the fact that you didn't get your morning dosage hurting your ability to know where you are and what you're doing?
No, Your
In the
Honor.
last 24 hours, have you taken anything that was not prescribed for you?
No, Your Honor.
All right. And in looking through your paperwork here, I see that there's a score sheet that says you score 71 total sentence points. And that means a recommended minimum prison sentence of 32.2 months. You're being offered what's called a mitigated sentence here. And if you were to mess it up and come back with a violation, you could get whatever the minimum would be, which would be roughly 38-plus months in prison. Could be more, or it could be less, depending on how the judge views the case and whether you presented any recognized mitigation. At any rate, the point is it's serious, and so it's important that you successfully complete the supervision that's being offered here. Do you understand that?
Yes, Your Honor.
All right. And so, tell me what happened about this grand theft and leaving the scene of an accident.
He let me use his truck and he forgot, I guess. He forgot that he let me use it.
How long
He has short-term memory loss.
How
And
long were
I,
you supposed to use it for?
just to run to the ATM machine, but I got into an accident. So I think he got upset when he saw his truck totaled out.
But he gave you permission to use it?
Yes.
And tell
And
me
we should have
about
been
this.
calling the police to report the accident, but it turned.
You did call the police to report it?
My sister called to report the accident.
Did you stay there at the accident
For
scene?
about 10 minutes. It was a busy intersection, and I wouldn't go across this way. The speeding cars were going this way. I don't know where they went. But I stopped right there by the car wash for about 10 or 15 minutes. Nobody came there, so I went to take the truck back to the
police
owner.
arrive. You got to stay until the police arrive.
Right.
But what happened when you got home?
When I got home from,
Right.
the police arrested me.
Well, you may have a defense to the grand theft charge of grand theft auto. You understand that?
Yes, Your
If you gave
Honor.
me permission, you could let the jury hear that, and they'd have to decide who and what to believe. You understand?
I'd rather successfully finish the year of probation and have it done with, Your Honor.
Well, if you do that, then all that'll happen, but if you mess it up somehow, you could be facing that prison time I talked about. And after today, any objection saying, well, Judge, I really didn't steal the man's car. After today, that's gone. So, you understand that?
Yes, Your Honor.
You want to take this plea offer,
Yes, Your Honor.
knowing the possible consequences if things don't go like you hope they will.
I can do a year of successful, probation successfully, sir.
I'm hopeful about that.
Your Honor, I mean.
All right. This time, then, I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea, and any possible defense to the grand theft charge is voluntarily waived. Any objection to the score sheet?
No, Your Honor.
All right, ma'am, at this time, you'll be adjudicated guilty. You'll be sentenced to 6 months in the county jail with credit for time served. That's to be followed by a 1-year probation. You'll pay $100 cost of prosecution, $415 in court costs, and you're entitled to a hearing regarding reasonable attorney fees. There's asking for a $50 public defender application fee and a $100 public defender fee. Do you think those fees are reasonable?
Yes, Your
Doesn't go to
Honor.
the attorney, it goes to their office for staffing the office with the attorneys.
Yes, Your
Help you
Honor.
in
Yes, Your Honor.
Okay, so you don't need a hearing about that, is that correct?
About the fees?
Yes, ma'am.
No, Your Honor.
All right, find you've waived your right to an attorney fee hearing. I do find that this is a legitimate downward departure and a mitigated sentence, and you'll have to enroll in an anti-theft course within 30 days and successfully complete that. And that's 30 days of your being on probation. You'll also perform 24 hours of community service work. And is there any reason that you can't do that or at a minimum rate of, say, 4 hours a month?
No, I could do it, Your Honor.
Okay, so starting the first day of the first full month after you put on probation, whether that's tomorrow or 2 weeks from now, and then the 1st of April, then you can do it at the minimum rate of 4 hours a month. So you can start earlier, you just can't wait later, and you can't do less than 4 hours a month, starting that first full month that you're on supervision.
Can I do the whole 24 hours in 1 month?
You can do it, more power to you, absolutely. The earlier, the better.
3 days at work, 8 hours.
If you can do it, good for you. It's better to get things done and behind you. That way, there's less to worry about.
Yes, Your Honor.
And you're otherwise waiving cost of supervision.
Yes, Your Honor.
And, ma'am, your advisory right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Your Honor.
Well, they can, period.
Your Honor, Tim Gibbs on behalf of Quentin Allen. This is 18 CF 2718, Judge. We're kind of here more of a status hearing, Your Honor. Last time that we were here, I had filed a motion to dismiss without prejudice under 916.303, stating that because he has been incompetent, found incompetent by the court for over 2 years, that that particular section requires that his case be dismissed without prejudice since he has been found incompetent. The court at that hearing denied the motion and granted the state's motion to appoint a second expert to determine his competency status. The latest report that we received from the Agency for Persons with Disabilities indicates that Mr. Allen is also not restorable, which also brings into considerations regarding whether or not he can be committed and is also held in the jail. I did file a renewed motion last week. It's not, I didn't file a notice of hearing for today, but I did file a renewed motion on that issue regarding the motion to dismiss.
Notice it for hearing and get it before the court properly, with the state having notice.
And Your Honor, in setting this for today's status hearing, we did reach back out to the examiner that was appointed in the order. And his office advised us they are backed up. We tried to facilitate doing the evaluation by Zoom. However, we were advised that by the jail that wouldn't be possible. But we do expect by the end of next month or beginning of April, he'll get the evaluation done. And he said that he would get us a report as soon as possible after he's completed that evaluation. My understanding is Dr. Pritchard has traveled to several counties. So we are working on that and getting that evaluation before the court.
Try to get a scheduled time that accommodates that, but ask them to do what they can here.
I guess, imagine we'll need a next court date if we could leave it on for Monday.
Let's have, all right, but let's have another control date of April 24 to see what's happened with the report if the hearing cannot be set, and find out when that's going to get done.
What I can do is we can go ahead and leave it for 4/24, Judge, and I'll file a notice of hearing on that motion.
Mr. Davis, please reach out to me. I'm in several courtrooms right now, so. Okay, thank you.
You understand, Mr. Allen?
Yes, sir.
You're going to have a little bit longer, and we'll try to get it back in court and see what the judge decides about whether this is going to be over or not.
I'm ready to go. I'm ready, enough of ready to go. I did my time. I'm ready to just.
So we just got to set a
Certain
hearing
things we
date
got
for
to
that motion.
take care of to make sure it's done properly.
Okay. Thank you, sir.
Your Honor, Tim Gibbs on behalf of Marquise Cox. Judge, this is 22 CF 2794. If I can have just one moment with Mr. Cox. All right. So. Is that still what you want to do? Okay. If you would, please. Sign right there for me, please. Sign yes. And if you would, please put today's date. All right. Thank you very much. Your Honor, if I may approach. No objection to the attached score sheet, Judge. Just stand right here before me. Come right. That way you make sure you can talk to the microphones.
Sir, if you raise your right hand to be sworn, do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Marquise Cox.
Mr. Cox, is this your signature on the written plea agreement?
Yes, Your Honor.
All right, did you have a chance to read all that before you signed it?
Yes.
Do you have any questions about anything in it?
Nope, they always answered.
Pardon?
No.
Okay, do you understand everything in it?
Yes.
And so do you understand you're giving up your right to a jury trial by entering a plea of no contest to these three charges?
Yes.
You understand you're giving up all the trial rights that are listed in the agreement?
Yes.
You understand you're giving up the right to appeal whether you're guilty of these charges?
Yes.
However, you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes.
Are you satisfied with the advice given?
Yes.
Anybody promise you anything other than what is on this paper to get you to plead?
No.
Have you been threatened or made to plead when you don't want to?
No.
Had any medicine, drugs, or alcohol in the last 24 hours?
No.
Ever been committed to a mental health facility?
No.
All right. And tell me about damaging people's property. There are 2 counts of criminal mischief causing damage of more than $1,000, and another one of causing damage less than $1,000 but more than $200. So what happened? There are 3 different things that you damaged?
Yes.
What were they?
All cars.
Why did you do it?
I was frustrated. I wasn't on my medication.
You did not take your medication properly?
No.
All right. And you think you did at least $1,000 of damage on 2 of them and between $200 and $1,000 on the 3rd one?
Yes.
Okay. And I'll find your plea at be freely, voluntarily, knowingly, and intelligently made, and there's a sufficient factual basis to support the plea. And I have the score sheet with 13.8 total sentence points that indicates no objection. So at this time, sir, to be adjudicated guilty, you'll be placed on 3 years probation on counts 1 and 2, 1 year probation on count 3 concurrent. You'll be required to pay $415 in court costs plus $100 cost of prosecution fee. You have the right to a hearing regarding reasonable attorney fee. Typically, there's a $50 application fee and a $100 public defender fee requested. Do you need a hearing about whether that is reasonable?
No.
I'll find the restitution is owing and reserve jurisdiction for a reasonable time to determine the amount. You'll submit to a mental health evaluation within 30 days and follow through with any treatment that may be recommended. That includes taking prescribed medication only as prescribed. You'll not take any medications or drink any alcohol without a doctor's prescription. You understand that?
Yes.
You'll have no contact with Ellen, is it Lean?
Yes, Your Honor.
And Denise Diaz and Daniela Seberg. And costs of supervision are waived. Counselor, are there any other requirements here I may have overlooked?
I don't believe so, Judge. Because counts 3 is 12 months and then counts 1 and 2 are 36 months, we'd ask that any outstanding requirements roll over into the longer term of probation.
All right. So ordered.
Thank you, Judge.
And you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Your Honor.
Cody Bell.
Who's next?
Cody Bell.
Your Honor, Tim Gibbs on behalf of Cody Bell, 22 CF 2079, if I can have just one moment.
Look, she showed me how much.
Your Honor, we got a new offer from the state on this case. He does want some time to think about it, so we'd like to continue this case if possible. I was going to put him on Monday. He'd like to have a little bit more time than that if we could put this on April 24th for pretrial.
Sure you want that much time, sir?
Yes, sir.
About it?
Yes, sir.
State have any objection?
No, Your Honor.
April 24, 9 o'clock. Your attorney will be in touch, sir.
Thank you.
Your Honor, Tim Gibbs on behalf of Landon Blair, 22 CF 3198, 21 CF 2622. Can I have just one moment?
Wait a minute. I only have one of the cases on the docket.
Correct. 21 CF 2622, Judge, is actually currently in mental health court. He did get rescheduled for, I believe, March 15th, if I'm not mistaken. I have actually spoken with the coordinator, Ms. Adams, with mental health court. She's indicated that he will soon be removed from that program back onto our docket due to the new charge that he's received.
Not here yet, so.
We have reached an agreement, I believe. I just wanted to go over those terms with him. Yeah, at most, you do 1129. At most, minus any credit you have, minus any game time you get. Yeah, you may end up serving less than that, yes. Okay. Yeah. All right. So sign right there. Today's date is. I think I actually signed this. Well, if I can find the correct page. No, this removes you from mental health court. Okay. So, you won't have to go back. I won't have to come back to no court? No, you'll be done after. Written plan and score sheet, Your Honor, no objection to the score sheet. Downward departure, plea, Judge.
All right, sir, if you raise your right hand to be sworn, you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
And counsel, since we don't have that other case on the docket, I'm just wondering whether there's any concern about the validity of the VOP taking a plea at this time, since it's still assigned to another section of the court.
It is assigned to a county court judge. I believe this court would still have the ability and the jurisdiction to take that.
I'm not disputing that. The issue is the timing. I mean, if it's still in that court, there has not been a formal determination of basically terminating that proceeding.
I understand, and I understand the court's concern, and I can try to confirm with that court, that specialty court, the status before we actually do take a plea in this court.
I think that'd be appropriate. And,
Understood.
let me just inquire, do you have an idea about,
I believe his next court date in that program, Judge, is March 15th. I believe we do have a later date in March, I believe March 30th. That's a status date that we could probably put him on to ensure that if he is indeed going to be out of that program, he is put back on our regular docket.
how much credit does he have right now as to this case?
In the most recent case, Judge, he was arrested in November, or he was arrested in December, I believe, after a November warrant.
So his jail time would be a while before that would be up regardless. Yeah, I think it's more appropriate to let the processes be clearly resolved, so.
Understood. I appreciate that.
Do you want it for March 30th then?
Yes, if we could set it for March 30th.
Is that acceptable to the state?
Yes, Your Honor, it
9
is.
o'clock?
That's fine, Judge. Thank you.
Are there just some technical things we need to get resolved to make sure it's done properly?
Yes, sir.
Thank you.
So, yeah.
It's without prejudice to calling it up earlier if you have an opportunity. And
Thank you, Judge.
resolve.
So, because you do actually have another mental health court date, so if that's
I get time to turn on that.
you're still building credit, yeah. So you're still getting all the credit. So go ahead and head back, and I'll see you another time. Your Honor, Tim Gibbs for Mr. Blocker in 22 CF 1710, 22 CF 2879. We're working on getting some defense information, Judge, some defense evidence, Judge. I'd ask to continue this case for now.
No objection. No
Locker, is that
objection.
all right with you?
Yes, sir.
Defense request to be granted April 24, 9 o'clock.
Thank you. All right, welcome to see you. Your Honor, Tim Gibbs for Mason Brand, 19 CF 278, 20 CF 2004, 22 CF 3087. If I may have just one moment. Written plea and score sheet, Judge, no objection to that score sheet.
Sir, if you raise your right hand to be sworn, do you swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, sir.
Mason Brand.
And Mr. Brand, I have a written plea agreement here regarding pleading no contest to 2 cases where there are violations of probation and a new case of aggravated stalking. And was your signature on that plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
Do you understand that by entering the plea, you're giving up your right to a jury trial on the new case?
Yes, sir.
You're giving up your right to a violation hearing on those 2 violation cases?
Yes, sir.
There's basically the same with a couple of exceptions. Number one, the state has to prove guilt for the VOP by just the greater weight of the evidence. That's a very low burden of proof. While in the new case, the state would have to prove guilt beyond every reasonable doubt. That's the highest amount of proof it takes to prove any fact in the court system. In the VOP, you'd have a judge hearing. In the new case, you'd have a trial, either a judge or a jury trial, depending on whether everybody could agree to a judge trial or not. Otherwise, the rights are pretty much the same. Do you understand all that?
Yes, sir.
Regardless of which rights apply, you're giving up all of your trial and hearing rights by entering this plea, and you're giving up the right to appeal whether you're guilty of these matters, but you keep the right to appeal fundamental issues or issues on sentencing errors. And have you had enough time to talk to your attorney about your decision?
Yes, sir.
Are you satisfied with the advice given?
Yes, sir.
Has anyone promised you anything other than what is on your paperwork to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
And tell me what happened about this aggravated stalking thing.
Basically, me and a coworker had a disagreement, and I ended up leaving to go back to the workshop where we were at, and then I ended up coming back looking for him because I wanted to talk to him, but I had came back, and then I had asked about where his whereabouts were, and he was across the street hiding, apparently, and that was it. I ran across the street to try to talk to him, but after that,
So you
I left.
informed on 2 occasions,
Yes, sir.
just to talk to him about what was going on.
Yes, sir.
And, sir, there may be a defense to that. If you weren't repeatedly coming after him and threatening him and doing things that normally are involved in allegations of stalking, you might have a defense to this charge. You understand that?
Yes, sir.
Are there any other violations of a technical nature in the VOPs or just the new charge?
I believe it is just the new charge. Yes, the new charge only, Judge.
So there is a possibility that a jury could find you not guilty because of the high burden of proof, but the court could find you guilty of violating your probation anyway.
Yes, sir.
Those are 2 different things. You understand that?
Yes, sir.
So the point remains the same. Are you willing to give up any possible defenses by entering this plea?
Yes, sir.
You think that's best?
Yes, sir.
I'll find your plea on these matters to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. Any objection to the score sheet with 40.8 total sentence points?
No objection, Judge.
And, sir, under the circumstances here, I want you to understand that actually it's with the supervision points added on, it's 52.8 total sentence points. So, sir, another matter here is the fact that if you were sentenced according to the criminal punishment code, you'd get 18.6 months in prison at this point. But the state's offering what amounts to a mitigated sentence. You understand that?
Yes, sir.
And if you mess up the opportunity here and you come back on any of the supervision that's being offered, actually it's jail time. So you're going to do the full amount of that time. You understand that?
Yes, sir.
And that's about a year in jail.
Yes, sir.
All right. And there is a possibility that you might have to spend a little bit longer in jail because of the different credit applying to the different cases. You understand that? The jail credit?
Believe it calls, yes, it's a concurrent sentence, Judge. He's been in jail most recently, I believe, for the last couple months. So that credit will certainly be applied. That's effectively the controlling credit.
Right. But the point is that with the added credit that he has on the two VOP cases, he may end up, after the year expires on them, doing his year on the new case that keeps him in jail just a little bit longer. The point is he won't do more than a year max from when you were arrested on the new case.
Yes, sir.
And actually, you'll probably get out earlier because of gain time, which I can't comment on, other than if you earn it, you get it.
Yes, sir.
You understand that? So it's important that you behave yourself while in custody. It's to your benefit. So at this time, sir, you'll be find you guilty of violating your probations. Your probations will be revoked. You'll be adjudicated guilty of those matters and of the new charge. You'll be sentenced to 11 months, 29 days in the Okaloosa County Jail with credit for time served. That is concurrent on each case. You'll be required to spend or pay $300 cost of prosecution for the three cases. You'll pay one $415 cost of supervision matter for the new case. Excuse me, that's a court cost for the new case. You'll also pay a $50 application fee and a $100 attorney fee for the three different cases. Yeah, but you're entitled to a hearing about whether that's reasonable. Do you object to whether that's reasonable?
No, sir.
Okay, I'll find that you've waived your right to an attorney fee hearing. And okay, so I misread this matter. The sentence is only as to the new case, and essentially the agreement is to revoke and terminate the probations. Is that the state's offer?
Yes, Your Honor.
Cancel that as to the two probation matters. As far as any additional sentence, those are effectively revoked and terminated today. But there are added fees and costs as to those matters as stated. And, sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Thank you, sir.
Good luck.
Outstanding monies are going to collections, is that the plan?
Yes, Your Honor.
It'll be imposed as a lien or go to collections, however you do it here.
Mr. Brown. Your Honor, Timothy Brown, Tim Gibbs on his behalf, 22 CF 2696, 21 CF 974, if I can have just one moment.
People left now. I asked for an estimate last time, so. Bad question.
Are you serious?
After this, gentlemen, I'm going to take about 5 minutes for a relief break.
Yes, sir. have the written plea and a score sheet. No objection to that score sheet, Judge.
All right, sir. If you'll raise your right hand to be sworn, you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, please speak up loud and clear. State your name, sir.
Timothy Wayne Brown.
And Mr. Brown, I understand you're pleading no contest to a new charge of possession of firearm as a convicted felon and a violation of probation. Is that your understanding?
Yes, sir.
And is this your signature on the plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
You understand that by entering your plea, you're giving up your right to a violation hearing and a trial as to the new cases?
Yes, sir.
At the violation hearing, the state would have to prove guilt by the greater weight of the evidence. At the trial, they'd have to prove guilt beyond every reasonable doubt. And the violation hearing would be in front of a judge, while the trial would be either a judge or a jury trial, depending on what you requested and whether the state could agree to a judge trial or not. And do you have any questions about those matters?
No, sir.
Do you understand whatever rights apply here, you're giving up all of your trial or hearing rights, you're giving up the right to appeal guilt if you were found guilty, but you keep the right to appeal fundamental issues or issues on sentencing errors.
Yes, sir.
Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Satisfied with the advice given?
Yes, sir.
Any promises besides what's on the document?
No, sir.
Have you threatened or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
Tell me about having a firearm as a convicted felon.
Sir?
Tell me about having a firearm as a convicted felon.
He
You had
wants you to
one?
explain, he wants you to explain the allegations.
How did the police find that you had a firearm?
Yes, sir.
How did they find it?
They never did find it.
Well, did you have one?
No, sir.
All right. So is there any other violation here besides the new charge? Okay. Well, sir, you're charged with possession of firearm as a convicted felon. The state would have to prove that, both facts, beyond a reasonable doubt. And you have the right to a trial that would basically decide the issue about whether or not you were in fact in possession of a firearm. And then what's called a bifurcated proceeding, it would be only then would a jury find out what you'd been convicted of before, unless you chose to testify. And if you testified in the original trial, all they could ask you about was, have you ever been convicted of a crime before? You know.
Okay.
And so it'd probably be to your benefit not to testify, but that would be up to you. You could testify or not.
Okay.
You understand all that?
Yes, sir.
So you're saying that they never found a firearm, you didn't have one, so you have the right to that hearing, and they'd have to prove it beyond every reasonable doubt. So the question is, do you want to go forward with this plea agreement or not?
No, sir.
You don't want to?
No, sir.
You don't have to. There's no obligation to. Reject the offer. Leave it set for March 6th and trial, the next trial cycle.
I mean, what is that?
Your Honor,
So
if I may,
if you don't want to accept the plea.
this offer was extended for today only and not to postpone it. So if he doesn't want to take it, it's revoked and
I'll take it.
Do you want to waive your right to a jury trial and not require the state to prove the charges against you?
Yeah.
Okay. Accept the offer today.
Yes. Yes.
Which is it, sir? You've told me two different things.
I'll just take the offer today.
You understand that if you did not take it, you have no obligation to take it.
Yes,
But if you did not take it, the offer's gone after today.
I understand.
So this makes a difference for you?
Yes,
You think it's in your best interest to take this plea?
yes, sir.
You think that, okay. I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea, and any possible defense is voluntarily waived. And I have a score sheet with 30.6 total sentence points. Any objection?
No objection, Judge.
All right, sir, at this time, I'll find you guilty of violating your probation. Your probation is revoked, and will be requiring that you pay a $50 cost of prosecution and a $50 public defender fee for this matter. You're entitled to a hearing of whether that attorney fee is reasonable. Do you need one?
No, sir.
All right, find you've waived your right to a reasonable attorney fee hearing. Any remaining costs or financial obligations from the VOP are transferred to the new case because the probation is terminated. On the new case, you'll be adjudicated guilty, placed on 3 years probation. You'll be required to pay any remaining things from the 2021 case as previously stated. You'll pay $415 in court costs plus $100 cost of prosecution. There's a $50 application fee and a $100 public defender fee here. Do you need a hearing about reasonable attorney's fees on the new case?
No, sir.
And any costs of supervision are waived. You'll not possess any firearms of any kind, and you'll forfeit all owned firearms. And I've already talked about the other matters from the VOP case being a part of the new probation. Sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. We're going to take a 5-minute break here. I'll use the room here.
Get him. Somebody ask him if we can leave.
Yeah, I had, my plan was as soon as I finished my inmates, I was like, Judge, I did a bunch of waivers, here's their names, thank you very much. I've already talked to all of them, they already know. And also, Judge, I have 2 people.
I don't know why.
Lynn Banks. Well, Lynn Banks, he called both us on Tuesday, so I'm just, I'm gonna see if I can put it on Monday. You know, Davis on the other hand. That's okay.
Trying to ask her to bring all these other people back tomorrow. That's gonna, they gonna be pissed back there.
Oh,
I'm gonna make y'all all go in the meeting. Y'all all go in.
That's a continuance, that's probably a continuance. He's going to DOC, he's getting out. He's getting out. So I got 2 people that I can still do.
I don't know, actually, I could go either way.
No objection, I've got 2 folks that I can.
Carrots.
I'm gonna.
Look, everybody hates me anyway, so just tell them it was my idea. You know, somebody's got to be the designated board around here. It's just going to be me. So.
Yeah.
Come back on, no, I'm not.
Come back tomorrow. Come back tomorrow.
Oh,
That guy was.
yeah, well, I think he may have gotten confused on that. Folks that may have gotten a little confused in his style.
I know. I know.
But I was like, but I'm like.
He wasn't with your guy.
And I'm like, you want to waive your jury trial right? Because the judge is telling you that you may have some defenses. You want to waive that in order to take probation. Like, oh, yeah. Yeah, but I don't blame you. Yeah, I don't blame you. I'm not mad. I ain't mad. I mean, I'm still kind of used to his style on how he does his colloquy.
That's fine.
Let's do it.
All case, please.
Judge, I believe next is going to be Mr. Richard Carpenter. Tim Gibbs on behalf of Richard Carpenter, 22 CF 3090, 22 CF 1727, 22 CF 681. Judge, I'd like to go ahead and leave this for Monday on docket day. We're trying to get some records in his cases that I think we might be able to have by then.
All right. March 6th at 9 o'clock, sir.
Thank you, Judge. Your Honor, Tim Gibbs for Rocky Carter, 23 CF 80, 22 CF 2905, 22 CF 2765, 21 CF 1897. Judge, he has a bond hearing scheduled for tomorrow. I'd like to go ahead and leave him set on that date with all four of these case numbers so we can address that bond hearing.
What time is that hearing?
I believe it's at 9 o'clock, Judge.
Oh, it's tomorrow morning, sir. Sorry you've had a long day today.
I'll be here tomorrow for that.
Yes, sir.
Okay, all right, thank you, Mr.
I'll see you tomorrow. Your Honor, Tim Gibbs on behalf of Jesse Lee Coleman, 22 CF 594. Judge, I don't have a written plea for Mr. Coleman, but he does, I believe, have an offer for an 18.6-month DOC sentence, which is also what he scores in this case. He's indicated that he would like to accept that today.
All right, we have a score sheet available.
I can grab one of Coleman.
Yeah, you can grab it, please. Yes, thank you.
Maybe I don't have a score sheet in the file.
Mr. Gibbs, I'll submit it later.
That's fine.
If it's okay with the
I
court, Your
understand,
Honor.
because I understand that is indeed the score.
What he's pleading to is the score. Yes, Your Honor, I'll provide it.
Trying to find the information. Here it is. Has there been an amended information filed? There's 3 counts: possession of firearm or ammunition or electric weapon as a convicted felon, improper exhibition of a dangerous weapon or firearm, and resisting without. Those charges.
Judge, actually, I do have a copy of a written plea agreement. Judge, there should just be the 1 count of possession of firearm, ammunition, or electric weapon by a convicted felon, 1 count of improper exhibition of a dangerous weapon, which is a first-degree misdemeanor, and resisting officer without violence, a first-degree misdemeanor.
I believe that's what I just said, so.
Sorry.
That's okay.
But yes, I have received a score sheet. I unfortunately just don't have a copy of it in the file. My understanding is that it does compute out to 18.6 months in the Department of Corrections as his presumptive minimum prison sentence. I've seen that. I don't have an objection to that score sheet, nor objection to Ms. Leone submitting that at a later time.
All right. Sir, if you'll raise your right hand to be sworn. Do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
And state your name, sir.
Jesse Coleman.
And Mr. Coleman, your attorney indicates you wish to plead no contest to these 3 charges. Is that your understanding and agreement?
Yes, sir.
All right, sir, you have the right to a jury trial in this case. At that trial, the state would have to prove guilt beyond every reasonable doubt. You'd have the right to confront or question any witnesses who testified, the right to bring in your own witnesses by court order if they would not come in voluntarily, the right to present any defenses or legal challenges you might have to evidence used against you. You'd also have the right to testify or remain silent during the trial. That's a personal right that you get to decide. No one can do anything other than what you want on that fact. You understand that?
Yes, sir.
And at the end of the trial, if you were found guilty, you'd have the right to appeal. But by entering a plea of no contest, you're basically saying, well, Judge, I'm not contesting this matter, but the court would treat you as guilty. You understand that?
Sir.
You're neither admitting nor denying it, but the court would treat you as guilty. And you're giving up the right to appeal any issues in your case about guilt or innocence. However, you do keep the right to appeal fundamental issues or issues on sentencing errors. And do you have any questions about any of these rights?
No, sir.
Do you understand all these rights? Do you understand you give them all up by entering a plea today? And have you had enough time to talk to your attorney about your decision?
Not really, but I'm okay with it.
Well, you have the time to take up, if you need more time to talk to him, you're welcome to it.
And we can set you for Monday, and I can come talk to you in the jail some more about it if you want.
Yeah, that'll
You'd
work.
rather do that?
You got a written agreement and a written score sheet in the meantime.
Yes, Judge. So
So
if we
it's
could,
basically going to be all this stuff and a little more, and he'll have that all for you, and hopefully you can get the case resolved Monday.
Yes, sir.
Thanks,
so
sir.
for the record, let's withdraw that tender
It
plea.
hasn't been accepted, so it's moot at this point, subject to renewal, if you will.
Thank you, Judge. Corbin? Tim Gibbs for Ronald Corbin, Judge, 22 CF 1821. If I can have just one moment. Let's do what you want to do. Sign it right there for me, please. And then today's date, please. Your Honor, I do have a written plea and a score sheet. No objection to the score sheet. This is a downward departure for a legitimate uncoerced.
Sir, if you'll raise your right hand to be sworn, do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
State your name, sir.
Ronald Lee Corbin.
Mr. Corbin, I have a written plea agreement here that says you want to plead no contest to a charge of failing to register as a sexual offender.
Correct.
And is this your signature?
Yes, it is.
And did you read all this document before you
Yes,
signed?
I did.
Do you have any questions about anything in it?
No, I don't.
You understand everything in it?
Yes.
So do you understand you're giving up your right to a jury trial, all of your jury trial rights, and the right to appeal whether you're guilty of this offense?
Yes.
However, you keep the right to appeal fundamental issues or issues on sentencing errors. And have you had enough time to talk to your attorney about your decision?
Yes, I have.
Are you satisfied with the advice given?
Yes, I am.
And has anyone promised you anything other than what is in the agreement to get you to plead?
No, they have not.
And have you been threatened, forced, or made to plead when you don't want to?
I have not.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No.
Have you ever been committed to a mental health facility?
No.
And you were previously convicted as a sex offender, is that correct?
Yes.
And you knew about all your registration obligations?
Yes.
What happened? Why didn't
I
you?
I made a mistake, that's all. I was just chasing after something, and that was more important to me than what I was supposed to do. And I went back and took care of it, obviously, but there's no excuse.
Sadly, sir, I'm sure you probably think that what was important at that time, considering what you're facing now, was not so important.
Absolutely not.
And here's the challenge for you. You know, you're in a difficult situation with everything, all the restrictions you have because of that prior offense, but it's your affirmative obligation to yourself and your liberty to cross every T and dot every I as a sex offender with registration obligations and everything else, because it's tough enough as it is, and you only make it worse when you don't do the basic stuff you've got to do.
Correct.
I hope you can. At any rate, you have the score sheet and with 94.1 total sentence points. Any objection?
No objection to that score sheet, Judge.
Sir, you understand you're getting a mitigated sentence here. You were supposed to get nearly 50 months in prison, but the state's agreed to offer a lesser sentence. So there's a valid basis for a mitigated sentence in this case with a written plea agreement. At this time, sir, I do find you guilty and you'll be adjudicated guilty. You'll be sentenced to 36 months in the Department of Corrections with credit for time served, and you'll be required to pay, is that $415 in court costs? Is that
Yes,
correct?
Judge.
Plus the $100 cost of prosecution. You also have a $50 public defender application fee and a $100 public defender fee. You're entitled to a hearing about whether those fees are reasonable. Do you need a hearing on that?
No, I do not.
You think they're reasonable?
Yes.
All right, and those are assessed. You've waived your right to a hearing. Those monies will go to collections, and once again, this is a downward departure based on a plea agreement. And, sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Think a little more carefully next time.
Yes, sir. Thank you.
Your Honor, Tim Gibbs for Stephen Creech, 21 CF 2333, 21 CF 2680, 23 CF 87. Judge, I'd like to leave Mr. Creech on docket day. We're still trying to negotiate these out with the state.
All right. And that's all right with you, Mr. Creech?
Well, I was hoping to have it completed today, sir, but
Well, Monday, it'll be back.
Monday?
Right.
Yes, sir. All right, thank you.
March 6th at 9 o'clock.
Yes.
I'll see you in the meantime. Your Honor, Tim Gibbs for Jacob Edge, 20 CF 2646, 20 CF 2650, 19 CF 748. Judge, we'd also like to leave this one for docket day, March 6th. We should also be able to have that wrapped up by then as well.
All right, sir, that'll be this coming Monday at 9 o'clock.
All right. Your Honor, Tim Gibbs for Justin English, 21 CF 2151, 22 CF 3185, if I can have just one moment. Serve on restitution. That's what you want to do. So right here, please. Your Honor, written plea and a score sheet. No objection to the score sheet. We had to edit it a bit due to the nature of the change in one of the charges in the violation case. Instead, it is a lesser included offense.
All right, sir, if you'll raise your right hand to be sworn. You swear affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, sir.
Justin Lloyd English.
Put your hand down, Mr. English. I have a written plea agreement here. I understand you want to plead no contest to your violation of probation, a lesser included offense of the new case of trespass in count 1, and then resisting without violence, criminal mischief under $200, and false name to law enforcement on the remaining counts. Is that your understanding?
Yes, Your Honor.
And is this your signature on the plea agreement?
Yes, it is.
Did you read all this document before you signed it?
Yes, Your Honor.
Do you have any questions about anything in it?
Nope.
You understand everything in it?
Yes, sir.
Now, there's a difference between a violation of probation and a new case. And in the VOP, you'd have the right to a violation hearing where the state would have to prove guilt by the greater weight of the evidence. That would be in front of the judge. That's a very low burden of proof. On the new case, the state would have to prove guilt beyond every reasonable doubt. You'd have the right for a trial on that. That'd be a jury trial or possibly a judge trial if both sides agreed. You understand that?
Yes, sir.
All the other rights are pretty much the same, but you're giving up the right, all the rights by entering this plea as to these matters. You understand that?
Yes, I do.
And if you had enough time to talk to your attorney about your decision, and are you satisfied with his advice? Does anyone promise you anything other than what is in this agreement to get you to plead?
No.
Have you been threatened or made to plead when you don't want to?
No, I haven't.
Had any medicine, drugs, or alcohol in the last 24 hours? Ever been committed to a mental health facility?
No.
So tell me what happened about some trespassing and resisting and doing some damage under $200 and telling the police the wrong name.
Just heat in the moment, just being somewhere that going next door, trying to diffuse a situation going on in my house.
So did you try to, you go into somebody else's property? And did you do any damage there?
I didn't do any damage. I just went to use the stove.
Okay. Did you get their permission?
Prior to that, I had, but at that time, I didn't have any permission to go.
And so was it the stove that got damaged?
No, sir.
What got damaged?
Nothing got damaged.
That you know of?
That I know of. No, I used the key to enter.
Well, you're charged with criminal mischief, which means maliciously damaging some property belonging to another. And you're saying you didn't do it, so you may have a defense on that charge. You understand that? So I gather the police came and you gave them a false name? Why? Because you just made matters a whole lot worse by doing that foolishness.
Yeah, I know I did. Because knowing I was on probation, even though it was the wrong thing to do.
I understand that reluctance, but the point is you just made it worse for yourself by doing that. So, are there any other allegations of violation of probation other than the new law violations?
Not that I'm aware, Judge.
Is the state aware of any?
There's no other allegations on the VOP.
No, yeah.
All right. Sir, at this time, and I've got a score sheet here with, it looks like 30 total sentence points. Sir, I do find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support your plea, and you're waiving a possible defense as to the criminal mischief charge. You understand that?
No, I don't understand.
Well, sir, it's what I talked about with you before. You're accused of damaging somebody else's property, doing less than $200 worth of damage. You say you didn't do it. That's a defense. You can testify about that and say, I didn't do it. And the jury would have to decide whether the state had proved its case or not against you, beyond every reasonable doubt.
Well, I do understand. Yes, sir.
So by taking this plea, you're giving up that possible defense as to the criminal case. Do you understand that? And do you want to do that or not?
I just want to get this case resolved. So.
You're the one that has to make that choice, sir. Your attorney's here to give you his best advice, but in the end, you're the one that pays the price. So it's your choice.
Yes, I do.
So this is the way you want to do it, take the plea and waive the defense.
Waive the defense, yes, sir.
And I find that you freely, voluntarily, knowingly, and intelligently waived your defense on the criminal mischief charge as well. And at this time, going to find you guilty of violating your probation. That probation will be reinstated under the original terms while adding a $100 cost of prosecution for that this proceeding. And you'll have the right to a hearing about reasonable attorney's fees of a $50 application fee and a $100 attorney fee for the VOP. Do you need a hearing about whether those monies are reasonable? You're shaking your head no, so I find that you've waived your right to a reasonable attorney fee hearing. On the new case, you'll be placed on 12 months probation on counts 1, 2, and 4, 6 months probation on count 3. Those will be concurrent with each other. You'll be required to pay an additional $50 cost of prosecution, plus $220 in court costs, a $50 PD fee on that matter as well. Costs of supervision are waived, and any of the outstanding requirements on the new case, they roll over into the larger probation, or whichever one is larger. The requirements will roll over to the longer probation.
Thank you, Judge.
Sir, your advisory right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Judge.
Thank you.
So you'll get fingerprinted, then you'll meet with probation. We got Fleming next morning. Your Honor, Tim Gibbs on behalf of David Fleming, 22 CF 2891. Judge, I believe we reached an agreement if I have this one moment. She's going to dismiss those two counts. This is what you want to do? Yeah. And then today's date, please, 2/27. Written plan score sheet, Your Honor. No objection to the score sheet. Edit it. Two of the counts are being dismissed. Subtract those points.
If you raise your right hand to be sworn, you
Yes, sir.
swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, sir.
It's David Fleming.
Mr. Fleming, I have a written plea agreement. I understand you're pleading no contest to count one, a charge of possession of a short-barreled shotgun.
Yes, sir.
And I have the written plea agreement here. Is this your signature?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
You understand everything in it?
Yes, sir.
You understand that by entering your plea, you're giving up your right to a jury trial, all the listed jury trial rights, and the right to appeal guilt.
Yes, sir.
However, you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Sir.
Satisfied with the advice given?
Yes, sir.
Anyone promise you anything other than what's on this agreement to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
Sir?
Have you been threatened or made to
Oh,
plead
no,
when
sir.
you don't want to?
No, sir.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Or been committed to a mental health facility?
No, sir.
And tell me what happened about having a short-barreled shotgun.
What happened?
Yes, sir.
It was in a rental car that I was in.
Was it yours?
It was under the seat.
Did you know it was there?
No, sir, not until it slid out.
Well, it slid out.
Yes,
When was
sir.
that?
Sir?
When was that?
During the track stop.
Okay. Up until that moment, you had no idea it was there? You never handled it?
No, well, I've handled that one before, but I didn't know it was in the car.
Well, whose was it?
I'm not sure. It was in the same house I was in.
All right. And whose car were you driving?
It was, I can't remember her name. It was, I left with my girlfriend that.
Well, here's the point.
I was in the back seat.
If, under the circumstances, if you did not know the shotgun was there until it slid out from under the seat, and by the way, how did the police find it anyway? How did you get stopped?
They pulled us over for a traffic stop for not stopping at a stop sign, I think.
And did you fail to stop at a stop sign?
I thought she stopped. I was in the back seat. I wasn't really paying that much attention.
So you weren't driving? But
No, sir.
the point
Yeah, I
is you
wasn't
thought
driving.
she stopped. Is that
Yes.
right?
Sir?
You thought she stopped?
Yes,
is that
sir.
right? Well, you might have a legal issue here about the validity of the stop, and then you might have a legal defense regarding the possession, because it has to be actual or constructive possession. And just being in the vicinity of it doesn't make you guilty necessarily. It's up to a
Right.
jury to decide all that.
Well,
How long was it?
It was short.
So you think it was under the legal limit? I think that's about, what, 18 inches? Right.
It was around that. I'm not sure how long it was.
Depending on whether it qualifies or not, that might be another issue you could raise at trial if it did not qualify, or it might be subject to a motion.
Right.
So the point is, you're maybe giving up some legal issues here by taking this offer. Do you
Yes.
understand that?
Yes, sir.
And you'll not be heard to complain later on if you mess up on this probation.
Yes, sir.
Go off to jail or prison.
Yes, sir.
Okay, after today, that's gone.
Okay, yes, sir.
This is how you want to handle your case?
Yes, sir.
I find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. Any possible defenses or legal issues are voluntarily waived. How does the state want to proceed on counts 2 and 3?
Dismissing count 2 and 3, Your Honor.
All right, they're null pros. And I have a score sheet with 34.4 total sentence points.
No objection.
And, all right, sir, at this time, you'll be adjudicated guilty, and you'll be placed on 2 years probation. Condition of that supervision is that you'll pay $415 in court costs, plus a $100 cost of prosecution. In addition, you have a $50 public defender application fee and a $100 public defender fee, but those fees are subject to a hearing about whether you think they're reasonable. Do you think that you need a hearing about whether those fees are reasonable?
No, sir.
All right, I'll find you waived your right to that hearing. And so they will be assessed. Costs of supervision are waived. You'll not possess any firearms, obviously, as a convicted felon, and you'll surrender any firearms that may be owned. And sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Yes, sir.
Your Honor, I believe next is going to be Mr. Cutter Ford. Judge Tim Gibbs on behalf of Cutter Ford, 22 CF 1928. Your Honor, we're waiting on an evaluation from the Agency for Persons with Disabilities for Mr. Ford. That order was signed several months ago, I believe 3 or 4 months ago. We have not received an evaluation from the agency. It's well outstanding. That's prejudice. I believe prejudicing Mr. Ford. I'd like to leave him on for docket day to see if we can't get in touch with APD to see where the status is on that evaluation being made.
Has anyone considered filing for any relief in that regard, directed toward the agency, if they're not complying with their legal obligations?
That's part of the consideration, Judge. That's part of the request for the continuance.
Sitting in jail when that might not be necessary, so I think that some other things might be appropriate to consider. So, March the 6th at 9 o'clock.
Thank you, Judge.
We'll be back on Monday morning. Hopefully, we can get things worked out.
Yeah, I'll come try to talk to you anytime. Judge, I had several clients as well where I had filed waivers of appearance on their behalf
All right.
with the intention to continue them.
All right.
Does the court need those names for the record so that we can get those minute sheets completed?
Done with all the inmates? Let's go ahead and get a couple while we're getting another inmate out.
I'm sorry, Your Honor?
We're trying to get rid of the, get the cases of the
Understood.
people who are here resolved and
Very well.
people who are not taken up last. So let's go out and Mr.
Williams? Yes. Judge, this is Ms. Heidel. We got an evaluation back on her. She was determined to be incompetent, so we need to set her for a competency hearing.
How many evaluations have there been?
Just the one.
Has the state intend
Followed
to
the
do anything?
evaluation. Have you seen the evaluation yet? My understanding was that we filed it.
What's the name, Mr. Williams?
Heidel. And I guess the question is, do you want to set it for, or do you want to have your own evaluation done as well?
I need to review it, Mr. Williams, so if you want to set it for March 6th, I'll have time to do that.
When would that report have been filed, sir?
Judge, I think we just got it on Friday.
It's not in the court's docket
Court's
yet.
file yet?
See it.
So did she already get it set for then, I guess? Okay, apparently she set it for a hearing but hasn't filed the actual evaluation.
The notice of confidential filing discusses a report from Dr. McDonald dated February 23rd, but the report is not in the file.
All right, Judge. I don't know if it would show up with it as a confidential, but I'll get a copy of it over to the state so they can decide if they need a second expert.
Let me double check here because there's a response to a demand for discovery. Here it is. It's actually, it's filed under a response for demand for reciprocal discovery. It was filed on March 26th. Excuse me, February 26th.
Yesterday, yes.
So it is in the court file.
All right, thank you, Judge. Judge, I don't know that Ms. Heidel needs to be brought in on Monday if all we're doing is finding out if the state wants a second evaluation. I'm going to be here anyway, so I don't have, obviously I'm going to be here.
How would you propose to proceed if the state waives the right to another evaluation?
Well, that's why we set it for a hearing. The court has to make its own independent determination. We can stipulate to the evaluations, and that's what seems to happen commonly over here. If the idea is that perhaps by Monday, the judge on Monday would go ahead and make the determination, we cancel the competency hearing, we could do it that way as well. I'm fine with
I'm fine to set it for Monday.
that. Okay. We'll just leave it on for Monday then.
And you'll be back Monday, ma'am. Hopefully we can move things forward.
I don't want to cancel it. Are you here for Monday or, okay. I don't want to cancel it for Monday.
That's fine. For the set, I'll have enough time before the second, Your Honor.
All right, well, we'll just leave it at 2nd of March. I'm sorry. It's been a long day.
Sure has.
All right, we'll do it on 3-2.
Heather Kelly next, Judge.
Judge, give me just a minute. I got a new offer literally about 10 minutes ago.
Counsel, considering a suggestion that was made earlier, and go ahead and talk to your client. Considering a suggestion that was made earlier, we have a lot of cases on the docket that either there were waivers that hadn't been discussed yet or failure to appear. And in looking at the docket for tomorrow, there are 105 cases on that docket total. So I was wondering if anyone had any thinking about moving cases where there were failures to appear until tomorrow morning or tomorrow.
That's fine, Judge. Just
That's fine,
let
yeah.
us know which ones and we'll bring them
Although
tomorrow.
if there are waivers and we can get those continued as of
Absolutely.
today,
Yes.
Yeah.
might make it easier for everybody. How does that work for you ladies about getting those cases back for tomorrow? And tonight on doing this stuff?
If it has to go.
All right, Judge, a new offer's been made that she'd like to accept. I need to finish writing that up
Go ahead.
and go over it with her.
Can we call up another case for some other counsel while you're doing that?
That's what I'm thinking. Let's call the one other female that they have at bat.
She
And
has a seat at the table there while he's doing that. Would that be acceptable?
He's the only counsel that's left.
Oh,
I have 2 folks that we haven't addressed as well as my waivers.
let's go ahead and deal with the ones we haven't addressed and, well, Mr. Williams tries to take care of his business.
just sit right there, just take a second to finish writing it.
I'll be right behind.
Your Honor, if I may, the first person we haven't addressed on my list today, Judge, is Lynn Banks. There was not a waiver on file. He contacted my office this morning. I believe he also contacted the state attorney's office, indicating that he his ride fell through, he wasn't able to get here. I'd like to just leave him on for Monday if the court would be so inclined to excuse his appearance today.
All right, Monday. And
Thank you,
notify
Judge.
the bondsman for Monday as well.
Thank you. The next person, Judge, that I have not addressed that does not have a waiver is going to be Mr. John Davis. His case number is, if I can get to the correct page, 21 CF 2282. He is not to be confused with Jonathan Davis. But I did not file a waiver for Mr. John Davis. I have not heard from him. I do not know his whereabouts. There is nobody else in the courtroom.
I'll ask for a capias, Your Honor. It's old case. Is it a VOP, Mr. Gibbs?
It's
This one,
it's still a new law.
It's a new law because it's old, huh?
It's older, yes.
Yeah, from 21. Okay.
And then, Judge, the only other ones that I have are waivers of appearances that were filed.
Hang on one at a time. Everybody's getting tired, and we need to make sure we're trying to do things properly. And on Mr. Davis, is that a new case or a VOP?
It's a new law violation, Judge. It is a bit old.
2021?
Yes, Judge.
Apparently back in 2021, there was a signature bond.
I believe that's correct, Your Honor. There is a waiver of appearance on file, Judge. I will say that that was done by mistake. I meant to file that on Mr. Jonathan Davis's case, hence my caution in confusing the two on the record today.
Well, was your client aware of his obligation to attend today's proceeding? And I understand that puts you in a little bit of a bind, but
I can't answer
refuse to
that.
answer that if you're not able to.
And understood. I can't answer that for sure. I can't answer as to what kind of communication he and I have had, even regarding the case.
And you did file a waiver of appearance for today?
Admittedly, by mistake, I did mean to find it.
It hasn't
file it
been
different.
docketed yet, so you're withdrawing that?
I would, yes.
So do we have any more information on bond? It was a signature bond apparently, and he's been out the whole time? All right. Issue a capias and set bond the amount of $10,000 cash professional, $5,000 per count. Let me just mention, counsel, I'm not going to speak for the judge tomorrow, but you'll have an opportunity to try to contact your client, see if he can show up and.
That would be fine, Your Honor.
Obligation to, or
Yes.
opportunity to try to convince the judge to withdraw the capias if he
Certainly.
shows up.
Certainly.
Yes, no problem.
Okay, next.
The next, Judge, are several clients for whom I have filed waivers of appearance. I'm sorry, Your Honor.
Okay.
Um,
Into it.
I can certainly list those names. The first is Stephen Arp, Cecily Austin.
Just hang on.
Okay.
One at a time for the clerk.
All right.
All right. Well, I don't have them. I've got to check them off my list. So
Okay.
I've got to go down the list. Does the state have any objection to any of these?
No, Your Honor.
So, have you received the list before?
Yes, we have. We provided a list by Mr. Gibbs
Everything's
already.
fine? All right.
Yes.
So ARP granted, April 24.
Thank you, Judge. The next I have is Cecily Austin.
2 cases,
Two case numbers, Judge.
April 24.
Thank you. Camden Barnum.
I'm going to slow down if I'm going too fast. Barnum, April 24.
Thank you. Ariel Bell.
Same date.
Thank you. Harold Benedict.
Going too fast here?
Nope, we're good.
April 24.
Alexander Barrios,
April 24.
Connie Brown Menzies,
April 24.
Brannon Burdette,
April 24.
Timothy Carter,
April 24.
Frederick Carruthers,
April 24.
Candy, I'm sorry, are you okay? Okay. Candy Corsi,
April 24.
Nathan Craig,
April 24.
Jonathan Davis, 22 CF 2802.
April 24.
Thank you, Judge. Make sure we don't, definitely want to make sure we don't get those two mixed up, as I already have. Tierra Demby, there's three case
cases
numbers.
on the docket, all three you're asking for?
Yes, Your Honor.
April 24 for those three cases.
Thank you. Brandon Dykes, two case numbers.
Cases, April 24.
Thank you, Judge. Kelly Ellis,
April 24.
James George, two case numbers. I believe he's in federal custody, Judge.
April 24.
Thomason Tillman, two case numbers.
That's with a T.
His first name does start with a T, Judge.
How about his last name?
Tillman, Tillman.
I want to make sure I was hearing it correctly. See two of them here,
Two case numbers, Judge.
and that's 2135 and 1266.
Correct.
April 24.
Thank you. Adam Truman,
April 24.
thank you. And lastly, Eddie Wilson.
April 24.
Thank you, Judge. I believe that concludes all of my business today.
Yes, sir. Thank you very much.
Thank you.
Okay, do we have any other?
Good job.
Your Honor, I do have one failure to appear, but he's actually in the Escambia County Jail. So I was going to request Andrew Stokes.
The state's position on the matter?
No objection to a defense continuance.
Do we need to put out a capias on the gentleman or not?
No, Your Honor, he's in the Escambia County Jail. I've confirmed that. He's got a VIP hold over there, from what I understand.
All right, so you just need to get an order to transfer, get him over here. Zoom matters. April 24.
And Your Honor, I have 1, 2, 3, 4 people where I filed waivers.
Okay, who are they?
Miguel Robles, 22 CF 1213.
The state received that list from,
Yes, Your Honor, we discussed it, and I have a list.
from Ms. Rivers. All right. That's, what was the name again, please? Robles?
Miguel Robles
Okay. April 24.
and Luis Rosales,
April 24.
Lonnie Strahan,
Two cases.
Two
April
cases.
24.
21 CF 1400, 21 CF 1403. Terry Young, 21 CF 2775. Thank you, Your Honor. I think that's all.
Judge, I have Emmanuel Colley, Colley. Case numbers are 19 CF 2948 and 21 CF 2367. Security informs me that Mr. Colley was transported. He's still in the custody of the jail, but they had to take him back to the jail. I had intended to ask him for a continuance on both cases. I met with Mr. Colley last week and informed him of my plans, and he was okay with it.
April 24.
Thank you, Judge. Good seeing you, Judge. That's all I got.
Also good to see you, sir.
Judge, I have a case where I can announce a null pros. The victim
Okay.
declines to prosecute. It's Marshall Nance, 23 CF 76. State announces the null pros to the case based on victim declination to prosecute.
All right, with the announcement, defendant is discharged on the matter.
We also have Chance Mayberry, who failed to appear earlier, 21 CF 3262.
Ms. Williams kept trying to bring that up, but we were delaying it, so once we get done with this young lady, we can deal with that.
Okay.
How many people we still have in the bag? Let's go, Ms. Williams, with this young lady's case first.
I'm going to recall Heather Kelly, case number 22 CF 2604. Judge, we have a negotiated plea agreement for misdemeanors, so there will not be a score sheet. On it. It's a little difficult for her to.
Right there.
Yes, ma'am. Sign over there in the chair with the shackles on. Okay. Ma'am, do you mind if I date this for you?
Oh, no, sir, go ahead.
Thank you, Judge. Thank you, ma'am.
Ma'am, if you'll raise your right hand to be sworn, please. Do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
And
And Judge, I don't know what the misdemeanor costs are over here, but the clerk will know, and 270?
well, at this time, ma'am, did I already swear you in?
Yes, sir, I do.
State your name, please.
Heather Kelly.
And Ms. Kelly, I understand you're pleading no contest to a lesser included offense of petty theft on count one, and that's a first-degree misdemeanor where you could get up to a year in jail, a year probation, or $1,000 fine. Is that based on a prior conviction or the amount?
It's based on prior convictions, Judge.
She was, yes.
And then you also have pleading to count two of resisting a merchant, count three trespass, not a structure or conveyance. Is that your understanding?
Yes, sir.
All right. And I have the written plea agreement. Is this your signature on that document?
It is, yes, sir.
Did you have a chance to read through it before you signed it?
I did.
Do you have any questions about anything in it? Do you understand everything in it? Do you understand that by entering the plea, you're giving up your right to a jury trial on these charges, giving up all listed jury trial rights and the right to appeal whether you're guilty of this charge? However, you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision? Are you satisfied with the advice given? Anyone promise you anything other than this to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to? Any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
So tell me about stealing some property, resisting a merchant, and trespassing. What happened?
Tell you about what happened. I was, and I put it back, and I was trying to tell him that, but he didn't see that part, and I walked out, and then I had a pack of hangers that I didn't see, and he was like, oh, look, there's something right here, and I was like, I didn't see that, and I walked back in and put it back, and he wanted me to go to the back with him, but I didn't. So I went to my vehicle and left, but then the officer came
All right.
in the parking lot.
And so let me ask, how's the trespassing involved here?
I think she can clear it up for you,
Trespass
Judge.
warrant?
Yes, I was in the parking lot. I gave someone a ride to Walmart, never went inside, and then I guess the person I gave a ride to had a trespassing warrant against them. I mean, I didn't know, and they came out, and then
Did you
that's...
have one against you?
Right, when-
Trespass warning
Uh-huh.
from Walmart?
Uh-huh.
You shouldn't go there, even on their property.
And I thought it was like 6 months. I didn't realize it was a year, but that was my fault.
At any rate, so did you in fact steal anything or try to steal anything? Intend to steal anything?
Mm-hmm.
You did? But then you
Intent.
returned it? You changed your mind
Mm-hmm.
before you left the store?
Yes.
All right. Well, and then what happened with the hangers? They were just an accident? You
Yeah, I
really
didn't.
intend to steal them?
I really didn't see them. I mean, they were like $2. I didn't
Well,
see
you may have a defense on the theft charge if you really changed your mind before you left the store, and then it was just a mistake about the hangers, and you
Mhm.
never intended to do that.
Yeah, and I returned them.
Present that. Might be a hard sell, but you have that possibility. You understand that? Doesn't sound like you have much of a defense on the other matters, however. But to the extent you have any defenses, you give them all up by taking this offer. You understand that? Don't go to Walmart.
I don't want to. Yes, sir.
Have you been sued yet?
Not as
Typically
far as
do.
I know, I don't.
They sue a lot of folks for civil side for trespassing and theft.
Yes, sir.
At any rate, at this time, I find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. You'll have adjudication of guilt withheld. You do 11 months, 90 days of, 11 months, 29 days of probation. You'll pay the $270 of misdemeanor court costs plus $100 cost of prosecution, or is it $50 for a misdemeanor?
$50, Your Honor.
50 instead of 100?
That's my mistake, Judge. It would be $50.
And it's also a $50 application fee and a $50 attorney fee regarding the misdemeanor charges, correct, Mr. Williams?
That's correct, Judge.
All right. So, ma'am, on the attorney's fee issue, it would be a total of $100 with the application fee and the attorney fee, but you're entitled to a hearing about whether those fees are reasonable. Do you need a hearing on that, or do you agree they're reasonable? All right. It's fine, you've waived your right to that hearing, they are assessed. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
And Your Honor, we request the supervision fees be waived, please.
Granted.
Thank you.
Your Honor, I don't have any further business. If I could be excused.
Yes, ma'am. Thank you
Thank
for
you.
your patience today and your diligence.
Misty Leon.
Who's that?
Misty Leon.
Judge, I am going to need to pass this until Monday to talk with Ms. Leon. I was out on the 25th and Saturday, and they didn't bring her down. I went out again Sunday, was told at 10:30 to come back at 1. At 1, I was told to come back at 3. At 3, they were still on lockdown. There'd been some kind of incident, so I wasn't able to see anybody.
Looks like it's going to be Monday morning, ma'am. Okay.
I will come out and see you between now and then.
Thank you.
Hopefully, they'll come off a lockdown at some point.
Yeah, I don't know what's going on. All right, thank you.
All righty, ma'am.
Robert McDonald.
Judge, I'm going to
That's crazy.
I have six cases on the docket for Mr. McDonald.
Yes, sir.
Mr. McDonald has a number of cases. One of them, I think he's representing himself. Point me on that favorable here.
No, I do not.
Okay, all right. He wants to continue to represent himself on that one.
Which one is that?
2348.
Yeah, 22 CF 2648, Judge, it's a failure to
What am I
appear.
doing with it?
On the others, Mr. McDonald,
Feretta hearing and all that done?
Yes, sir.
that's already been, he's been representing himself on it, Judge. I was just offering. Judge, he's another one of the folks that I was trying to see yesterday, so I'm going to ask to pass him till the 3rd, till the 6th, not 6th, till Monday.
Your Honor, I'm sorry, I would like to make clear, the cases are getting old. It would have to be set for either plea or trial on Monday. I'm not continuing any longer.
Although not all of the, sir, are you also going by Bobby?
Yes, fine.
Okay. You had Bert originally? Judge, we've not had, I realize that the cases may have some legs on it, but not with us. He was
Right.
apparently represented by Bert Moore, and
He has been suspended from the practice of law.
Yes, sir, I understand.
So that's where the issues rely, Your Honor. It's not on us, and it's not on the state, it's not on the state, or it's not on the defense. It's on representation, Your Honor.
So how do you want to proceed?
Judge, I still want to go out and talk with him. and have him come in on Monday. I just don't want to obligate myself to go to trial the following week on,
Issues we need to go over.
on like 4 cases that I'm just, I don't know I'm going to be able to.
So when did you pick up the cases?
Let's see.
November 10th.
It's been about 2.5, 3 months.
Yes, sir. Well, originally, Mr., well, it doesn't matter. The Public Defender's Office had it, so it would still be attributable.
What happened, Your
to
Honor, is
me.
I had to let Mr. Moore go because Mr. Moore was not doing anything on October 26th, and I took over the cases. And then I wanted to see discovery, and so therefore, Mr. Williams was issued that for discovery purposes, to look at the discovery, and here we are again today.
Well, under the circumstances, these are getting, one of the cases is almost, nearly 4 years old.
Yes, it is.
2 of them, actually. So, but under the circumstances, with Mr. Williams recently picking it up, set it for Monday. But how do you want to proceed, sir, on the case where you're representing yourself?
I want to continue to represent myself on that, Your Honor. I've already issued notice of discovery, and I filed some court filings within confidential information within the court filings, and 3 subpoenas on that case.
Have you received your discovery?
No, sir, I have not.
Has the state received the notice, the request for?
Yes, yes, sir, they have. Yes, sir, they have. 151 Cedar Avenue's address.
File a copy with the clerk?
Yes, sir.
I can only state that the state has complied with any requests, if there was any. The difficulty that we have another case where an incarcerated person is representing herself, and we cannot share discovery with them, like videos and all of this, it's impossible.
Well, there is a written demand or notice of discovery filed by defendant on January 13.
Yes.
And I'm not seeing a response to that.
There is no response.
You have the right to certainly
Participate.
claim exemptions or maybe have an investigator go out and show it to them. But at any rate, you have the opportunity to respond in an appropriate way to his demand. He is representing himself, and he has the right to a response.
Yes, Your Honor, how about the 19 case where he's represented? We're ready for trial, the state is ready. He's represented in the other cases.
Well, I'm talking about the 22 cases. On the 19 cases, I understand that Mr. Williams is handling all of those, 2019 and 2020 cases. Is that correct, Mr. Williams?
I'm sorry, Judge.
I'm asking you if you're handling all of the 2019 and 2020 cases for Mr. McDonald.
Judge, as far as I know, except for the failure to appear,
Which is the 2022 case.
I'm handling all of his cases.
Those are set for the docket day Monday without subpoenas, since he's fairly new to these cases. You get one more shot, Mr. Williams, try to get it pulled together.
Thank you, Judge.
Monday, Your Honor?
Monday.
All right.
See something real quick. Judge, I went out and saw Mr. Henderson on Saturday, and he advised me of some potential mitigation information. Also, I have requested that he be evaluated. We do that in-house instead of going through a court order. And so I'm going to ask to continue his case so that we can get the reports back on that and decide where we're going.
No objection. No objection, Your Honor.
Mr. Henderson, how about you, sir? granted April 24. Your attorney will be seeing you, sir.
Thank you.
Herbert? Judge, this is Nico Herbert. He's filed a request for a Nelson inquiry. We'll need to set him a hearing date on that.
Counsel, when would you like to have that done?
Um,
Want to do that on the 2nd or the
Second's probably okay, Judge.
State be ready?
Yes, Your Honor, the state is ready.
Herbert, you'll be ready for that on your motion?
Yes, Your Honor.
This Thursday.
May I speak?
Well, sir, you're going to have a hearing on your motion at that time, and the judge will, I will not be here. It'll be another judge that'll resolve that question. So what time is that? 9 o'clock. So, sir, if you're welcome to speak if you like, but I want to caution you, if you say anything about the case, whatever you say might be used against you if it relates to the facts of the case. So what do you need to say?
I just wanted to move towards resolvement. This case had pretty much destroyed my life. And
Has there been an offer made by the state?
I just want to get it over with.
Was that an offer, Mr. Williams, that you know of?
Hang on just 1 second.
I don't know if they
We
seen,
normally,
I guess
do
my time
make
served
offers.
from the capias from when the order was sent out. I guess I'll be able to get time served from my credit.
Let's do it this way.
All right, Judge, I've got a fair amount of medical record in here that
Well, today's Monday, and
move out of the way.
point is if you could look through that file, put a note on it, and make sure you look and see if there is a plea offer. And if one has not been sent by the state, if you can send one to Mr. Williams so he can get it to Mr. Herbert, so Mr. Herbert can make a decision. He may want to withdraw his Nelson motion if there's a reasonable resolution. So if we can get that resolved before Thursday, that would be helpful.
I will have that information for Mr. Williams as soon as I get a chance, Your Honor.
Thank you. And if you find it, Mr. Williams, try to get out and see your client.
Yes, sir,
about that
I will.
Before Thursday.
Thank you so much, Your
Sir.
Honor. You have a blessed day.
Marcus Ingram.
Judge, Mr. Ingram's case is going to be a plea.
3 cases on the docket.
Ingram, please, please.
I just want to clarify, you have no objection in buying out the community service
No,
warranty?
no, no.
Okay. Do you have a score sheet?
Yes, I'll provide it.
I probably have a copy of it.
You gonna give me one, huh?
Give you what?
Score sheet.
No, you and I went over the score
Okay,
sheet
okay.
on Saturday. That's the thing with the points that we were
I got
talking
you,
about.
I got you.
Okay. Judge, I've got it.
If I may, Your Honor, I do have the score, it's 40 points total, so not minimum guidelines. He has it? Okay.
So, sir, while your attorney's getting that for me, let's begin. If you'll raise your right hand to be sworn. You swear firm testimony you give will be the truth, whole truth, and nothing but the truth, self you
Yes,
got?
sir. Yes,
State
sir.
your name, sir.
Marcus Ingle.
And Mr. Ingram, I have a written plea agreement here. It's my understanding that you wish to plead no contest to the 3 cases, 1 case involving abuse of an elderly person without great bodily harm, another case, it's a VOP, apparently a lesser included offense of resisting an officer without violence, and another case of assault on a VOP assault case. So is that your understanding? You're
Yes,
pleading
sir.
to those 3 matters?
Yes, sir.
And is this your signature on the plea agreement?
Yes, sir.
Did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
You understand that by entering the plea, you're giving up your right to a violation hearing on the VOPs?
Yes, sir.
You're giving up your right to a trial, and that'd be a judge or jury trial on the new case.
Yes, sir.
And you're giving up all your other trial rights. Now, there's a difference between those two proceedings. On a VOP, the state only has to prove guilt by the greater weight of the evidence. At the trial on the new case, they'd have to prove guilt beyond every reasonable doubt. And you'd have the right to the hearing with a judge on the VOP or a jury trial or possibly a judge trial on the new case. Otherwise, the rights are virtually the same for all proceedings. But regardless of which rights apply, by entering this plea, you're giving up all rights to these two kinds of proceedings. You understand that?
Yes, sir.
You're giving up your right to trial, your right to a hearing, all your trial or hearing rights, and the right to appeal guilt, but you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Are you satisfied with the advice given?
Yes, sir.
Does anyone promise you anything other than what is in this agreement to get you to plead and what's been added
sir.
on here about buying things out?
No, sir.
Have you been threatened, forced, or made to plead when you don't want to? Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Or been committed to a mental health facility?
No, sir.
So tell me about this abuse of an elderly person without great bodily harm. What happened?
We was
Financial or what?
Nah, we was at watching the game, and her son was antagonizing me down the street, and we had a few words, and I was on outside of the fence, and he took a stick and hit me across my shoulder, and I retaliated and hit him back, and
How old was he?
he's like 50-something. He's my wife's friend.
I think he's got to be over 60, if I recall this.
He's not over 60. He's like in his 50s, late 50s.
Is the age 60 or what?
No.
It's a disabled person, it's not for the age.
Because it does say abuse by elderly, of elderly.
Because I think that's the statute, Your Honor, the gentleman was on a wheelchair.
Well, so there is a different issue for a disabled person. Was he disabled?
Yes, sir.
And you knew that at the time?
Yes, sir.
Well, the point is, you say he hit you first, correct?
Yes, sir.
Did you need to hit him back?
At the time, I was ticked
You had
off,
a
but
fence between you?
yes, sir.
You had a fence between you, as I
Yes,
understand?
sir.
So he wasn't going to come, if you back away,
Yeah.
that's the end of it, right?
Yes, sir.
So you say you were ticked off.
Yes, sir.
You got to control your temper.
Yes, sir.
Okay. And was there any other basis for the violations of probation? Or just the new case?
Yes, Your Honor, you had two new cases, one new case.
Was he injured in any way where he got?
No, Your Honor.
All right, sir. Well, under the circumstances, I'll find your plea to be freely, voluntarily, knowingly, and intelligently made. I don't believe, based on what you said, that there's really any legitimate self-defense issue involved. That's why I made the comment about backing away from the fence. You could have stopped it right there and then called the police and had him arrested where he was in trouble and not you.
Yes, sir.
So think about those things.
Yes, sir, I will.
All right. At any rate, and I have the score sheet here with 37.3 total sentence points. Any objection?
No objection, Judge.
All right, sir, at this time, I find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea, and I don't believe there are any valid defenses here. And under the circumstances, at this time, I find you guilty of violating your probation, and you'll be sentenced to time served on the VOPs. You'll be required to pay an additional $50 cost prosecution case per VOP, and a $50 public defender fee per VOP. And you're entitled to a hearing about attorney's fees issues on the VOP. Do you understand that?
Yes, sir.
Yeah, but that's on the question of whether the fees are reasonable. Do you have any question about $50 per case being reasonable? Those fees are assessed. On the new case, you'll be sentenced to time served followed by 36 months probation with, here we go again. You'll do 6 months of community control followed by 30 months of probation for a total of 36 months, as I understand it.
That's correct.
And I find that restitution is owing, and reserve jurisdiction for a reasonable time to establish an amount. You'll pay $767 in court costs, or are there more considering a disabled adult? All right, just the battery extras are added on? All right. And you pay $100 cost of prosecution. There's a $50 application fee and a $100 fee regarding this case for the public defender. Is that reasonable, sir?
I guess so, sir.
Pardon?
I said, I guess so, sir.
Well, you're the one to tell me. Otherwise, you need to have a hearing on it.
Oh, yes, sir, it's fine.
It's okay?
Yes,
So
sir.
I find you've waived your right to a hearing. You're required to submit to a substance abuse evaluation within 30 days. If any treatment is recommended, you'll sign up for that treatment within 30 days. Excuse me, I'm misreading your thing here. You'll sign up for the evaluation within 30 days and begin treatment within 60 days, if any is recommended. You'll attend and successfully complete an approved anger management class, and you should do that within the first 6 months of your supervision, I would think. You'll be required to perform 50 hours of community service work. Is there any reason you you could do that at a minimum rate of 5 hours per month?
Yes, sir.
You have anything else holding you in custody?
No, sir.
All right, then starting March 1, you'll do it at a minimum rate of 5 hours per month. You can do more, just don't do less, okay, on a monthly basis.
Judge, I believe his intent is to buy it out, so
All right.
that may be why he's kind of
Okay.
hesitating.
You'll have no contact with Thomas Josie. There will be no trespassing at 1124 North Maple Street in Okaloosa County. And it's permitted here that you can buy out your community service work instead of doing the 5 hours a month, and that'll be at minimum wage.
Yes, sir.
Counsel, is there anything I've neglected?
No, sir, I don't believe so.
No, Your Honor.
Sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Excuse me.
And we request the supervision fees be waived, Your Honor?
Yes.
Sorry, paper locking on your name. It's Johnson.
Johnson, yes.
Judge, this is Mr. Johnson. It's actually a 3850. What I had originally suggested a month ago was to leaving on, and we'll see what days maybe are available that we don't use during our trial dates. I went out and saw Mr. Johnson on Saturday and advising what I'm hearing is that we may not have any available trial dates. In that event, he's fine with the case being passed off until the next trial docket. This is going to be for probably a fairly lengthy 3850, Judge. He's filed a 43-some-odd page motion involving a trial that he had with two local attorneys.
And your office is appointed to handle the matter?
That's correct, Judge.
Adopted the motion?
I haven't specifically said I'm adopted the motion. It went to us. The motion was filed before we were appointed, and the court appointed us, felt like he had sufficient grounds.
All right. Mr. Johnson, do you have any questions, sir?
No, sir.
It's a scheduling challenge with a crowded docket. You see how big it's been today.
Definitely.
And everybody's trying to move cases forward, so they'll get to it as quickly as they can. How do you want a control date on it? April 24?
Your Honor, if I may, this keeps coming up on the pretrial and docket day dockets, and since it's a 3850, would it be more appropriate to put it on miscellaneous day?
I would think.
Could we do that, please?
That would be fine, Judge. I don't think it makes a difference for us.
March 30th, was that a miscellaneous day? How about that? Thank you. Yeah, so this is not really the place for that kind of issue to be addressed.
Christopher Jordan.
Judge, this is Christopher Jordan. It's case number 20 CF 2081.
Everybody's signature on the, oh, we don't. Need to get your signature on this. This is what I went over with you. On Saturday, I guess it was. You okay?
Yeah,
If you're not okay and you need more time, you just tell me, okay?
that's close enough. Hell, I know it's my work.
I will. I'm in circle.
Ms. Lowney, do you have a short sheet on this gentleman? If not, I'll go through, and I'm sure I've got one in here. Oh, I had it in my hand 5 seconds ago. What's behind this? Okay.
What, but I got, what's for her? She's got one. Call that for her. Let's go look at her.
You have a plea offer too?
Sorry, Judge, Judge, we had at one point moved to withdrawal, and RCC had been appointed. It appears that the case that created that conflict has been resolved. I can't find it. It involved a witness in an Escambia County case.
At any rate, so, Mr. Jordan, are you ready to proceed with the plea?
Yes, sir.
Raise your right hand to be sworn. You swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, sir.
Christopher Mark Jordan.
And Mr. Jordan, I have the written plea agreement, and is this your signature on that plea agreement?
Yes, sir.
All right, and I understand you're going to plead no contest to a charge of possession of a controlled substance, methamphetamine.
Yes, sir.
And your attorney has indicated that they may have had a prior conflict of interest. It may have been resolved. For the purposes of this hearing, if you want to move forward with this with the assistance of the Public Defender's Office, are you willing to waive any objection to a potential conflict of interest? It sounds like a relatively standard resolution for a case like this.
Yes, sir.
So that's acceptable to you?
Mhm.
Does anyone promise you anything to get you to give up your right to have independent representation?
No, sir.
Conflict-free?
No.
Anybody threatened you or made you
No.
agree to this when you don't want to do it?
No.
Find that you've waived any objection to potential conflict of interest in the Public Defender's Office. And sir, did you read all this plea agreement before you signed it?
No, he was telling me about it the other day when it
Let
come
me go
up.
through it, basically what it says to you. Listen to me while I'm talking to you. You have the right to a jury trial on your case. You're facing up to 5 years in prison, 5 years probation, a $5,000 fine is the legal maximum of these charges. But in this case, if you had a trial, you could have a jury trial. The state would have to prove guilt beyond every reasonable doubt. That's the highest amount of proof it takes to prove any fact in the court system. You'd have the right to confront or question any witnesses who might testify, or your attorney could do that for you. You'd have the right to bring in your own witnesses and make them come to court by court order if they would not come in voluntarily. You'd have the right to present any defenses or any legal challenges you might have to evidence used against you. You'd have the right to either testify or stay silent at your trial That's a choice that's personal to you. Nobody can make you testify if you don't want to. Likewise, no one can prevent you from testifying if you choose, so long as you testify truthfully.
Right on.
All right? And so, do you have any questions about any of those rights?
Oh, what is the, no, not none of my rights. What is the charge what am I getting out of this charge? The 2 year
Getting the
probation?
Probation, that's and
Two.
all the,
Huh?
you're getting the probation along with costs.
Okay, all right. I was just making sure you threw in that 5 year prison term in there and I couldn't understand what that was for, so.
I merely told you what the legal maximum
Oh,
could
okay,
be,
all right, now I understand.
not what you're going to get.
Okay, okay.
What you're going to get is on this paper.
Okay, thank you, sir.
Okay? So, the point is, there'll be other things, including some evaluations. And you can't possess things and submit to testing and that
Right.
sort of thing.
Yeah,
You read about all that?
yes, sir.
Okay, so that's what you're going to get.
Okay,
If
that's
I
right.
take this, if I accept this plea.
Yes, sir.
At any rate, do you have any other questions about it?
No, sir.
So, do you understand you're giving up your right to the trial, all the trial rights, and the right to appeal guilt?
Yes, sir.
But you're giving, you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Are you satisfied with the
Yes.
advice given? Does anyone promise you anything other than what is on this paper to get you to plead?
Right on. I'm good with that.
Have you been promised anything else
No,
except
sir.
what's on
No,
this
sir.
document?
No,
Have you been threatened or made to plead when you don't want to?
no, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
Tell me about getting caught with meth.
I was riding with a girl and, they throwed it up there in the front seat with me when we got pulled over. The black guy there in the back did. And whenever we got out, he pulled me out of the car and caught it with me on this date, you know,
Know
2021.
that the meth was there in the car?
No,
They threw it
he
up there?
throwed it up there to the black guy in the back seat, throwed it up there to me, in the front seat where I was sitting. And, it was right there whenever the officer over here pulled me out of the car, he found it right beside of me. And that's what that's what he.
Did you ever handle it or touch it in any way or do anything with it?
No, sir. It was, he put that little piece in the baggie right there and tested it, and it come up meth. They arrested me and put me in the county jail. They signed me out with R&R bond.
Gotcha. Here's my point, sir. If you did not exercise any control over it, in other words, you weren't in actual or constructive possession of it, as those terms are defined by law, you may have a complete defense in this case. If you didn't know it, you never handled it, you never intended to use it, some other guy just threw it out there where it looked like you might have had it, you could have a defense here that, and a jury would listen to the case, and if they had a reasonable doubt, they should find you not guilty. You
Right.
understand that?
It's too long. I got to get back out and go back to work, Your Honor.
Sir, you have to make that final decision, but I just want to make sure you
Yes, sir.
understand you're waiving or giving up a possible defense, and you're going to be on probation for 2 years. And
I
if
have
by
to be.
some reason you mess it up and you get into trouble, after today, that defense is gone. You know, you
Yes,
could
sir.
face a possible jail or prison sentence
Right on.
if you mess up your probation,
I understand that.
okay? So, but you still want to go ahead and take this plea anyway.
I mean, yeah, 'cause I ain't got time to sit in jail for, another 6 months or something.
That's your
I
decision.
got to
and
get
you
back
have
out
to
of my
make it,
kids,
sir.
Yes,
That's
sir.
what you choose to do?
Yes, sir.
All right. I find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. Any possible defense is voluntarily waived, and I have the score sheet with 26.2 total sentence points. Any objection?
No objection.
All right, sir, at this time, you'll be adjudicated guilty. You'll be placed on 2 years probation. You'll be required to pay $515 in court costs plus $100 cost of prosecution. There's a possible $50 public defender application fee and a $100 public defender fee, but you're entitled to a hearing about whether those fees are reasonable. Do you need a hearing about whether the public defender fees are reasonable?
No, sir. I mean, he's doing his job, so.
I find that you waived your right to that, those fee, or a hearing on those fees.
It's about $1,000.
It's, in addition, you'll be required to submit to a substance or drug or alcohol evaluation and treatment. You'll be required to do the evaluation within 30 days and start the treatment within 60 days after the recommendation. You'll continuously attend and successfully complete the treatment as well as any aftercare. You will not possess or consume any alcohol or controlled substances without a doctor's prescription, and you'll submit to random breath or urine testing.
That's right.
Counselor, are there any other required restrictions here?
Not that I'm aware of, Judge.
All right. Sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Your Honor, Noemi Collazo from State Probation, we ask that cost of supervision.
Granted.
Judge Terrell? Your Honor, I only have one left, but these kind ladies have said they'll cover for me, so may I be excused?
Yes, ma'am.
Thank you.
Thank you for your diligence and patience today.
We'll bill you later.
Okay. Hell yeah.
What's your name?
Your guy's after.
Yesterday, I went up the day before getting your brother. Instead of you. I was out on Saturday. Brought your brother down, and I tried to go out and see you yesterday, and they wound up on lockdown pretty much the whole stinking day. So what I'm going to do is I'm going to pass you until Monday, and I'm going to come out and see you between now and Monday. I've got court tomorrow, so it's probably going to be tomorrow afternoon or like Thursday morning, something like that.
Anything in the works that we'll talk Monday, by Monday?
I can go over everything with you on Monday. I
Well,
really
I know
can't
that
do it
these
here
guys ready to
today.
go home, so-
We're still trying to get you into Phoenix House.
Okay.
Let me rephrase that. They have agreed to take you, but the state has to agree to that as a
She's right
resolution.
here, ain't she?
Yeah, she is, but
Talk to her.
I have.
Okay.
Okay, it's going to involve a bit more convincing.
All right.
9 o'clock, sir. He'll be out to see you in the meantime, hopefully with good news. Yes, sir.
All right. Hey, Mr. Lestrap. Judge, I went out and saw Mr. Lestrap on Saturday, and I'm going to ask to pass his case so that I can have experts appointed.
Think April 24 is a sufficient time?
I believe so, Judge.
Sir, your case will be back on April 24 while you see Mr. Williams in the meantime.
She's here.
Thank you, sir.
Hang on, Mr. Martin.
Hey, how are you?
Judge, Mr. Martinez, I'm sorry, I can't lay my hands on this file. I had it 5 seconds ago. But Mr. Martinez is another one of the fellows in the group from yesterday, and so I'm going to ask to pass him until Monday, and I'll go out and see him between now and then.
He tried to see you, but couldn't get in to see you yesterday, sir, so you'll need time to talk to you about anything about the case. That'll be on-
I do
we'll
have
see
a
you
new
between now
offer
and
for
Monday,
you.
sir.
I'll go over it with you when I go out to the jail, okay?
Okay, sir, okay.
Thank you, sir. So you'll be back in court Monday morning, 9 o'clock.
Your Honor, yes, Monday morning at 9
Yes, sir.
o'clock? Okay. May I speak to you? Okay, can I have a business card? Because they took our Bibles and I don't have your contact info.
Yeah, just a second, I'll get you. Diesel blank.
That's me.
We're running super
Okay,
late
thank
today. I
you.
really need to, yeah. Thank you, sir.
Those are names.
I'm sorry.
Just a maze.
close guess.
Yeah, here you are. You're sitting right here on the bench. Judge, I went out and saw Mr. Mays on Saturday. Judge, I'm going to ask to pass the case. It's a fairly new case. I think this is actually the first time up.
I believe it would be. Is that all right with you, Mr. Mays?
Sure, I need to, can I have a word with him for a second?
Pardon? Yeah, you need to talk to your attorney.
You said what now?
He'll be out to see you, Mr. Mays. He needs to help work on the case to get it prepared so he can give you good advice.
Yes, sir.
So that'll be April 24 will be next court date.
Call, yeah. Just in the call.
I have 6 cases for Mr. McCall.
Yes, sir. Judge, let me just put something on the record. When I first met with Mr. McCall last docket, he was inclined to go ahead and accept the plea offer. It's a very, very serious matter. He wound up, he's facing a 20-year minimum mandatory because of the discharge of a firearm. The discharge was accidental, and in fact, he shot himself. So he's not subject to the life, but he is subject to 20 year. He wants to, I asked him to give me a month to investigate it. I haven't been able to get depositions set because we're setting depositions at the end of March. But he wants to go ahead and sign the plea agreement. So this is going to.
Though I don't have the files with me.
You
So
don't?
I would ask, right, and I need to make sure the restitution forms are in there, so if we could set this to plea maybe Thursday or,
I think we could do it as early as Thursday. Would that be okay with you, Mr. McCall?
I don't have no choice.
I don't think anybody expected, I know certainly they didn't expect that you were going to want to play. I can do it for Thursday morning. If that's not as good for you as Monday, Monday's good also. I tell you what, if they get you back to the jail in time, I got to go out there tonight anyway, and that'll give me a chance to go over things with you, or I can try to just see you again between now and Thursday, because I want to make sure. I mean, I went over stuff with you before, but I want to make sure that this is really what you want to do. Okay.
I got no choice.
You do have a choice. You have an absolute right to go to trial on it. Nobody's going to make you do that. Nobody's going to make you take a plea, okay? Like I said before, nobody's going to make you, okay? Whatever you want to do, we'll do, all right? They're asking to set it off for a couple of days so that they have the right paperwork. Yeah, you would come back up here. Okay.
Which day do you want, Mr. Williams? on a second, sir. Day do you want? A second.
Judge, life would be easier for me on the 6th, but I think I can do it by the 2nd.
I'll do the 6th just in case. That might would be good for me. He has so many cases, that might be good so I can reach out to the victims and notice them. We're here all day tomorrow, too.
Well, unless it's going to improve the offer, I don't know if there's any benefit to them for you, and that's who I have to be concerned about. The victim on the shooting was him. That's why he's walking with a limp. All right, let's do it for the 6th then, I guess.
Let Mr. Paul know that they'll come back on the 6th.
That's better than him coming up on the 2nd and getting passed again, so.
And that's for a plea?
Yeah, that'll be for a plea.
All right, next case. Three cases on the docket.
Hey, Mr. McLean, I tried to see you yesterday and you guys were in lockdown. So what I'm going to do is I'm going to pass your case until the 6th, which is Monday. That'll be the docket day, so that'll still leave you on the trial thing. And I'll come out and see you between now and then. I have copies of the depots. It's Judge, he's advising me that I had said something about getting a mitigation eval on him. Let me look. I don't think that's been done. Well, I'm looking at the wrong file. Hang on. So let's do this. Let's set it for the 6th. We'll do it without subpoenas then, and I'll go through the file. And if there's a basis, a mitigation eval, I don't really need any basis other than I hope it'll be helpful. Do you want me to just continue it and order that eval?
It don't matter, sir.
Okay. I'll just move to continue it then, Judge, and order the eval.
State's position.
No objection, Your Honor. I just asked that this be the last continuance because these cases are getting.
Judge, I don't anticipate that there's nothing I can foresee that would require me to ask for another.
April 24, your attorney will be in touch, sir. Hopefully you can get everything worked up and ready to go for the next cycle.
Yeah.
Mayor McKinney.
Mr. McKinney?
Judge, this is another one that was on for me to see yesterday. The state has made an offer.
Just a moment, Mr. Williams.
Signature bond, and then, because I already got the 6 month time served in.
Well, it's All right, Judge, we're going to pass him till Monday. It looks like we're going to have a plea on Monday, but I need to check into the situation. He's got a BOP over in Walton County.
We overhear briefly a little bit of what you were saying, and Ms. McKinney, if you were on probation at the time this alleged incident occurred, then pleading guilty to this new charge would be a basis to violate your probation.
That's right, but see, like on my misdemeanors, they did they give me a signed plea deal, right? And they gave me a RR bond.
Well, the point is that if you were on active supervision,
Mm-hmm.
now if you were on bond and you hadn't been put on any probation, that's a different issue. They could revoke your bond and have you sit in jail until the charge got resolved. But if you're on probation, pleading to this charge could revoke your probation. So Mr. Williams will be out to talk to you about what you, and give you a recommendation about what's best for you.
So Monday, this Monday coming up?
This Monday, March 6th, 9 o'clock.
I tried to come out and see it yesterday, but you guys wound up on I grabbed it the motion, but I need to get the answers to some stuff. So I'm going to reset you for Monday. Judge, this is another one I'm going to want to reset until Monday. I'm working on a bond motion for Mr. Mobley. He has a severely ill father. He wants to be an organ donor for him. And I just need to get some further specifics to flesh out the rest of the motion.
And all right with you, Mr. Mobley? March 6th, 9 o'clock. That's this coming Monday.
Thank you, Judge.
Ivan Morris.
This way. Mr. Morse, you're another one I was trying to see yesterday, and you guys wound up on lockdown. So I'm going to pass in from 10:30 to 1, and then from 1 to after 3. At any rate, we're going to pass you until Monday, and I'm going to come out and see you between now and then. I'll go over what the offer is with you then, as well as what I saw when I reviewed all the body cam videos and all that. Okay. All right, Judge, if we can, let's set him for Monday. This is the first time up. Hopefully, though, we'll be able to get it resolved.
Monday, March 6th, 9 o'clock, sir. Your attorney will be seeing you in the meantime.
All right. I'll be out to see you like tomorrow or the next day. Okay. I think there is, but we need to move you. See, it's 8 o'clock at night. Jesse. All right. Judge, this is another one I'm going to ask to pass until Monday. I'm hoping to be able to get it resolved.
March 6th at 9 a.m. Thank you, sir. Yes, sir. Your attorney will be out to see you.
Ronald Norris. The last. Right here.
Judge, sorry, it's been a long day and everybody's getting a little punched on.
I understand.
Judge took depositions in Mr. Norris's case, and unfortunately, the two people I needed most to talk to were not set, and that's the two civilians. So I'm going to ask to continue the case again so that I can take the deposition of the woman that was on scene, as well as the other individual that came up shortly after.
No objection.
Is that all right with you, Ms. Norris? Mr. Norris,
Yes, sir.
is that okay with you?
Yes, sir, it's fine with me.
All right.
This is my counsel.
April 24, 9 o'clock. Your attorney will be in touch, sir.
Thank you, sir.
Thank you, sir.
Sorry for your long day here.
It's all right.
No doubt.
Feel like the old Johnny Carson routine. I have the last question.
Just 4 FTAs, okay. Well, let's deal with those. Who do you have? Let's go through the clerk's list.
Chance,